giornata, del modulo poi, perché oggi e domani avremo la fortuna di riaverti non più come coordinatore ma come relatore, quindi questo è un grande privilegio sulla mediazione, quindi
Sì,
ti aspettiamo anche
è,
domani mattina. Okay.
questo è il modulo dedicato alla patologia che attacca i contratti internazionali, le relazioni commerciali internazionali e le cosiddette alternative dispute resolution, viste su un panorama e su una dimensione ampia che riguarda appunto l'arbitrato, la mediazione e la negoziazione per l'approccio e la soluzione dei problemi, anche in via preventiva, non solo delle controversie e della liti già in atto. Nelle relazioni commerciali internazionali queste modalità e queste tecniche, questi percorsi assumono una portata molto particolare rispetto a quello che vediamo e siamo abituati a vedere a livello interno, perché diventano la norma. Ora lo sentiremo dai nostri relatori, ma divengono la modalità naturale di gestione e di approccio al conflitto, ma soprattutto alla criticità della relazione, alla crisi della relazione, al problema che pone il rapporto commerciale. Ecco perché, insomma, oggi abbiamo degli esperti e illustri relatori a parlarci di questo. È un tema che nel nostro paese è ancora in evoluzione, è ancora incontra, soprattutto mi riferisco alla mediazione, incontra ancora molti ostacoli, molte remore di carattere culturale, però stiamo cercando, noi siamo appassionati dell'ADR e per quanto mi riguarda della mediazione in particolare, non molliamo e andiamo avanti nella battaglia per la diffusione della cultura appunto della mediazione. Domani in particolare affronteremo il tema della gestione e mediazione del conflitto e lo faremo in una modalità pratica, e cioè vi sottoporremo un caso dopo una presentazione delle tecniche di mediazione di base da parte dell'avvocato Laura Ristori. Vi presenteremo un caso sul quale vi cimenterete tutti in qualità nel gioco dei ruoli della parte dell'avvocato e del mediatore. A breve, anzi, vi manderò il materiale, la documentazione necessaria per affrontarlo. Ecco, che dire, io ringrazio veramente di cuore i nostri relatori. Thank you to all you. Thank you, Patricia. And it's a great pleasure to have you here. And have a nice day with our scholars, with our participants. And thank you again.
Ok, grazie Paola. Allora ci possiamo mutare e cambiamo anche lingua perché questa sessione è in lingua inglese.
Ah, scusa, ho sottovalutato.
Patricia. So we're going to change language. Patricia, thank you for being here. And thank you to Professoressa Maria Beatrice Deli, from the University of dell'Università di Studi del Molise, segretario generale, Secretary General della AIA, l'Associazione Italiana dell'Arbitrato, e ICC Italia. Patricia Peterson invece admitted in 4 jurisdictions, I believe, England and Wales, Paris, Ontario and Quebec. Wonderful to be here. Una dei più grandi esperti lei è independent arbitrator, quindi ha un proprio studio dove effettivamente svolge solo attività di arbitro. E poi, last but not least, Andrea Carlevaris. Che piacere, Andrea, averti qua, poi passo all'inglese, ma con te ci parliamo sempre in italiano. Sia Andrea che Patricia sono membri dello Steering Committee della Commissione International Arbitration della UIA, Unione Internazionale degli Avvocati. Questo è il corso di UIA Italia, quindi ci tengo a ricordare questa circostanza. L'avvocato Carlevares adesso è rientrato con Bonelli Erede come esperto di arbitrato, ma è stato segretario generale della Corte internazionale, della Corte di Arbitrato internazionale presso ICC Parigi, quindi un ruolo prestigiosissimo. Okay, so thank you everyone for being here, and Patricia, Professoressa Deli, Andrea Calevaris, the floor is yours. Thank you.
Andrea, vuoi iniziare tu? Io con un breve cenno all'arbitrato vogliamo dare la nostra scaletta, because I think we decided to allocate our time.
Solo due parole introduttive, poi ti lascio volentieri la parola, Maria Beatrice, per l'introduzione della scaletta e poi per dare la parola a Patricia. Innanzitutto voglio ringraziare molto Carlo e l'UIA, un'organizzazione da tanto tempo vicina al mio cuore. Sono molto attivo in particolare con Patricia da molto tempo con l'UIA, e la professoressa Lucarelli per aver organizzato questo corso, per avermi invitato. Oggi parliamo di arbitrato internazionale e insomma, ne sentirete dire molte. Volevo, a titolo introduttivo, solamente 3 brevissimi cenni sull'arbitrato internazionale visti dal giurista e dall'avvocato italiano, che suppongo sia il punto di vista di molti di voi. Il primo è che uno degli aspetti più affascinanti sicuramente, ma anche delle sfide nell'accostarsi all'arbitrato internazionale, è la presenza di diversi livelli giuridici. Mentre da avvocati nazionali siamo abituati ad affrontare i problemi da un unico punto di vista, il diritto applicabile, la procedura, anche quando siamo in un arbitrato domestico, grosso modo il modello e la cultura procedurale è quella nazionale. Qui invece ci troviamo in un contesto in cui le parti, gli arbitri, la sede dell'arbitrato, il diritto applicabile possono portarci verso diversi ordinamenti, e quindi dobbiamo far in qualche modo vivere e collaborare questi diversi piani del diritto, non solo diversi ordinamenti, ma anche un piano procedurale, un piano sostanziale del diritto applicabile, preoccupazioni per quanto riguarda l'esecuzione del lodo, preoccupazioni per quanto riguarda la validità del lodo alla sede dell'arbitrato, quindi veramente un mosaico di diritti che dobbiamo tenere insieme. La seconda considerazione ha a che vedere con appunto la cultura di cui parlava la professoressa Lucarelli all'inizio, e quanto è importante, soprattutto per noi giuristi italiani abituati a fare le cose in un certo modo, entrare invece in un mondo, quello dell'arbitrato internazionale, in cui le cose si fanno in un modo molto diverso, e quindi lo vedremo in particolare più tardi quando parleremo di procedura, ma è un aspetto che riguarda tutti gli altri aspetti della disciplina dell'arbitrato, compresa la redazione delle convenzioni arbitrali, il regime applicabile al lodo, e cioè le cose si fanno a livello internazionale in un modo diverso, e quindi per fare arbitrato internazionale bisogna familiarizzarsi con nozioni come quelle di cross-examination, di witness statements, di document production, con cui come giuristi anche del contenzioso interni abbiamo poca dimestichezza. E badate bene, questo non significa che l'arbitrato internazionale segua un modello completamente anglosassone, perché probabilmente dal punto di vista anglosassone anche ci sono nel modello che prevale a livello internazionale degli aspetti poco omogenei rispetto a quel modello procedurale. Come vedremo dopo, il tema invece è proprio quello della compresenza di diversi modelli per sviluppare un tipo di procedura che sia utilizzabile tendenzialmente, con degli aggiustamenti ovviamente, ma che sia tendenzialmente utilizzabile in ogni sistema e in ogni ambiente e cultura giuridici. Il terzo punto, molto rapido, è quello della flessibilità del meccanismo di cui stiamo parlando. È un tema, tra l'altro, in questo momento anche molto sensibile in Italia, in discussione. L'arbitrato offre, in particolare in un contesto internazionale, una flessibilità a livello di meccanismi, di presupposti per il procedimento arbitrale e per lo stesso svolgimento del procedimento arbitrale, che non esiste nella procedura civile di nessun ordinamento. E quindi ce ne accorgiamo e forse apprezziamo, soprattutto in momenti travagliati come questo aspetto, che ci consente tutto sommato, con delle difficoltà, ma ci consente di portare avanti procedimenti di arbitrato internazionale proprio grazie alla flessibilità, per cui tutti ci siamo abituati a fare udienze in modo virtuale, sviluppando e accelerando dei processi che già erano iniziati precedentemente, che già erano molto diffusi nell'arbitrato, che adesso in questi ultimi mesi ovviamente stiamo usando ancora più frequentemente. Tutto qua, ho fatto queste brevi considerazioni in italiano ovviamente, poi passerò all'inglese più tardi per la mia presentazione, e intanto passo la parola a Maria Beatrice Deli.
Grazie molte Andrea, io anche da parte mia naturalmente un ringraziamento a UIA, un ringraziamento all'avvocato Mastellone, alla professoressa Lucarelli con la quale ogni tanto ci incrociamo in qualche attività collaborazione, e anche un grazie all'avvocato De Napoli che così gentilmente ha verificato che anche le questioni tecniche potessero filare perfettamente. Condivido ciò che è stato detto da Andrea, naturalmente, la flessibilità dell'arbitrato, ma anche allo stesso tempo un rigore da parte degli utilizzatori dell'arbitrato, e questo spiega perché abbiamo predisposto un programma abbastanza una scaletta che vorremmo seguire con molta attenzione. Abbiamo suddiviso gli argomenti che ci sono stati affidati, lasciando che la prima parte, la stesura, la redazione delle clausole arbitrali, quindi drafting arbitration clauses, sarà affidata a Patricia Peterson, e al termine del suo intervento alle 9:45 immaginiamo di avere un piccolo break, per passare poi alla parte relativa alla procedura che sarà illustrata da Andrea Carlevaris. Avremo al termine di della sua presentazione, avremo un altro piccolo break alle 12:15 e infine concluderemo con la parte relativa al lodo che sarà mia cura presentarvi. Ovviamente tutti e tre presenteremo le nostre relazioni in inglese, e avremo un set di slide che è compatto, nel senso che ci sono tutte le nostre slide insieme, ma ciascuno di noi le presenterà, le condividerà separatamente. A questo punto di nuovo grazie a tutti quanti sono presenti oggi, and it's a great pleasure for me to leave the floor to Patricia for the first presentation. Thank you, Patricia.
Thank you very much, Maria Beatrice. I will just share my screen. So I hope all of you can see that now. I'm delighted to have this opportunity to participate in this arbitration session in the UIA School of High Specialist Education, and I would like to thank the organizers for this kind invitation. My only regret is that we are not all gathered in Florence today, which is one of my favorite cities in the world. Maybe we can organize something at a later stage. My topic is drafting arbitration clauses for international commercial arbitration proceedings. I will assume, for the purposes of the presentation, that the parties have already considered the advantages and disadvantages of arbitration and have chosen arbitration as a dispute resolution method, as many commercial parties do for an international transaction. Now, having made that decision, you will have a number of important choices to make. And I've outlined in this first slide what the main choices are. And these are the topics that I'll focus on in the next 50 or so minutes. These choices will impact the procedure, who will decide the dispute on the basis of what evidence, the outcome, and the enforceability of the award. And when I think of drafting arbitration clauses, I'm often reminded of quite a well-known cartoon that appeared in the American New Yorker magazine, with which some of you might be familiar, from the 1970s. And this cartoon depicted a lawyer in his office with a client. And the lawyer says to the client, you have a pretty good case, but how much justice can you afford? Now, I'm not certain that the pursuit of justice is what commercial disputes are really about, but what I would suggest to you is that a well-drafted arbitration clause will improve the chances of your client being able to achieve their objectives, whatever those may be. The first choice that you need to make is whether you want to provide for institutional or ad hoc arbitration. So what is the difference? Institutional arbitration proceedings are administered by an arbitral institution in exchange for a fee, and the proceedings will be submitted to the rules of that institution. By contrast, ad hoc proceedings are not administered, and the burden of running the proceedings falls on the parties. And once the arbitrators are appointed, the responsibility will fall to the arbitral tribunal. If there are difficulties in the process, assistance will have to come from either a court or an appointing authority, and I'll speak a little bit more in a moment about appointing authorities. So, what is the role of an arbitral institution, and what services are provided, generally speaking, for the fee you pay? First, the institution will give effect to the arbitration agreement, and if there are elements missing, such as a seat, and the parties cannot reach agreement, the institution may select that for them. The role of the institution in the constitution of the tribunal is one of its central functions. The institution will determine the number of arbitrators if the parties cannot agree. The institution reviews nominations of arbitrators by the parties, makes appointments where necessary, and where arbitrators are challenged on grounds of lack of independence or impartiality, the institution decides those applications. And where necessary, it will replace arbitrators. But another key function of an arbitral institution is the financial management of the case. They will set the arbitrator's fees, the amount of the provision for costs, and they will collect that provision. The institution may also have powers to consolidate proceedings and to appoint emergency arbitrators, as we will see later. And I think Andrea Carlavaris is going to be speaking more about those aspects. Some institutions, like the International Chamber of Commerce, that I'll refer to as the ICC, review awards, while others do not. All of the points that I've mentioned to you regarding the role of an institution are, in my view, the advantages of institutional arbitration. And that's why institutional arbitration would be my own personal choice. But what are the advantages and disadvantages of ad hoc arbitration where you don't have an institution? Flexibility is usually cited as one of the main advantages. You can structure the procedure as you wish. With regard to costs, you will have no administrative fee to pay to an arbitral institution. But you should bear in mind that there are also no restrictions on the arbitrator's fees. And one of the first steps that needs to be taken in an ad hoc arbitration is to draw up terms of appointment, and that will involve the delicate exercise of negotiating the level of fees of the members of the arbitral tribunal and determining the amount of and who will hold the deposit for costs. Now the disadvantages. An arbitration clause for ad hoc proceedings is more difficult to draft because you need to provide for many procedural features that are addressed in arbitral rules. That is, unless you choose the UNCITRAL arbitration rules, which I will come back to in a moment. We have included in your materials the IBA guidelines on drafting arbitration clauses, which are a very useful reference. And I would direct you to guideline number 2, which is a clause that sets out the minimum of what you would provide for a simple two-party ad hoc arbitration clause. It gets much more complicated if you have multiple parties. Another disadvantage is that, generally speaking, the effectiveness and extent to which the proceedings will run smoothly depends largely upon the cooperation between the parties, and difficulties may need to be resolved by a court. It is strongly recommended in the case of an ad hoc arbitration that the parties designate an appointing authority, which may be a court or an arbitral institution that can assist in case of difficulties in constituting the tribunal and can make appointments if necessary. Otherwise, a lot of time can be wasted in trying to constitute the tribunal or replacing arbitrators when necessary. I mentioned a few moments ago the UNCITRAL arbitration rules. UNCITRAL is the acronym for the United Nations Commission on International Trade Law, and UNCITRAL has made a major contribution in the field of arbitration, which includes the UNCITRAL arbitration rules, the UNCITRAL model law, which is a model arbitration law that I will mention later, and I think Maria Beatrice Deli will be referring to it. And it has also produced the UNCITRAL notes on organizing arbitral proceedings, and you have at least the latter two documents in your materials. The first version of the UNCITRAL arbitration rules dates from 1976. The rules were updated in 2010, and further amendments in the interest of transparency were made in 2013. The UNCITRAL arbitration rules provide a framework for an international arbitration that can be adapted to meet the needs of the parties. It's important to remember that they are not a code. The basic assumption is that the parties and arbitrators will decide the procedure for the arbitration within the framework of these rules. But they're a very good set of rules, and I would recommend that if you choose ad hoc arbitration, that you choose the UNCITRAL arbitration rules. And I'll also mention that a 2018 survey on international arbitration conducted by Queen Mary College in London and the law firm White & Case showed that 84% of respondents said that they choose UNCITRAL arbitration most often when they are drafting ad hoc arbitration clauses. Where a party selects the UNCITRAL arbitration rules, an appointing authority can be chosen in the event that assistance is required in constituting the tribunal. There are many institutions that offer this service and other assistance, such as deciding challenges to arbitrators and fund holding for the deposit on costs. One of them is a very old arbitral institution established in The Hague called the Permanent Court of Arbitration, or the PCA, which is actually referenced in the UNCITRAL arbitration rules. And I've set out in this slide the model arbitration clause with the PCA designated as appointing authority under the UNCITRAL arbitration rules, which you can find on the PCA website. And the main part of the model clause selects arbitration under the UNCITRAL rules as the method of resolving disputes under the contract, and then adds one statement. The appointing authority shall be the Secretary General of the Permanent Court of Arbitration. And in addition to acting as appointing authority under the UNCITRAL rules, the PCA can offer other services such as fund holding for the deposit for costs and review and payment of arbitrator fees. And now in the COVID-19 era, they can also organize a remote hearing for you. Now, I mentioned that other institutions offer similar services and they've also established rules and model clauses for acting as appointing authority under the ancestral arbitration rules and sometimes for other ad hoc proceedings, and providing other services. And these rules and model clauses are available on their respective websites. And by way of example, I would mention the ICC, but also I think perhaps of interest for this group, the Chamber of Arbitration of Milan in 2016 published its procedure and services under the ancestral arbitration rules. And another popular choice is the Arbitration Institute of the Stockholm Chamber of Commerce. I'm now going to assume that you've chosen institutional arbitration, which, as I've already revealed, would be my preference. So the question becomes, how do you choose an institution? And the choice depends on the nature of the transaction, the type of disputes anticipated, and the parties, who the parties are, where they're located, and their particular legal culture. And there are institutions with different profiles, and the choice is really very wide. Some institutions are specialized by subject matter, such as prime finance in The Hague for financial contracts, or WIPO for intellectual property matters. There are European and North American institutions with an international caseload, and here I'd mention, of course, the ICC and the LCIA, the London International Court of Arbitration, but also the Chamber of Arbitration of Milan. And there are the Asian institutions that have in recent years been increasing their caseloads, such as the Singapore International Arbitration Center, SIAC, and the HKIAC, the Hong Kong International Arbitration Center. And there are other regional institutions that I've listed in the slide, which can be a very good choice depending upon who the parties to the proceedings are. So what are the selection criteria? I would suggest considering three. And I think the most important criterion is experience. You will want to choose an institution with a proven track record, and I would mention that the major institutions with the most experience can administer arbitrations throughout the world. So, for example, the London International Court of Arbitration does not just administer arbitrations in London, they can administer proceedings outside England. Second, you should consider the features of the arbitration rules. The major institutional rules now tend to feature provisions that deal with multi-party situations, groups of contracts, emergency arbitrators, expedited proceedings for smaller claims. And some rules, like the ICC rules, provide for scrutiny of awards, while others, such as the LCIA, do not. And the third factor you might want to consider is costs. One of the features in a set of arbitration rules that can affect costs is the question as to whether the fees of the arbitrators are set in accordance with the amount in dispute or on the basis of hourly rates. The ICC has a fee scale based upon the amount in dispute, whereas the LCIA sets fees on the basis of hourly rates. A fairly recent study that was published in Global Arbitration Review comparing costs of different institutions for different amounts in dispute showed that the costs vary greatly depending on the amount in dispute. So this is a point that you may wish to research. And turning back to that 2018 Queen Mary College White and Case International Arbitration Survey, it was revealed that the most popular institutions are the ICC, the LCIA, then the Singapore International Arbitration Center, Hong Kong International Arbitration Center, Stockholm Chamber of Commerce, ICSID for investment arbitration, and then the American ICDR AAA, American Arbitration Association. But the ICC led that table by a significant margin. It was selected by 77% of participants in the survey, which included corporate counsel and practitioners who were permitted to select up to 5 institutions. And the LCIA came in second with 51%. And I now turn to the anatomy of an institutional arbitration clause. There are certain features of an arbitration clause that are mandatory, while others are optional but recommended. And there's a further category that I would describe as nice to have for certain types of transactions, but unfortunately these are beyond my time limit. At the very minimum, you should first identify the disputes that will be submitted to arbitration. And I would suggest that you define this broadly. In some circumstances, the parties may wish to exclude certain types of disputes and to submit them to expert determination or to the courts. An example would be the determination of a price that may be submitted to an expert, or decisions on ownership of intellectual property rights that would be submitted to a court. And if you do this, I would simply advise that you make this very clear in the clause so the delineation is easily understood. Second, you need an unequivocal submission of disputes to arbitration for final determination. And without this unequivocal submission for final determination, your clause may not be enforceable. So it's a very important point. Beyond that, what are the basics? I would suggest there are 4. First, the seat. Second, the number of arbitrators. Third, the language. And fourth, if the parties want it, confidentiality. Some institutional rules feature emergency arbitrator regimes and expedited proceedings that can be opted out of. So this is an additional choice that you must make, but I'll come to that later. And in multi-party situations or where there are groups of contracts, consolidation or joinder is something that might be considered. Most institutional rules now include provisions that address issues that arise out of multi-party situations or where there are groups of contracts. Therefore, you should think carefully about what is in the rules of the institution you select before you decide to address these issues in an arbitration clause, as it can be a source of disputes over the interpretation of the clause. And then finally, as I will explain later, a clause specifying the choice of law governing the agreement may also be advisable. When you are drafting an institutional arbitration clause, the most important point to remember is that you should use the model clause of the relevant institution. This is not the time to be creative with your drafting skills. The model clause language will have been considered carefully, interpreted many times, and will therefore provide you with certainty. And you have on the screen the model ICC clause, which is the clause that I will consider for the purposes of this presentation and will build upon that clause. And you will see that the types of disputes submitted to arbitration is defined broadly. The clause refers to all disputes arising out of or in connection with the contract, and the submission to arbitration is unequivocal with the wording that all disputes shall be finally settled under the arbitration under the ICC rules. One of the reasons why parties choose arbitration is that it cuts away layers of appeal. It is not necessary in the case of an ICC clause, as is the case with most institutional rules to waive rights to appeal a decision of an arbitral tribunal. In the case of the ICC, this is provided in Article 35(6), which you see on the screen. An appeal may not be permitted under the law of the seat in any event, but it is something that you should check. Now, the seat. In my opinion, the choice of the arbitration seat is the most important decision that you will make in drafting an arbitration clause. In fact, I've heard some practitioners say that they would rather have a good arbitration seat and a governing law that they do not favor than the reverse. So why would anyone say that? This is because the seat determines the legal framework for the proceedings, and it will address critical issues such as the extent to which assistance will be available from local courts, for example, to obtain interim measures. It could establish formal requirements with respect to the validity of the award. The seat defines the rights of recourse against the award and grounds for challenge and setting aside, which is something that Maria Beatrice Deli is going to be speaking about. And it can also affect the enforcement of the award. For example, some signatories of the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which will be discussed in the third presentation, have subscribed to a reciprocity reservation. So how does one go about choosing a seat? The criteria can be divided, I believe, into three categories. First, considerations relating to the legal framework. Second, practical considerations. And third, but not negligible, logistics. The principal criteria relate to the legal framework. And I would suggest that the most important point is that you should always choose a seat in a jurisdiction with a legal regime that is supportive of arbitration. And the most well-known arbitration seats will fulfill this criterion, such as London, Paris, Geneva, Hong Kong, Singapore. But if your counterparty is proposing a seat that is not one of the well-known safe seats, you will want to do some due diligence and obtain local advice to see if there are any problems. In 2015, the Chartered Institute of Arbitrators in London published its London Centennial Principles, which set out criteria for an effective, efficient, and safe seat for the conduct of international arbitration proceedings. I don't have time to go through those principles, but you have them in your materials. And I would suggest that those London principles can serve as a due diligence checklist. I will note, however, that the first item on the list is a clear, effective, modern arbitration law. I mentioned the UNCITRAL model law earlier. This is a model law which facilitates arbitration. It was issued in 1985 and amended in 2006. And today, approximately 84 countries have adopted in some form the model law, at least in its initial state in 1985. Where a country has adopted the UNCITRAL model law, this is a good sign, but you need to determine still how faithfully the model law has been adopted and how it has been interpreted by the courts in the relevant country. So it's by no means a guarantee. And the last point, which I alluded to earlier, is that you will want to choose a seat in a jurisdiction that is a party to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards to ensure reciprocity if that is an issue where you seek to enforce. Briefly, the other points I've listed in the slide are self-explanatory. On a practical level, the seat can affect the choice and availability of specialized counsel, choice of arbitrators, and you will want to take into account logistical issues like the location of potential witnesses, site visits if necessary, hearing facilities, unless these days you're considering a remote hearing, and visa requirements. And visa requirements may seem like a detail, but I can tell you from experience, they can be a major headache if you have to go through that process every time someone is traveling to the seat. The Queen Mary Whiting case study that I mentioned earlier included a survey of preferences for arbitration seats, and respondents were asked to choose 5 preferred seats. And you have the top choices on the screen with the table led by London, Paris, Singapore, Geneva, New York, and then Stockholm. And here we have the seat selection clause, which I've added to the submission to arbitration. It's very simple language. The seat or place of arbitration, one sees both terms used, shall be, and then you just name the city. For example, Florence, Italy, or Milan, Italy. The next element to consider is the number of arbitrators. With the ICC rules, as is the case with most institutional rules, you do not need to choose the number of arbitrators in your clause. And you will recall that the model clause says that the dispute will be decided by one or more arbitrators appointed in accordance with the ICC rules. And when you use the standard language, you are leaving this decision up to the arbitral institution. And the ICC will generally make that decision based on the amount in dispute, but there could be other criteria. And there are 2 schools of thought on this. One of them is that you should specify the number of arbitrators if the nature of the disputes that are likely to arise is known. And you would want to choose 3 arbitrators for more complex, higher value cases. Having 3 decision makers rather than 1 is thought to offer some reassurance. If you anticipate disputes of a small amount that are not of great strategic importance, you may wish to specify that there'll be a sole arbitrator. And proceedings with a sole arbitrator can move more quickly and will obviously cost less because you'll have only 1 set of fees to pay. The other school considers that it's often difficult to predict the value and significance of a dispute in advance, and therefore you should leave it open to the institution to decide once the dispute has arisen. As one very well-known arbitrator put it, you choose your horse when you know the course. I'll explain this later, but since 1 March 2017, the ICC has introduced an expedited procedure for claims of up to $2 million, which will be increased to $3 million for arbitration agreements concluded after 1 January 2021. And unless a party opts out of this regime, the ICC may decide that there'll be a sole arbitrator, even if the parties have decided upon 3. So I will come to that later because it is one of your opt-out choices. On the screen, you have the arbitration clause that we're drafting, which shows you where you would insert the number of arbitrators. And where you've provided for a tribunal of 3, I would recommend that you consider providing that the 2 co-arbitrators will nominate the president of the tribunal. One drafting point under the ICC rules where the parties nominate arbitrators, these nominations are subject to the confirmation of the Secretary General of the ICC or of the ICC International Court of Arbitration or the International Court of Arbitration, which makes the appointment. So you need to bear in mind this distinction between nominations and appointment in your drafting. And I've given you the wording for an optional clause where the two co-arbitrators nominate the president after the dispute has arisen. And if you do not provide this, or the parties don't agree upon a method for selecting the president after the dispute has arisen, the ICC court will appoint the president, usually after consultation with the national committee of its choosing. But I think Andrea Carlavaris is going to deal with these issues in more detail. And having the court appoint the president of the tribunal is absolutely fine. Experience does tend to show that the chemistry between the arbitrators can be important, so the optional language provides the co-arbitrators with a chance to choose a president that they would like to work with, and depending on the style of the co-arbitrator, he or she may consult with the party that nominated them on the choice. So this gives you another opportunity to have an influence on the composition of the tribunal, apart from selecting one co-arbitrator, but it really is optional. It's a matter of choice, and it's perfectly fine to allow the institution to select the president. The language of the arbitration proceedings can be a very contentious issue, and if you do not specify it in the clause, the arbitrators will decide for you in the absence of an agreement between the parties. And this, like most things, can become a matter of strategy after the dispute has arisen. The language of the proceedings will be used in the written submissions and hearings, as well as procedure orders and the award. So the language can have significant cost implications, since translation of witness testimony and documents can be very expensive. So the factors to consider would include the following. First of all, you'd want to take into account the language of the contract and whether or not there are likely to be documents in other languages that will need to be produced in the proceedings. If you have a significant volume of documents in a language other than the one that will be selected as the language of the proceedings, I'd suggest that you consider providing that documents in the second language need not be translated unless the tribunal orders otherwise. However, you should bear in mind that any choice you make as to language can have an impact on the language qualifications for arbitrators. So if you choose some obscure language that few people speak, you're going to narrow the choice. And generally, it's recommended that you think carefully before providing for proceedings in two languages, as this can slow things down and it can prove to be expensive. So adding to our arbitration clause, you will see that the clause specifying the language is very simple. And I've also given you wording for a clause providing that documents in a second language can be produced in that language unless the tribunal orders otherwise. Confidentiality. First, it is important to distinguish between the concept of having non-public hearings and the confidentiality of various aspects of the proceedings and/or the award. Many parties to arbitration agreements assume that arbitration is confidential. In fact, they often choose arbitration because they think it's confidential. But this is not an assumption you should make. It will depend upon the arbitral rules that are applicable and the law of the seat. So if parties want confidentiality, you should provide for it in the arbitration clause ideally. And the first thing you'll need to do is to think about what you want to keep confidential. Is it documents produced by an adversary? Documents created for the purpose of the proceedings, such as submissions, witness statements, expert reports? Is it just awards and procedure orders? It's also necessary to define the exceptions to any confidentiality obligations that you're going to impose on the parties. If you're acting for a listed company, think about the company's disclosure obligations under the relevant stock market rules. And also consider set-aside proceedings where you want to file the award with the review court at the seat. I've given you a sample confidentiality clause, and I'd like to note a few things. In the first part of the clause, you have the issue of what is confidential addressed. So in this clause, it's all awards and orders, all materials in the proceedings created for the purpose of the arbitration, and all other documents produced by the other party in the proceedings, which are not already in the possession of the receiving party, nor in the public domain. That's fairly typical. But then the second part of it is a carve-out. So it says that these documents will be kept confidential, but saved to the extent, and then it goes on to list where disclosure is necessary pursuant to a legal duty for the purpose of reporting within a company's corporate group, to protect or pursue a legal right, or to enforce or challenge an award in bona fide legal proceedings before a state court. And the third part deals with trying to extend the confidentiality undertaking to others. So the parties undertake to use their best efforts to ensure that the terms of the present clause are respected by witnesses, experts, external and in-house counsel, and any other individuals granted access. I can't stress enough, I think, the importance of thinking about confidentiality at the stage of the drafting of the arbitration clause. I have little time to go into this, but I'll simply state that some of the biggest fights that I've ever been involved in trying to settle terms of reference, for example, were trying to negotiate the terms of a confidentiality clause or even the principle of including one. Confidentiality becomes strategic once a dispute has arisen. So if the parties think it's important at the outset, provide for it. I mentioned that under the ICC rules, there are certain provisions that will automatically apply unless a party opts out of them. And the first is the possibility of having an emergency arbitrator appointed to decide on applications for interim measures that are so urgent that they cannot await the constitution of the tribunal. And the ICC rules specify that this will not prevent a party from going to court with jurisdiction to seek interim measures. And emergency arbitrator proceedings are really just an additional option for a party that needs such a measure. I'll run through a few general features of emergency arbitrator regimes. These are common to many institutional arbitration rules. And emergency arbitrator provisions are now very common. Yeah, I would say in most institutional arbitration rules, this has been a trend that started in about 2010. So generally speaking, an emergency arbitrator cannot be a member of the arbitral tribunal appointed to consider the merits of the case unless the parties agree otherwise. And the merits tribunal may then vary or set aside the emergency arbitrator's decision as they are not bound by it. And some institutional rules will empower the emergency arbitrator to order interim relief in the form of an order or an award. Under the ICC rules, I've mentioned that only a procedural order is possible, so enforcement can be difficult unless national legislation in place in the country where enforcement will take place provides for enforcement of an emergency arbitrator's order. But experience shows that voluntary compliance is quite high. And for this reason, because the possibility of getting urgent relief from an emergency arbitrator is really just an additional option, I would not recommend that you opt out of the emergency arbitrator regime. But if you choose to do so, you may do so by simply adding the words, "The emergency arbitrator provisions shall not apply. And the second opt-out I'd like to mention relates to expedited proceedings. Unlike emergency arbitrator proceedings, expedited proceedings is a topic in itself, which I don't have time to go into, but I'll mention it briefly. There's been a regime under the ICC rules in force since 1 March 2017 that will automatically apply to disputes below $2 million commenced upon the basis of a clause concluded after that date of 1st March 2017. And as I mentioned earlier, the ICC rules have just been amended. And so that threshold will be increased to $3 million for clauses concluded after the 1st of January 2021. Now, I also mentioned that with such disputes, the ICC court may decide to appoint a sole arbitrator, even if the parties have provided for 3 arbitrators, depending on the circumstance of the case. So that's what you need to bear in mind when you're drafting. So just very briefly, what are a few features of the regime? Well, apart from the fact that in most cases you will have a sole arbitrator, the proceedings will be conducted on the basis of a very tight timetable with a reduced fee scale. And the arbitral tribunal must render its final award within 6 months of the date of the case management conference, which will be conducted at the outset. And the arbitral tribunal has the discretion to adopt the procedural measures that it considers appropriate and may, after consultation with the parties, decide the dispute solely on the basis of documents, and where there's a hearing, it can be by video conference or telephone. So why would you opt out? Well, first, it's often difficult to predict what the value of a dispute will be, and the parties can opt in to that regime once the dispute has arisen. Secondly, just because a dispute is under $2 million or $3 million doesn't mean that it's not of importance for the parties. For example, the dispute could involve interpretation of a provision of a long-term agreement that will have an impact on relations between the parties going forward. So you may wish to have a 3-member tribunal decide that. I think that it'll be interesting to see, I mean, for example, Andrea Carlavaras and Maria Beatrice Deli may have totally different views from mine with regard to whether or not one would opt out. I personally would consider opting out and waiting until a dispute arises, unless you're really confident that procedures structured in this way will be suited to any dispute that arises out of the relevant agreement. And I've given you the opt-out language, which is, of course, very simple. The expedited procedure provisions shall not apply. And finally, I would like to say a few words about groups of contracts and multi-party transactions. The ICC rules, like many institutional rules, provide for joinder of parties and consolidation of proceedings in certain cases. And the point to bear in mind is that where you have a group of contracts, you will not be able to consolidate arbitration proceedings commenced under different contracts unless you have compatible arbitration clauses. Therefore, it is strongly recommended that you insert the same clause in each contract within the group of contracts. The availability of consolidation can depend upon the degree of connection of the relevant disputes and, importantly, how advanced these separate proceedings are that may have been commenced under separate contracts. And I will close on this subject by saying that the drafting of a consolidation clause is complex, and I would recommend that you consult an expert on this. I'm not going to go any further than to point out to you that in the materials, I mentioned the IBA guidelines for drafting international arbitration clauses. They provide you with model clauses and explain the considerations behind the relevant clause. And with regard to multi-party and multi-contract situations, I'd refer you to Section 5 of the guidelines, which provide you with clauses and guidance for multi-party clauses, which raise issues of joinder of parties to the proceedings, and Section 6, which contains guidance for drafting multi-contract arbitration clauses, which deals with issues of consolidation. But as I mentioned, the ICC rules do address these issues. And I think the most important point for you to retain if you're drafting a series of contracts is to put identical clauses in each of those contracts. I'd like to turn very briefly to the law applicable to the arbitration agreement, which is an issue that has received quite a bit of attention in the arbitration field recently. So when thinking about governing law clauses, there's actually a distinction to be drawn between the rules of law that govern the relevant contract, that is the substantive law, and the rules of law which govern the arbitration agreement, which I'll refer to as the law applicable to the arbitration agreement. Now, you may wonder why such a distinction would be of any interest. Well, the law applicable to the arbitration agreement potentially governs a number of important issues, such as the formation, existence, scope, validity, interpretation, termination, effects, enforceability of the arbitration clause, and very importantly, it may determine who the parties to the arbitration clause are. So the difficulties that would arise where the parties have chosen a seat which is not in the country of the chosen substantive law. So for example, you choose English substantive law to govern your contract, but an arbitration seat in Paris. Recent court decisions, notably in England and in France, have highlighted the fact that this distinction can have important implications where the relevant principles of the arbitration law of the seat differ from the principles that would be applied if the substantive law of the contract were applied. For example, with respect to jurisdiction of an arbitral tribunal with regard to parties that are not signatories of the relevant contract. I would like to give you one brief illustration of that, which is a recent case called Kebabji SAL against Kaut Food Group. And there you had a contract with an English governing law clause and a seat in Paris. And the arbitral tribunal in France had to decide a jurisdiction issue as to whether a company that had been involved in the performance of the agreements but hadn't signed them was a party to the arbitration agreement. And it is a principle of French arbitration law, the law of the seat, that a party that doesn't sign a contract but is aware of an arbitration clause in the contract and participates in the negotiation, performance, or execution of the contract will be considered a party to the arbitration agreement. And in this Kebabji case, there was actually a clause in the contract that said any amendments made to it needed to be in writing. So if one were to add a party, that would have to be in writing, and that had not been done. So applying the French principle, as the seat was in France, the arbitral tribunal by a majority extended the arbitration clause to the respondent who hadn't signed the contract. The award was challenged before the French courts and upheld. But then, in enforcement proceedings in England, the English courts reviewed the question as to whether the non-signatory was a party to the agreement containing the arbitration clause. And English courts take a very different approach from that of the French courts. And they decided that the parties in their governing law clause had made an express choice of English law to govern both the substantive law and the arbitration agreement. And under English law, the no oral modifications clause was enforced, so the non-signatory was not a party to the contract. So the English court held that the award couldn't be enforced in England against the non-signatory respondent. So that gives you a good illustration as to why this question, which is actually quite a hot topic in the arbitration field, of the law applicable to the arbitration clause is of practical significance. I've given you on this slide an example of a separate governing law clause that is separate from the arbitration clause, which would address the substantive law and the law of the arbitration agreement. And then I've also given you as an alternative language that you could add to the arbitration clause, simply stating the governing law of this arbitration clause shall be the laws of, and then you would choose the seat, or you could, if you wish to, choose the substantive law of the contract. And my last topic is tiered dispute resolution clauses, which have become increasingly popular, I think, in recent years. I'm going to just quickly run through a typical tiered dispute resolution clause, which starts with direct negotiations between the parties, and then the process moves from that to assisted settlement through mediation, and finally to adjudication through arbitration. I'd like to just give you a few quick drafting points. One of the issues that often arises is whether the parties are actually ready to settle at the outset. So it is best to start the process when the parties understand their respective positions and are ready to settle the dispute. And this means that the individuals who will be engaged in the negotiations have authorization to negotiate a settlement or can easily obtain the necessary authorization to accept an offer. And you should provide for some written notice that commences that process. But equally as important as knowing when the process is beginning is that you should provide for time limits for each phase so that either party can move to the next phase of the process if there is no settlement. A few quick points with regard to the negotiation phase. First, you should consider having the negotiations conducted by individuals who are not involved in the dispute. Sometimes a bit of objectivity can help parties to find their way to a solution, which is often a compromise. So you should specify the level of management of the negotiators. Of course, depending upon the importance of the contract, you will decide whether they or not they need to be senior or how senior they need to be. Then you should consider what needs to be done. Is it just meetings? And I would suggest that you avoid language like good faith or bona fide negotiations. Such language often ends up in disputes as to whether the negotiations have been undertaken in good faith or not. And then finally, you should provide for confidentiality. Otherwise, there may be no obligation to keep the negotiations confidential. If the negotiations fail, there are a number of choices to be made in relation to mediation. And the first choice would be whether you want to choose institutional rules. An institution can help the parties select a qualified mediator with the requisite expertise for the case. And if you do not select an institution to assist with mediation, you need to specify how to select and appoint the mediator. And I'd suggest providing that the mediator may not subsequently act as arbitrator unless all of the parties agree in writing. You should designate the place where the mediation will take place, the language, and finally specify that it'll be confidential. I won't go through the arbitration slide because the same considerations apply that we've already discussed. There are two other optional points to which I draw your attention. One is that limitation periods will continue to run through a negotiation period, and they may even continue until the arbitration proceedings are commenced. depending upon the place where the mediation takes place and whether you have a provision in the law that stops the limitation period. You may, in the context of the pre-arbitration phase, wish to consider a tolling or a standstill agreement to suspend the mediation period. And it's also not uncommon to see language in a tiered dispute resolution clause that provides for the possibility of interim measures applications to be made during the negotiation and mediation process. And I've provided in the next two slides a sample tiered dispute resolution clause from the IBA guidelines on drafting arbitration clauses. And I will just highlight a few points. The first paragraph defines the disputes and makes the procedure mandatory. And you will note in the negotiation phase that the level of management is specified. And then importantly, in the mediation section, you will see that it begins after a specified time limit, within 30 days after either party's requested in writing negotiation, or within such other time period as the parties would agree in writing. And then again, a time period is specified for the mediation beyond which a party can take the initiative to start arbitration proceedings. And the final paragraph addresses confidentiality. So my time is now up. I would like to give you just a few final words of advice. Do not forget a governing law clause, as I've already outlined. But I think very important is for you to make sure that all of the necessary parties are signatories to the relevant contracts so that you can avoid a problem such as the one I outlined in the Kebabji case. You won't have the benefit of joining parties to proceedings who are not parties to the arbitration agreement that you find in some civil procedure codes for court proceedings. And this can lead to objections to the jurisdiction of the tribunal, which can be very expensive to resolve. And generally, I would suggest that you try to keep your clause simple. Sometimes less is more. And above all, what you want to avoid is the interpretation of the clause becoming a part of the dispute. So that ends my presentation, and I think we may have a few minutes for questions. And I see that there is one on the chat. According to my experience, which are the criteria to be followed to select arbitrators? Is it advisable that at least one arbitrator must be of legal education? I'd actually like to ask Andrea Carlavaris. I think you may be dealing with that in your presentation. I'm not sure. The actual selection once the dispute has arisen, but I would like to deal with just one little point on drafting. And that is that sometimes one sees parties specify qualifications for the arbitrators in their arbitration clause. For example, the person must have expertise in the construction industry, or they may even say an engineering background. Those are just examples, but you can imagine all kinds of qualifications that somebody could specify in an arbitration clause. And while that's an acceptable way of proceeding, I would suggest that you be a little bit careful with that so as not to limit the pool of arbitrators who can potentially sit on your case. You don't want to set the bar so high in terms of qualifications that it will be difficult to find an arbitrator that fulfills those qualifications. You can also end up in a big fight with the other side and possibly even challenges on the basis they don't have the right qualifications. So I would warn against that. I have my own personal views on selecting arbitrators, which goes beyond my topic of drafting arbitration clauses. And when you ask whether it's advisable to have at least one arbitrator who has a legal education, I would say absolutely yes. And probably if you have a 3-member tribunal, you would want the president of the tribunal to have a legal education and to be very experienced in the field of arbitration so that they can ensure that the award that is prepared is going to be enforceable. And whether or not you want to have somebody that has a non-legal background, for example, an accountant or an engineer, would depend upon the nature of the dispute. And I would just mention that, you know, we as lawyers have a tendency, I think, to be a little bit sometimes arrogant and a bit chauvinistic about this and think, oh, well, only a lawyer can be an effective arbitrator. And I would mention that the Chartered Institute of Arbitrators in London offers training to become, to obtain a Chartered Institute qualification to non-lawyers. And I must say that I have come across in various programs I've been involved in at the Chartered Institute, engineers who have done all of the Chartered Institute training, sit as arbitrators, and there they take courses. They are legally trained by the time they go through the Chartered Institute's training, and they know what they're talking about when it comes to arbitration. So I don't think we should necessarily dismiss the possibility of having a non-lawyer on the tribunal. And, you know, I think that the general criteria that I would apply would be experience in the fields that are necessary to resolve the dispute, arbitration experience. But I think most important for me is, I think when you're choosing a co-arbitrator, you should choose somebody who's going to be independent, who's competent, and who will gain the confidence of the president of the tribunal, who will really be a voice on the tribunal. But this is a topic in itself, and I think I'll stop there. I see another question, and it is, when dealing with a US counterpart, any suggestion to identify and insert clauses that can protect a European company? I have to say that I'm not entirely sure what that question is getting at. Protect a European company in what way? Could Barbara Bonifini explain?
Yeah, sorry.
Okay, sorry.
Yeah, I was thinking, in order to avoid the risk of the risk that the arbitral awards cannot be fully executed in the US, for instance, for differences between, I imagine, from differences between federal legislations, national legislation. So since it's a system that is quite different from ours, at least within the EU. I was wondering if there are any suggestions, or maybe it's a problem that doesn't exist, that simply doesn't exist. So
okay, so I understand that your question is really aimed at enforcement, and that you'd like to ensure that an award would be enforceable in the United States.
Yes. Thank you.
Well, I think that once you have heard Maria Beatrice Deli's presentation, your question will be answered, because she's going to be talking to you about enforcement, and there you would be able to use the New York Convention, and that should facilitate enforcement. So I don't think that should be much of a problem, but I think you'll have a really clear idea of that once you've heard the third presentation. I don't mean to just duck out of it, but you're going to have I think a clear explanation of that.
Absolutely.
Thank you.
Well, thank you, Patricia, for an enormous wealth of recommendations, and I I'm sure that by going back and looking through your presentation, which will be made available, your PowerPoint presentation, this is most valuable. But let me just take 2 minutes to remind the most significant points that I've jotted down here. Well, the Whiten Case QMC survey report indicating that the ICC is at the top of the table. 77% of the arbitrations go towards the ICC and 51% to the LCIA, London Court of International Arbitration. The golden rule of do use the model clause. I think that's extremely precious piece of recommendation. Do not be creative. Once in a while, although you're an Italian lawyer, don't be creative. Go to the model clause and work on that. So thank you for presenting your slides in a way that we were slowly developing the various recommended additions and changes. The confidentiality was extremely important as a point. And if I might go back on this, emergency arbitrators do not opt out of emergency proceedings, do not. That was your recommendation. Whilst the other recommendation was do opt out of expedited proceedings, if I understand correctly.
You mean the expedited ones?
Yeah.
Well, it wasn't necessarily. It was think about the contract and think about the types of disputes. And if you think you may have a complex dispute that you would like to have resolved by 3 arbitrators, or you think that even if it be a low value dispute, in the terms of the relationship between the parties, it could set an important precedent, then I would opt out, knowing that you can always opt back in again. Of course, that'll become strategic and you could have a huge fight over that. That's my personal view, but it may be that my colleagues, Andrea and Maria Beatrice, actually have a different view from me on that. So I wouldn't take it as a hard and fast rule. That's just my own personal views. Think very carefully about the situation and whether you really want to find yourself possibly with a sole arbitrator when that wasn't what you had in mind.
Yeah, I think the important message that came across was watch out, because if you do not opt out, you must be aware of the fact that if you're choosing 3 arbitrators, you might end up with one arbitrator. So just being aware of that, it's so important. I mean, this course is to assist lawyers to draft cross-border contracts, and drafting these clauses is critical. So if you're not aware of the problem, you're not going to even consider it. So that's very important. And also the governing, please.
So I think Andrea has just unmuted his mic. He may totally disagree with what I said.
No, not at all. I mean, just a very quick comment to say that this was a huge debate when the ICC expedited rules were approved in 2017, because as we know in Italy, for example, we have a provision of the Code of Civil Procedure which says that in case of discrepancy between the arbitration agreement and the arbitration rules referred to in the arbitration agreement prevails. So an arbitration agreement which expressly provides for 3 arbitrators may ultimately prevail over the rules. At the end of the day, it's really a matter of interpretation of what the party's real will was in specific cases. As a matter of suggestions, maybe to participants, I tend to agree that unless you clearly have a type of contracts from which you can expect also only certain types of disputes that can easily be handled by a sole arbitrator, tying your hands by applying these rules that may end up with an appointment of a sole arbitrator, even against the party's will, or in any case provide for a sole arbitrator when you can't really anticipate the kind of disputes that may arise from your contract is probably not what I would recommend.
Yes, Patricia, there are two further questions on the chat. I don't know whether you feel like addressing them.
I can. I just am wanting to be a little bit conscious of time. I think we were going to start the break at 9:45. So I just want to make sure that my other two colleagues who are going to speak are happy to continue. Okay, so I see. Is it advisable to include in the arbitration clause a provision according to which parties have the right to request interim relief from the courts in the country or countries where the need for interim relief arises? Probably this point has already been dealt with, but my concern regards the opportunity to skip the arbitral tribunal in case of a need for interim relief arises. That, I think, is a question which needs to take into consideration the law of, well, the institutional rules that you choose, and whether or not, sometimes depends on whether it's prior to the Constitutional Tribunal. Prior to the Constitutional Tribunal, you can go to the courts. The ICC rules that provide that you can also go to the courts in appropriate cases after the tribunal has been constituted. But the question as to whether or not your hands might be tied can be affected by the law of the seat. For example, in England, once a tribunal is constituted, a certain provision of the English Arbitration Act, which has been interpreted, at least in one case, as suggesting that once a tribunal is constituted, the parties should only be going to the arbitral tribunal for interim relief. And we all know that there are some interim measures for which one might want to go to the court because they will have more teeth in them, so to speak. So that's an evaluation that needs to be made on the basis of the institutional rules you choose, if you choose institutional rules, what they say about that, and the law probably of the seat. But if you'd like to be absolutely certain and take what one would call a belt and braces approach, it's not uncommon to see that language to that effect added to an arbitration clause. And once again, I'd also like to give my colleagues an opportunity to add their views on that. They may have views that differ from mine. And then just looking at the last question, it says, do you have suggestions on how to protect a client in dealing with a counterparty placed in a country that, despite being part of the New York Convention, in fact does not easily recognize arbitral awards? I'm especially referring to countries which Sharia law is applicable. I think once again, that's a topic probably more for the third presentation that is going to deal with the award. In terms of the actual arbitration clause, I don't think that I have specific advice, but once again, my colleagues may have suggestions as to language that might be added. But I think, the recognition and enforcement of the award depends a lot on what is in the award and whether the tribunal has taken care to render an award that is enforceable and that is not going to give rise, for example, to a party being able to invoke the public policy exception to enforcement in the New York Convention. But I don't see that really so much as an arbitration clause exercise, but I may stand corrected by my colleagues.
Well, thank you, Patricia. If you will allow, I'm going to suggest that we do not have a break now, but maybe a break between Maria Beatrice's presentation and the last one by Andrea Carlevalis. One break should be sufficient. We usually have a break at 11:30. So if Professoressa Daly, if your presentation will take...
I think the order was that I would go now and...
Oh, Andrea, okay.
Last.
Andrea, how long
for me, no problem, but for me it's absolutely fine. I mean, I think it's more for participants, whether they are tired and they want a break. Maybe we can start now, and then we can have a break even during my presentation, if that's too much. Or
well,
otherwise complete the presentation.
We're used to having a break at 11:30, but even if that's 11:45, that's fine. We do need one break, definitely. Maybe two, it takes too much time away. So I would suggest, I'm not going to have a referendum of this, I just suggest you carry on, and if we could stop at 11:45, then that would be a very good time to have a break.
Very good, happy to do that.
Thank you, thank you.
So let me now try to share my screen so that I can be in command of the slides. Can you see my screen with the slides?
Not yet. Okay, that's fine, thank you.
No, okay. Very good. So we continue now with procedural aspects. And of course, we have to start with the okay, no, that's fine. We have to start from the applicable rules. The moment you start arbitration proceedings, of course, you want to be sure what the normative framework is. Now, Patricia already referred to a notion which is the notion of the law applicable to the arbitral process in general. This is also known as the lex arbitri. And we have to start by distinguishing the lex arbitri from the actual rules applicable to the procedure before the arbitrators. Lex arbitri, as Patricia said before, covers all aspects of the relationship between the arbitral process and the law of the place where the arbitral process takes place. So it concerns, for example, the scope of party autonomy in referring matters to arbitration, the powers of arbitrators, including the powers to order interim relief, and probably most importantly, the conditions upon which an award can be declared enforceable. In other terms, what are the grounds for challenging an award before court proceedings? These are all issues that are governed by the so-called lex arbitri, which corresponds to the law of the place of arbitration. And I totally agree with what Patricia said about the paramount importance of the place of arbitration. Now we're talking of something that is slightly different, and it's the actual procedure before and the arbitral tribunal, and even before the arbitral tribunal is appointed. Now, there may be rules of the lex arbitri, of the law of the place of arbitration, which are mandatory, which have to be applied in arbitration proceedings, regardless of any agreement of the parties on any institutional or other rules. But in general terms, the parties, as we can see, are free to agree on the rules they want to be applied to the arbitral process. The question is, can the parties choose a domestic procedural rules to govern the arbitral proceedings? They can. Most arbitration rules, institutional arbitration rules, recognize this power of the parties, this freedom of the parties to agree on procedural, even domestic procedural rules. I would submit that this would be inappropriate in most circumstances, and that parties actually resort to arbitration precisely because they want to move away from the technicalities of domestic procedural rules. These are rules that are dictated by codes of civil procedure for court proceedings, and in most circumstances, they would be inappropriate to govern the arbitration procedure. We already know from what Patricia said how important arbitration rules are. So the pre-established set of rules that the parties may simply refer to in their arbitration agreement without any need to reproduce them or to have enter into specific agreements on their applicability by simply referring to ICC, LCIA, Milan Chamber arbitration or rules. This set of rules becomes automatically applicable. Now, if we look at the institutional arbitration rules, and we have started doing so, and we will comment on some of the institutional rules also in my presentation, we'll see that procedural rules, strictly speaking, are not very numerous in these arbitration rules. Most of the rules you will find are administrative rules, which means rules that govern the role of the arbitral institution in the administration of the process under the rules of the institution. Which means, once again, that the parties, and in the absence of an agreement of the parties, the arbitrators have very broad freedom in deciding what the applicable rules to the procedure are. Not only, as I said, domestic law is in most cases inappropriate to govern the arbitral procedure, but you will see that in the domestic arbitration laws, there are very few rules applicable to the arbitration procedure. So what you have is precisely Code of Civil Procedure applicable to the court proceedings, but in the laws on arbitration, the procedural rules are, as I said, very, very scant. Now, in terms of deciding, so the general principle is that the parties are free to agree on the rules applicable to the procedure, and in the absence of an agreement, the arbitral tribunal can decide what the applicable rules will be. Now, how does or how should an arbitral tribunal go about selecting the applicable rules? Of course, one solution would be an upfront decision made at the beginning of the proceedings, setting out the procedural rules. A different approach is deciding on a case-by-case basis throughout the proceedings whenever procedural issues arise. In practice, arbitrators tend to decide on the applicable rules with a mix of these two approaches, which means at the beginning of the case there is generally a procedural order that will fix the general procedural framework of the case. But of course, experienced arbitrators would refrain from providing too much details about the procedure at the beginning of the case, because they don't want to tie their hands, and they may want to decide and resolve procedural issues throughout the case whenever those issues arise. Typically, for example, for the conduct of the hearing, this is generally something that is decided and in consultation with the parties before the hearing, and not necessarily at the beginning of the case. We mentioned institutional rules, domestic rules, particularly mandatory rules of procedure at the place of arbitration, and any rules that the parties may agree upon or the arbitrators may decide. Quite an important role is played by soft law instruments. What are soft law instruments? These are procedural rules that are drafted and published by several organizations. They don't have a binding nature as such. They are certainly not the value of law, and not even the value of an agreement of the parties until the parties specifically agree on their applicability. The most relevant ones are listed in the slides, and the IBA, the International Bar Association, is obviously the most prominent organization in setting rules for the conduct of arbitration proceedings. Particularly relevant are the 2010 rules on the taking of evidence in international arbitration. We'll have an opportunity to make references to them shortly. always the IBA also published guidelines on party representation in international arbitration. This set of rules governs rather the duties of counsel and other party representatives in the conduct of the proceedings, and tries to tackle a problem, which is that different rules or ethical and deontological or legal rules apply to the legal profession in different parts of the world. And so to, as we say, level the playing fields, these rules were adopted in 2013 precisely to set common standards with respect, for example, to what are the duties of counsel towards the arbitrators when counsel is aware of circumstances that may be a disadvantage to their clients, what to do with documents in possession of the party or their representatives, which may precisely be a disadvantage to the party's case. The UNCITRAL, the United Nations Commission on International Trade Law, also published in 1996 and then revised in 2016, notes on organizing arbitral proceedings. And more recently, the rules, the so-called rules on the efficient conduct of proceedings in international arbitration were published. They are better known as the Prague rules because they were adopted in Prague. And these rules were, in a way, a reaction to what many civil law lawyers from continental Europe perceived as an unbalanced approach taken to procedural issues in the IBA rules on the taking of evidence in international arbitration. As we know, there are two quite different procedural models in civil law and in common law. And so civil law arbitration practitioners, some of them, felt that the IBA rules were a bit too followed the common law model on several issues, which is, as we know, more accusatorial and gives lesser powers to the arbitrators in the conduct of the proceedings. And so you have the Prague rules adopted in 2018, which recognize broader powers of the arbitrators in the conduct of the proceedings. Once again, all of these instruments are not binding as such. They become binding only when the parties or the arbitrators decide to adopt them as applicable rules for the conduct of the arbitral proceedings. I will continue by distinguishing three, possibly four procedural phases. The phase that comes before the constitution of the arbitral tribunal, the constitution of the arbitral tribunal itself, which, as we all know, it's a crucial step which may have a decisive impact on the outcome of the case. Then there is the actual procedure before the arbitral tribunal, and possibly after the award that Maria Beatrice will deal with, there may be a post-award phase if any problem arises with the drafting of the award. So let's start with the pre-arbitral phase, let's say, or all procedural steps that predates the constitution of the arbitral tribunal. Here, of course, there is a fundamental distinction, as I would say throughout the steps of the proceedings between ad hoc and institutional arbitration. Institutional arbitration provides for many rules for precisely the phase that before the constitution of the arbitral tribunal, where in the absence of an arbitral tribunal, it is of course for some other institution, precisely the institution which is in charge of administering the proceedings, to take a number of procedural decisions and actions for the actual setting in motion of the proceedings. This doesn't exist, of course, in ad hoc arbitration, which generally starts precisely with the appointment of the arbitral tribunal, which is regulated by generally the law of the place of arbitration. And it is the tribunal which is constituted as soon as possible that will then be in charge of taking all decisions pertaining to the conduct of the proceedings. Patricia already mentioned how the arbitration agreement can provide for some pre-arbitral phase. This could be cooling off periods during which the parties give notice to each other of the existence of a dispute before the actual arbitration proceedings can commence, generally intended to avoid the dispute and to facilitate a settlement of the case. The settlement can be encouraged also by more precise description in the arbitration agreement, and so there may be, even from a procedural point of view, the need to take certain concrete procedural steps to attempt at negotiating a settlement of the dispute, and this can be also more structured if the parties have included in the arbitration agreement a pre-arbitral mediation or conciliation or other similar instruments before the actual arbitration proceedings can start. Obviously, before the actual start of the arbitration proceedings is also when something that also Patricia referred to, the emergency arbitration proceedings could take place. And as she mentioned, most international institutional arbitration rules now provide for rules on emergency arbitration, the appointment on an emergency basis of an arbitrator to hear requests for interim urgent relief. So I won't go into the details of this procedure, but this, of course, would be something that takes place before the actual arbitration starts, or actually, depending on the relevant rules, it can be until the arbitral tribunal is actually constituted, because as we will see in a moment, once the arbitral tribunal is constituted, it will be in charge of all procedural aspects, including also deciding on requests for interim relief. There is, of course, an arbitration starts with an initial exchange of written briefs, a request for arbitration, an answer, possibly containing a counterclaim, and it is once again for arbitration laws or in institutional arbitration for arbitration rules to describe how this happens, what is the content of the request for arbitration and of the answer, what are the time limits to submit an answer to the request for arbitration. If the answer contains a counterclaim, possibly what the time limit for the claimants to submit a reply to the counterclaim is. And then what Patricia already described as probably the determination of one of the most important, if not the most important element of the arbitral process, which is fixing the place of arbitration. She mentioned this from the point of view of the arbitration agreement, where the parties are it is certainly recommended that the parties discuss and decide the place of arbitration themselves. But in cases in which this is not possible, generally because the parties disagree on the place of arbitration, in ad hoc arbitration, this will typically be the first important decision the arbitral tribunal, once constituted, will have to take. In institutional arbitration, I would say most arbitration rules, with only a few exceptions, provide that this is a decision to be taken by the arbitral institution itself. Now, how does the arbitral institution go about selecting a place of arbitration when there is no agreement of the parties? Well, first of all, to exercise its power to determine the place of arbitration, the arbitral institution must be satisfied that there is no agreement between the parties. The parties might have discussed the potential place of arbitration, and it is for the institution to ascertain whether they managed to reach an agreement on the place of arbitration. There may be situations in which the parties agreed, it's rare, but sometimes you see in arbitration agreements that the parties refer to more than one places of arbitration at the choice of the claimant in the case. There are cases in which the arbitration agreement refers to a certain jurisdiction without fixing the actual city in which the arbitration will take place, will have its legal seat. And this may require an intervention of the institution in a way to complete the parties' agreement and to fix the city in which the arbitration proceedings will be seated, which may be relevant, especially in jurisdictions where the city may determine also the courts having supervisory powers on the arbitral proceedings. I said, how does the arbitral institution go about choosing the place of arbitration in specific cases? The parties may have strong views on this, of course, precisely because it's such an important element to be determined. The institution, if the institution has to decide, it will certainly fix the place of arbitration in a jurisdiction that gives sufficient guarantees that the award will be enforceable, that the party autonomy in the conduct of the proceedings will be respected, and in general, in a jurisdiction where the local law supports the arbitral process and precisely is particularly favorable to the process and to the validity of the award. As I say, the parties may have conflicting views on the place of arbitration. The arbitral institution will have to take a neutral approach to the decision, not necessarily in the sense that it will have to decide a place of arbitration in a jurisdiction different from those the parties in their respective pleadings want as the place of arbitration, but that when the guarantees, they say, of enforceability of the award are comparable, the arbitral institution may choose a neutral place of arbitration with respect to the nationality of the parties. Another important set of decisions that may have to be taken at the early stage of the proceedings, even before the constitution of the tribunal, concerns preliminary decisions on jurisdictional objections. The respondent may not participate in the arbitral proceedings. It's something that happens quite frequently. Or the respondent may participate in the arbitral proceedings by submitting an answer, but by objecting to the jurisdiction of the arbitral tribunal on, of course, a variety of bases, which could be the absence of an arbitration agreement, the total inexistence of an arbitration agreement, something quite rare, the invalidity of the arbitration agreement, or, and I think this is what happens most frequently, the scope of the arbitration agreement. So an arbitration agreement exists, but a party claims it doesn't cover the dispute in question, either because it doesn't cover the dispute from an objective point of view, the claims submitted to arbitration, or because it doesn't cover any of the parties involved in the arbitration. For example, the respondent claims that it is not a signatory of the arbitration agreement and it is not otherwise bound by the arbitration agreement. Now, we take the ICC rules as an example of this kind of rules and of role the institution plays in this initial this type of decisions. In Article 6.3 of the ICC rules provides that precisely when a party against which a claim has been made either does not submit an answer, so it doesn't participate, or raises one or more pleas concerning the existence, validity, or scope of the arbitration agreement, or whether all of the claims made in the arbitration may be determined together in a single arbitration, the arbitration shall proceed, and any decision on these objections will be referred to the arbitral tribunal once constituted, unless the Secretary General, so I mean, this applies to the ICC, there may be different organs having the same role in other types of institutional arbitrations, unless the Secretary General of the court decides that this matter requires a decision of the court. And so it refers, the Secretary General refers the matter to the court for an initial decision. When cases are referred, so the principle is under the current ICC rules that any decision on the jurisdiction of the tribunal will be directly taken by the arbitral tribunal unless the case is sufficiently doubtful, I would say, that it requires a decision of the ICC court. When the ICC court precisely has to decide, the Article 6.4 of the ICC rules, or similar rules contained in other institutional rules, provides that the arbitration shall proceed if and to the extent, which means with respect to the claims or with respect to the parties, that the court is prima facie satisfied that an arbitration agreement under the rules may exist. And then there are specific examples of specific application of this general principle of the institution's power to screen requests for arbitration at this early stage of the proceedings, to the situation where precisely it's the small Roman 1 of this important provision, when where there are more than two parties to the arbitration, the arbitration shall proceed between those of the parties, including any additional parties joined, with respect to which the court is prima facie satisfied that an arbitration agreement may exist. And when, so this covers, let's say, the razione persone scope of the arbitration agreement, and small Roman 2 covers the claims that are submitted to arbitration. And so the razione materia scope of the jurisdiction of the tribunal. You will have noticed the language used in this provision, which says the institution will set the procedure in motion and let the arbitral tribunal be appointed if it is satisfied that an arbitration agreement covering those claims or binding all of the parties may exist. I am, let's say, taking a few minutes on this provision because I think it's extremely important also to understand the role of arbitral institutions, which is certainly not to decide disputes, even at the jurisdictional stage. Any decision on the jurisdiction of the arbitral tribunal pertains to the tribunal itself. We are talking here of an administrative preliminary decision as to whether and among which parties and with respect to which claims the proceedings can be set in motion. Therefore, the threshold for the court decisions, the ICC court's decision, is extremely low. If there is an argument or any kind of evidence that a party may indeed be bound by the arbitration agreement, or a certain claim may be covered by the arbitration agreement, and if there is any evidence that an arbitration agreement exists and may be valid and under any theory under the applicable rules, then the institution will set the procedure in motion. And as I said, any decision on the jurisdiction of the arbitral tribunal will be taken by the arbitral tribunal itself, which is precisely what you see reflected in Article 6.5 of the rules. During these initial phases of the arbitral proceedings, there are also decisions to be made generally by the arbitral institutions or in ad hoc arbitration pursuant to rules that may be contained in the arbitration laws applicable to the proceedings with respect to what we can define as complex arbitrations. We've been referring so far to the typical and most straightforward procedural scheme, which is one claimant, one respondent, possibly raising counterclaims, but in a very simple bipolar scheme. A significant portion of disputes submitted to arbitration are, however, more complex than this. They may include claims under more than one contract. They may involve more than one party. They may require the joinder of parties in already pending proceedings, or the consolidation of two or more already pending arbitrations. And since 2012, there are specific rules in the ICC rules of arbitration, as there are in most other major arbitration rules. So let's see very briefly how the ICC rules deal with this, and other rules deals with these complex arbitration situations. Article 9 of the ICC rules deals with multi-contract cases. It is a pretty simple provision which simply permits multi-contract arbitrations, subject, however, to the provisions of Article 6, paragraph 3 to 6, paragraph 7, which means that the multi-contract cases may give rise to objections to the jurisdiction of the arbitral tribunal, for example, on grounds that some of the claims are not covered by the arbitration agreement on the basis of which the arbitration was commenced. In these cases, of course, the possibility of bringing claims under more than 2 contracts is subject to any decision the institution or the arbitral tribunal at a later stage may have to take on the scope of their jurisdiction or of the jurisdiction of the arbitral tribunal. Patricia already mentioned joinder of additional parties. Again, she mentioned this from the point of view of the drafting of arbitration agreements. Let's see how this works from a procedural point of view. This is the situation in which an arbitration is already pending. There is a request for arbitration. And after the request for arbitration, which typically identifies the claimant and the respondent or respondents, if more than one, a party can be joined in the proceedings only through specific mechanisms that are described in arbitration laws or rules. And this is the case of Article 7 in the ICC rules. Now, this is typically the situation in which a respondent party tries to join in the arbitral proceeding an additional party. For example, it files a counterclaim not only against the claimant, but also a claim against another party. For example, the parent company of the claimant or some third party. But this can also be the situation in which, after submitting the request for arbitration, the claimant intends to join additional parties in the proceedings. This may be due to something the claimant realizes after receiving the answer to the request for arbitration, that it is appropriate to join additional parties, or simply to an oversight in the request for arbitration. This is always possible in complex cases. So Article 7 of the ICC rules governs this, deals with this situation from a procedural point of view. This is a request for joinder that has the same content, basically, as a request for arbitration. Again, the request for joinder makes the additional party automatically a party to the proceedings, subject, however, of course, to any jurisdictional decisions that either the institution or the arbitral tribunal may have to take. So the additional party may raise objections to the jurisdiction of the arbitral tribunal on itself, and this will be decided under the ICC rules by the arbitral tribunal itself, subject to the possibility that the Secretary General of the court refers the matter to the court, and the court decides, applying the standard I described before, which is a very low standard, whether the additional party may be joined, or rather whether the arbitration can proceed with the additional party. The additional party will then be invited to submit an answer. Now, to render this process manageable, of course, there is also a power that is generally given to the arbitral institution to set a time limit for any requests for joinder. If, of course, a joinder is requested too late, this may be very disruptive of the arbitral proceedings, in particular because the party that is joined in already pending proceedings might not have taken part in the constitution of the arbitral tribunal, which may constitute a significant problem at the stage of the enforcement of the award. And this is why this provision, Article 7, paragraph 1, also provides that no additional party may be joined after the confirmation or appointed of any arbitrator, unless, of course, all the parties agree. Article 8 deals with another type of complex arbitration, which is the situation where there are claims between multiple parties. Once again, we dealt so far with the usual scheme of claims between the claimant and the respondent, possibly also counterclaims by respondent against the claimant. But there may be more complex situations in which, for example, there are two respondent parties which have claims against each other, or claims may be raised vis-à-vis an additional party. Once again, the rule is the same. This is certainly admitted under the ICC rules and other major rules, always subject, however, to the provisions of Article 6, so that the possible objections to the jurisdiction of the arbitral tribunal with respect to these claims. And finally, we have, as an example of complex arbitrations, the consolidation. Consolidation is different from joinder because in this case we are talking of two or more proceedings that have already been introduced and are already pending, and which a party is seeking to precisely consolidate, join together. There are, of course, different rules applicable under different types of institutional arbitration, which are governed by the arbitration rules. Once again, we have the example of Article 10 of the ICC rules, which deal with the consolidation of arbitration proceedings in a rather complex provision by distinguishing three types of situation. One is the situation where all parties involved on all the pending arbitrations agree to consolidation. This is pretty straightforward. In arbitration with the agreement of all parties, everything or almost everything can be done. The second situation, let's say, provides some form of consensual basis to the consolidation, but not a fully consensual basis. And this is a situation where all the claims in the arbitrations to be consolidated are made under the same arbitration agreement. So there are different proceedings pending, but all based on the same arbitration agreement, which in most cases means based on the same contract contains the arbitration agreement. And then under C, you have the most complex situation, which is where claims in the arbitrations are made under more than one arbitration agreement. In this case, consolidation is possible, and unlike the joinder of additional parties, as a matter of principle, consolidation requires a decision of the arbitral institution. So it's only possible if the ICC court decides to consolidate the proceedings. And Article 10, point C, sets out the requirements for the consolidation of cases when the arbitrations are based on different arbitration agreements. And these requirements are that the arbitrations are pending between the same parties, which means exactly the same parties, two or more parties must be involved in all the arbitrations to be consolidated. The disputes in the arbitrations arise in connection with the same legal relationship. And a lot has been written about the notion of same legal relationship, which is quite a narrow notion, narrower, for example, than the same economic transaction, for example, which may indeed refer to a broader array of situations. Legal relationship does not necessarily mean the same contract, but is certainly more narrow. And finally, the court can decide to consolidate if it finds that the arbitration agreements are compatible. This is quite a logical requirement, because if the arbitration agreement are not compatible, the arbitrations cannot be consolidated without violating at least one of the arbitration agreements, which constitutes the basis for the arbitrations to proceed. Finally, there is, in the last part of this provision, a margin of discretion for the institution, even if those requirements are there, to decide whether to consolidate. And this provision says that the court may take into account any circumstances it considers to be relevant, including whether one or more arbitrators have been confirmed or appointed in one or more of the arbitrations to be consolidated, and if so, whether the same or different persons have been confirmed or appointed. Again, this is something that is quite easy to understand, because once arbitrators have already been confirmed or appointed in one of the cases to be consolidated, it would be extremely difficult to consolidate cases without having to remove those arbitrators, unless precisely the same individual have been chosen in the different cases. Finally, there is a case of complex arbitration which, unlike the previous ones, is not dealt with in the ICC rules. And this is the case of the spontaneous intervention of the party in pending arbitral proceedings. We've seen in the ICC rules the possibility of a joinder, which means one of the existing parties is trying to join or is joining a third party. In this case, it's the third party, which of course must be informed of the arbitration, which may precisely take the initiative of requesting to be admitted into the proceedings. And this is something that you have under certain institutional rules. For example, Article 4, Paragraph 2 of the Swiss rules deal precisely with the situation where one or more third persons request to participate in arbitral proceedings already pending. Let's move to the second procedural phase, which is the constitution of the arbitral tribunal. We already discussed the number of arbitrators. I would say most arbitration agreements, in my experience, still leave the question open whether the arbitration will be submitted by one or three arbitrators. In the applicable arbitration rules, there may be rules in this respect, or more often there are presumptions in this respect. For example, in the ICC rules, there is a presumption that unless the parties have decided to submit the dispute to three arbitrators, there will be one arbitrator, a sole arbitrator will be appointed, unless the ICC court, on the basis of certain criteria, decides that the dispute warrants the appointment of a three-member tribunal. So there is this initial decision that in case of disagreement between the parties, either in the arbitration agreement or after the commencement of the arbitration proceedings, it is for the arbitral institution precisely to decide on the number of arbitrators. There are also specific rules applicable in domestic statutes on arbitration, which govern this issue, and which, for example, provide either for default rules on the number of arbitrators or possibly on the appointment of an additional arbitration whenever the agreement of the parties would render the arbitration agreement inoperable from this point of view. It's typically the case where the arbitration agreement provides for an even number of arbitrators. The parties may request the appointment of an additional arbitrator. The typical scheme for the appointment of an arbitral tribunal is that either the arbitral institution or the appointing authority, which is a third person or institution that is identified as precisely with the specific role of appointing arbitrators. In case of a sole arbitrator, it will be precisely for the arbitral institution or appointing authority to select the sole arbitrator. In the, I would say, more frequent situation of a three-member tribunal, the parties will appoint the co-arbitrators, and the institution or appointing authority will select the presiding arbitrator, subject, of course, to any different agreement the parties might have reached. And the constitution of the tribunal is an area where party autonomy has, I think, really possibly the broadest scope. And so it's quite frequent, for example, to see an agreement on the appointment of presiding arbitrators by the two party-appointed arbitrators. Or, obviously, the parties may even agree on a joint appointment directly by themselves, although this kind of agreements are, in my experience, quite rarely successful. I already covered this point. Sole or third presiding arbitrators are typically appointed by the arbitral institution, by the co-arbitrators. This can be the solution envisaged by the applicable rules or agreed upon specifically by the parties directly, or by the appointing authority. When, one way or another, the arbitral tribunal is constituted, subject to any other administrative formality, such as the payment of an advance on the costs of the arbitration, the file is transmitted to the arbitral tribunal. And this is the moment when the arbitral tribunal takes control over all procedural aspects, virtually all procedural aspects. Before moving on to the next procedural phase, a quick reference to the appointment of the arbitral tribunal in multi-party cases. I've referred here to this DATCO 1992, which is a very important, really milestone decision that was taken by the French courts in the 90s, the decision of the Court of Appeal in Paris, which was then confirmed and qualified by the Court of Cassation. This was a situation where the arbitration was pending between one claimant and two respondents. At the time, the ICC rules provided that unless the multiple respondents didn't agree on the appointment of an arbitrator jointly, the arbitral institution could appoint one on their behalf. Now, in this case, DATCO, the two respondents had very different substantive positions on the merits of the case. And so they refused to jointly appoint an arbitrator. Rather, one of the two respondents refused to join the first respondent in the appointment of an arbitrator. When the ICC court announced that it would appoint one on their behalf, the respondent, the second respondent, agreed to on the appointment of the arbitrator by the first respondent, but under protest. It made a reserve in this respect, and it subsequently, when the tribunal issued an award upholding its own jurisdiction and the regular constitution of the tribunal, this party challenged this award in French courts. And the French courts precisely decided that there had been a breach of the fundamental principles of the equality of the parties in the constitution of the arbitral tribunal, and therefore annulled the arbitral award. So after this happened in France, the ICC rules and other arbitration rules worldwide have been amended to provide for a different mechanisms and avoid the consequences precisely of the possible inequality of the parties in the constitution of the tribunal. And this is now reflected in Article 12.8 of the ICC rules, which, when there is precisely a situation of where the multiple claimants or respondents are unable to agree on a joint appointment, the institution will intervene by appointing all the members of the arbitral tribunal. Therefore, in a way, forfeiting the parties' right or interest in appointing an arbitrator of their choice, but respecting what is considered as a superior principle of equality of the parties in the constitution of the tribunal. There are then, of course, issues with respect to the composition of the arbitral tribunal. In particular, all arbitrators, as we know, must be independent and impartial from the parties. Recently, also, their availability has been added as an additional requirement, their availability of sufficient time to devote to the case. And there are international standards for to assess precisely whether a certain arbitrator has the necessary independence and impartiality. And most typically, at an international level, the IBA guidelines on conflicts of interest in international arbitration, which are frequently used also by institutions in assessing the arbitrator's independence and impartiality. And also the ICC published as part of its note to parties and arbitrators on the conduct of the arbitration proceedings under the ICC rules, published some guidance as to circumstances that will have to be disclosed at the beginning of the case that may raise doubts as to the arbitrator's independence and impartiality. Independence and impartiality are assessed at three different stages. The first is the stage of confirmation or appointment. Confirmation applies to the situation where an arbitral institution, as in the ICC system, is simply confirming an arbitrator that has been nominated by the parties or pursuant to their agreements, for example, selected by the co-arbitrators. Appointment is when the institution selects the individual directly. Now, obviously, the same requirements, the same independence and impartiality applies to all arbitrators, whether they are to be confirmed or appointed. But in practical terms, of course, the standards applied by institutions in vetting arbitrators' independence and impartiality tend to be a higher threshold when it comes to appointment, because the institution is in a way free to select whoever it deems appropriate, whereas in confirmation, it is in a way just ratifying something that has been done by the parties. But even in confirmation, I repeat, there is a power of the institution in not confirming arbitrators who don't meet the necessary requirements of independence and impartiality. A second stage at which arbitrators' independence and impartiality can be assessed is if a challenge is filed against an arbitrator. So this is after confirmation or appointment. A party may challenge an arbitrator on various grounds, which are described in arbitration rules, but generally it's independence and impartiality. Under the ICC rules, there is a reference to any other reason to challenge an arbitrator. So it may, for example, be the lack of certain other requirements agreed upon by the parties. And then there is a specific procedure that is also governed by the applicable rules. This is when challenge is when the parties themselves request the removal of an arbitrator, disqualify an arbitrator, but institution may itself take the initiative of removing an arbitrator. For example, an arbitrator who is not fulfilling his duties under the rules, who's delaying the proceedings or for other reasons. It's quite rare, but sometimes institutions do themselves take the initiative of replacing arbitrators. Let's move to the third phase of the proceedings, which is the actual arbitral procedure before the arbitral tribunal. I already mentioned at the beginning that this the procedure before the arbitrators is governed by any rules the parties may agree upon, or in the absence of an agreement, the arbitral tribunal has the power to decide. The arbitrator's powers is reflected in, I would say, all arbitration laws and rules. If this has not been decided before in the arbitration agreement or at a later stage, the language of the proceedings may still have to be decided by and in most arbitration rules, this is a decision that the arbitral tribunal will have to take. Language or languages sometimes is mentioned in arbitration rules, the possibility of having more than one language. In most cases, as also mentioned before by Patricia, one language is chosen, subject to specific arrangements that may be made during the proceedings to have, for example, documents in a language other than the language of the proceedings submitted in the original language without translations. There may be practical arrangements to limit or avoid translation costs. In ICC arbitration, there is a typical feature, which is the terms of reference. Terms of reference is a document that is ideally signed by the tribunal and all the parties within, under the current rules, 1 month after the file is transmitted to the tribunal. It's a document that reconfirms the parties' agreement to submit the dispute to arbitration, that in a way provides a snapshot of what the dispute is at this initial stage, generally based on the parties' initial briefs, And it also records any agreement the parties may reach on the conduct of the procedure. Terms of reference are generally adopted or discussed and possibly adopted during a case management conference that under the ICC or other rules arbitrators are now required to hold with the parties at the initial stage of the proceedings. Whatever doesn't go in the terms of reference, or if we are not in the context of an ICC arbitration, all procedural rules are generally reflected in what is typically referred to as procedural order number 1. It can, of course, be number 2 or number 3 if language or other issues had to be discussed and decided before. But let's say there is generally a document in the form of an order which reflects all, as I said before, the fundamental rules applicable for the conduct of the proceedings. Vague but also quite important is the duty of parties and arbitrators to conduct the proceedings in an efficient and cost-effective manner. This is now a clause that you will find in most arbitration rules. Again, I said vague because, of course, it doesn't reflect in specific provisions, or rather it reflects on specific provisions that are also included in the rules. But this is a fundamental principle that all rules now want to emphasize. I already mentioned the normative framework for the conduct of the procedure before the arbitral tribunal, the rules of the arbitral institution, which, however, tend to contain very little guidance on the conduct of the proceedings, any domestic law rules applicable on the basis of the parties' agreement or considered mandatory by the arbitral tribunal, any rules contained in the terms of reference, or, regardless of whether they are reflected in terms of reference, might have been agreed upon by the parties or are decided by the arbitral tribunal. Now, I mentioned during my introductory remark earlier this morning that there are, of course, two fundamentally different approaches to the conduct of the proceedings. Civil law, which is more inquisitorial, with broader power of the adjudicator in the conduct of the proceedings, and common law, which tend to respect more the party autonomy also with respect to the conduct of the proceedings, and in which the role of the arbitrator with respect to the conduct of the proceedings is much less proactive. Now, as I also already mentioned, in what prevails at an international level is a transnational approach, an approach that tends to combine elements of both legal traditions, even if this is not absolutely mandatory. This is what is reflected in the soft law instruments I mentioned before, the IBA rules on the taking of evidence, the Prague rules, of course, in different ways, but all, let's say, commonly used international soft law instruments tend to reflect a procedural model that combines elements of the two traditions. However, the parties, in particular, if all the actors of the arbitral process belong to a certain cultural and legal culture background, nothing prevents them from adopting, obviously, a procedural model that follows either the civil or the common law approach, or whatever the parties and the arbitrators are most familiar with. But let's say, at a broadly, generally speaking, a transnational approach is what prevails at an international level. We can, of course, distinguish a written phase from an oral phase.
Andrea, sorry.
Yes.
I'm terribly sorry to interrupt you, but we have reached midday, and I think you first, and maybe the participants, I think we might need a break because we started at 9:30. Would you, I know it's very bad interrupting, but what would you feel, like a break now, or do you feel, I mean, I don't know how long you still have. This is extremely interesting, and it's better if we have a fresh mind. Would it be terrible if we had a break now, because it's midday? I'm sorry.
I think that is It's absolutely fine, and it may be also the right point to pose. I think I probably have some 10-15 minutes left before handing over to Beatrice, but I agree this could be the good time for.
Okay, well, I'm terribly sorry to break you right in the very middle, but I think if we take 15 minutes and reconvene at 12:15, we will have a fresher mind. It's very important that we all have fresh minds, because it's all so important what you're telling us. So thank you very much for this interruption, and 15 minutes for a coffee.
Very good. See you later.
Thank you. Sorry. Thank you. Okay.
Let's go back and quickly deal, before we proceed with the written and oral phase of the proceedings, with two issues which again Patricia already mentioned when she dealt with the arbitration agreement, but I think it's interesting to see how certain topics reflect on several aspects of the process, particularly from the arbitration agreement to the arbitral proceedings themselves. One is confidentiality. I mean, she mentioned that this is something that is frequently dealt with in the arbitration agreement, sometimes also with very complex provisions on confidentiality. This is also something that is frequently dealt with in the terms of reference, whenever there is an interest of the parties in regulating the confidentiality of the proceedings, possibly in the procedural order, the first procedural order dealing with the procedural rules, or obviously most arbitration rules also recognize the arbitrator's power to render a procedural order on confidentiality of the proceedings in general, or on specific, the confidentiality of specific aspects of the proceedings. Another thing I wanted to mention, as I referred before, the constitution of the arbitral tribunal to the emergency arbitration proceedings, I also mentioned that under most arbitration rules, arbitrators, the actual arbitral tribunal, is also empowered to make orders on interim relief on urgent measures. Once again, this is something that is recognized by all arbitration rules. What is interesting, of course, from the point of view of an Italian lawyer, is what is the situation under Italian law, because as you probably all know, Italy is one of the few jurisdictions in which a provision contained in the Code of Civil Procedure still prevents arbitrators from rendering interim measures, and still reserves this power to the courts. There has been a debate about the possible change of the law, of course, in this respect. Article 818 of the Code of Civil Procedure is still in force, although it reserves the possibility of a different approach to this rule whenever specific provisions of the law so provide. But this is something to keep in mind, because arbitration rules, including the rules of the Milan Chamber or other Italian institutions, refer to the powers of arbitrators to render decision on interim relief. But this is, of course, still subject, whenever the arbitration proceedings are seated in Italy, to the rule of Article 818 of the Code of Civil Procedure, which is generally considered as a rule of a mandatory rule, which therefore the agreement of the parties cannot derogate from. Agreement of the parties possibly reached by reference to arbitration rules that provide for this power. So this is still, for us Italians, an open problem, something that is not a problem in arbitration seated in, I would say, virtually all other jurisdictions, where the arbitrator's power to order interim relief is generally and very largely admitted. So let's move quickly to the actual proceedings before the arbitrators. As I said, there is a written and an oral phase. A written phase which generally consists of an exchange, one or more exchanges of pre-hearing written briefs. We mentioned the initial exchange of brief, the request for arbitration, the answer to the request for arbitration. When the tribunal is constituted, it will generally give the parties additional time limits within the procedural timetable that generally is adopted as part of the procedural order number 1 or otherwise, the tribunal will give the parties additional time limits for the submission of actual briefs on the substance of the case, which is a statement of claim, a statement of defense, possibly a second round with a reply, a rebuttal. The number and the sequence in certain situations may vary. For example, while it is typical to have successive sequences, precisely statement of claim followed by a statement of defense and possibly a reply and the rebuttal, in situations where, for example, both parties have claims against each other, it is also possible to provide for simultaneous submissions. These are all issues that are can be agreed upon by the parties or are otherwise decided by the arbitral tribunal. Written briefs will obviously also attach documentary evidence, and the parties' agreement or the tribunal's order will also provide details as to how documentary evidence will be provided, issues of language, as we mentioned before, and even very practical issues of how this should be presented. After the hearing, to which we'll come in a moment, that generally is a post-hearing phase with post-hearing briefs that will be submitted, the scope of which may vary. In certain cases, arbitrators may want full-fledged final submissions of all issues discussed in previous briefs and at the hearing. In other cases, arbitrators will invite the parties to submit focused post-hearing briefs on issues the tribunal still requires clarification on. Again, this is something that is generally decided by arbitrators in consultation with the parties. An important aspect of the written phase of the proceedings is the document production phase. This is something that, again, as Italian litigators, we are not very familiar with. As we know, the possibility under Italian or other civil law systems to request the production of a document that is in possession of the other party is extremely limited. And we know that this is not the case in common law jurisdictions where, to the contrary, this power is very broadly recognized. Now, in international arbitration, the possibility to request the production of documents in the possession of the other party is generally admitted, certainly in terms that are broader to what Italian law or other civil law jurisdictions would permit, but probably not as broad, or certainly not as broad as it would be under US or even English civil procedure. This, in a way, compromise between the two traditions is somewhat reflected in the IBA rules on the taking of evidence in international arbitration, and the central rule on document production is Article 3, Paragraph 3 of the IBA rules, which permit, of course, the request for document production, but refer to a narrow and a specific requested category of documents that are reasonably believed to exist. So you see several terms that tend to limit the scope of document production. So the so-called fishing expeditions, where parties request the production of undefined and extremely broad categories of documents, would certainly not be admitted under these standards. There is a practice with respect to requests for document production, which is generally reflected in a document that is in international arbitration jargon is generally referred to as the Redfern schedule. Redfern is a well-known English arbitrator who created this practice. It's basically a very simple spreadsheet where divided into columns to force the parties to be succinct in their requests and in their arguments on document production. In the first column, the requesting party would include a reference to the document it requests production of. In the second column, it will indicate the reasons, the basis for the request. A third column would then be for the other side, the requested party, to indicate its objections and the basis for its objection to document production, or possibly the production of certain documents it accepts. And finally, there is the final column where, in general, in very concise terms, the tribunal will set out its decision on the production of documents. As we said, with a somewhat following, in most cases, the somewhat narrow approach reflected in the IBA rules on the taking of evidence. The written phase of the proceedings is generally followed by an oral phase that tends to have a place which, again, is much bigger than what would be typical in a civil law style procedure, meaning hearings in arbitrations tend to be pretty long. They consist generally in the parties' oral arguments, which take the form of opening statements at the beginning of the hearing and then of closing statements at the end. And then in the middle, the central, and I would say most important part of the hearing is devoted to witness examination. Before that, maybe a reference to whether the parties have a right to a hearing, something that is quite hotly debated, especially in the current situation, where, as you can imagine, holding a hearing is sometimes problematic. Article 25(2) of the ICC rules, for example, refer to the possibility of the arbitral tribunal, or rather requires arbitral tribunal to hear the parties together in person if any of them so requests, or even failing a request of a party, if the tribunal itself decides to hear the parties in person. So, in a way, this provision seems to identify indeed a right of the parties to request a hearing, or even in the absence of a request, if the tribunal deems it appropriate to hold to hear the parties in person and to hear witnesses, of course, the tribunal can decide to have a hearing. But this is, in a way, a right the parties seem to have under Article 25(2) of the rules or other similar provisions. Now, hearing the parties in person, of course, doesn't necessarily mean convening an in-person meeting in the presence of the parties, and this is why I say this is this rule, which, by the way, will probably be amended in the ICC rules that will come into force in January, provides arbitrators, following the experience of the last few months, but more generally, given the evolution of technology, gives arbitrators the power to agree that hearings can be held through precisely technological tools, even without a physical presence, something that is becoming almost the rule in the last few months, and that will probably remain certainly more than we've seen in the past in the future of international arbitration. Witness examination, again, as I said, is the most important part of a hearing. Again, it's something that takes place according to modalities which are quite different from those Italian or civil law litigators would be accustomed to. Typically, a witness will have submitted a witness statement before the hearing, with the parties' briefs or otherwise, to identify the scope and the subject matter of the testimony. And the general rule will be that the witness will be examined on the basis of the witness statement at the hearing, briefly by the party offering the witness, so-called direct examination. But then I would say the core of the witness examination will be cross-examination, examination by counsel of the opposing side, which obviously will try to underscore any possible inconsistency or contradiction in the testimony of the witness, if not try also to, in a way, attack the credibility of the witness, possibly generally followed by a short redirect examination by the party offering the witness, in which that party will try to rectify any issue that might have arisen during cross-examination, with obviously the arbitral tribunal's power to intervene in this process at any stage. This applies to witness evidence. Of course, there are two types of witnesses, generally speaking: factual witnesses who precisely give testimony on the facts of the case, and expert witnesses that the parties offer on possibly technical issues relevant to the resolution of the dispute, or even on legal issues. In cases, for example, where specific legal expertise on certain issues is required, the parties are allowed to offer expert witnesses. The rules in the examination of factual and expert witnesses are not significantly different. Of course, the subject matter of the testimony is different. And finally, talking about experts, the tribunal may appoint its own experts. This may be the case when the parties themselves have offered witnesses on technical or legal issues relevant to the resolution of the dispute. In my experience, this tends to be quite rare. To avoid the costs and possibly also the procedural complexity of involving a tribunal-appointed experts, arbitrators tend to decide the case, hearing the parties and their experts. But in particularly complex and technical cases, arbitrators may indeed want themselves the comfort of their own experts. And finally, and this is just a reference, what I described at the beginning as a very last procedural phase after the award, which of course I'm not dealing with, and you will hear from Maria Beatrice on this point. After the award, there may be a procedural supplement if the award requires correction, interpretation, or if the award possibly omitted to deal with issues, at least in a party's opinion. In this case, before these defects, minor defects, are raised in setting aside or enforcement proceedings, they may still be rectified at the stage within the arbitral process itself. And so arbitration rules or arbitration laws provide for time limits after the notification of the award to the parties to request corrections of errors which are generally narrowly described as computational or seminal errors, the interpretation, which is the case, the situation in which there may be an apparent contradiction between the body of the award and the dispositive section, or possibly, as I said, certain laws and certain arbitration rules provide for the possibilities of inviting the tribunal to issue an additional award on claims that have been submitted to it and that, according to the parties submitting the application, the tribunal failed to address in the award. I know it was a lot. I'm sorry if I was a bit long. I don't know. Maybe we have a few minutes for questions, but I don't want to take too much time to Maria Beatrice's presentation.
Okay, wonderful. Thank you ever so much. This was a wonderful presentation. My personal suggestion is that we should take each and every of these slides afterwards and slowly go through them using the documents that have been provided. So using the ICC, the IBA rules, the ICC regulation, so as to take it in, because I mean, there could be a full course only on this. I'm wondering whether there are any questions. I don't see any questions on the chat. I don't see any on the chat, and well, thank you very much for underlying the special situation of Italy, which is that yet no interim measures can be issued by the arbitral tribunal. You must go to court. This is a limitation and in particular the differences between the common law and the civil law general approach with the orders for production of documents, although very limited in scope, based also on this red fern schedule. This is very interesting. Possibly the lack of questions is due to there are so many so many aspects that have been looked at. So I'd like to thank you ever so much again, and it's been very, very precious, everything that you've told us, and I'm going to ask our next speaker to take the floor. I'm not sure I can see the participants at the moment, but I believe you're there.
I'm here, but Andrea dovresti non condividere più il tuo schermo.
Okay, so
now you're talking to. Is it okay?
Yeah, that's great. So thank you so much. I hope you can hear me well and clearly, but because I had some connection problems, I don't know why my connection is rather poor today. So after such detailed and extensive presentations from my colleague, I will try to present the complex topic of the result of the arbitral procedure, the award. So it's my turn to, okay, I must say just a second, yes, okay. Is it okay? Can you see it?
we can see it. I think you need to press.
Yeah, I'm doing.
Perfetto.
Okay, great. So this is more or less the outline I'm planning to offer to the audience. So we will have three parts: the award, the issue of setting aside the award, and then recognition and enforcement of foreign award. And given the strong interconnections with some domestic rules, sorry, I choose to make reference to Italian Code of Civil Procedure, and whenever quoted, I also decided to keep the provisions in Italian. So, okay, here we are. So, moving towards the award. At the very end of the procedure described by Andrea, we have the deliberation. What do we mean with deliberation? Deliberation is the moment in which the process of reaching the decision. So the deliberation is a very delicate moment during which the arbitrators will probably meet in person, supposed to meet in person, but as Andrea already mentioned, in this year's pandemic showed the great flexibility of arbitration, and in many cases the deliberation was kept in remote, let's say, not virtually, but in remote. But according to our Article 823 of the Code of Civil Procedure, il lodo è deliberato a maggioranza di voti con la partecipazione di tutti gli arbitri, and it's written, e ciascun arbitro può chiedere il lodo sia deliberato riuniti in conferenza personale, so in person. But Let's move to a different problem. When is the right time to deliberate? Because of course this is quite provocative. The night before the hearing, during the hearing breaks, or after the proceeding has ended. Well, actually, I think it really depends on the case, on the arbitration case, and on the arbitral tribunal. Of course, the deliberation should occur after the proceeding has ended, and the parties have had the right to describe their positions. So I think that that is the best part, the best moment for starting deliberation. And here we have a few notes on the deliberating techniques. As I said before, it really depends on the arbitral tribunal, on the single arbitrators, and it could be it could be on the initiative of the chair of the arbitral tribunal to prepare a draft and then share the draft with the other arbitrators. And sometimes it could be, it could be circulated an agenda, or as it's usually called, a decision tree, with especially when the case is particularly complex, and a decision tree could also be used. The deliberation techniques could also move through an exchange of different communications among the arbitrators, and this is certainly the case in the most recent the awards rendered during this pandemic, when there was no possibility for the members of the arbitral tribunals to meet. And in any case, the majority rules apply, and these according to our Code of Civil Procedure and also the ICC rule, when the arbitral tribunal is composed of more than one arbitrator. So we are thinking of a three-member arbitral tribunal. The award is made by a majority decision. And then we have the possibility of a dissenting opinion, which could be raised by one of the members of the arbitral tribunal. Sometimes it could be raised even during the arbitral procedure. The members of the arbitral tribunal might feel that one of them is already making his or her mind to a different solution, but there is, of course, a possibility for them to express in a separate opinion their dissents, and the dissenting opinion might be attached to the final award. Another possibility is that the deliberation is reached by a truncated tribunal. This is even, it's an extreme possibility. So we are going beyond different opinion by one of the members of the arbitral tribunal. Here we have the case in which one of the arbitrators refuses to participate in all the proceeding or in part of the proceeding, and so refusing to take part of the decision. Here, well, of course, this is not a very positive solution, but sometimes the decision might be reached by the truncated tribunal. In this case, it's clear that validity is challenged because of a violation of the principle of collegiality. but we also have to consider that there are certain arbitration rules which provide for the validity of an award rendered under this situation. So, drafting the award. So we are going to the more realistic part of the writing the award, and it is probably important to consider who is the award written for the parties, for the council of the parties, for the court who will enforce the award. In any case, what is extremely important and what is highly recommended is that the award must be clear, accurate, and comprehensive. And this is, for instance, sorry, I was moving towards. The language of the award should be clear, and all the reasons should be accurately motivated and comprehensive, meaning that all the issues have to be dealt with by the arbitral tribunal. Of course, there is an obligation to render an enforceable award, because maybe the question is not who is the award written for, but what is the award written for. So the award has to be enforceable, and this is what is provided for by Article 42 of the ICC rules. And the court and the arbitral tribunal, the arbitrator shall act in the spirit of the rules and shall make every effort to make sure that the award is enforceable at law. So that's the purpose we have to keep in mind when drafting the award. As I said before, the drafting of the award might be done at the beginning or structured by the president or jointly by the arbitrators. It's really up to the arbitral tribunal to decide how to proceed for the drafting. Sometimes in an arbitral tribunal where the roles are perfectly well balanced, the arbitrators will try to divide their roles, and each of them will be assigned with a specific issue, and then of course a personal conference or meetings will have to coordinate their work. And so try to provide a perfectly uniform also in the language award. Or so it's up to the arbitral tribunal. What is the role? You might know that sometimes arbitral tribunals, especially in complex cases, need the help for a secretary of the arbitral tribunal. But the secretary of the arbitral tribunal should only have an administrative role and not a role in drafting the award. And this is something which is now clearly stated in the ICC note to parties and arbitral tribunals on the conduct of the arbitration, which is a note issued and recently updated by the ICC Court and Secretariat, where we can read that under no circumstances the arbitral tribunal may delegate its decision-making function to an administrative secretary. And I think that many of us have started acting as secretary of an arbitral tribunal, which is a great experience also for our career, for our profession, but still it's really an administrative role. So the arbitral tribunal cannot rely on the administrative secretary to perform its duties. Really, the drafting of the arbitral award has to be made by the president and the co-arbitrators. Well, moving to the definition of the award. What is an award? The award is the decision by which, in general, the arbitral proceeding is closed. And we do not have a definition of award in the New York Convention. According to our Italian Code of Civil Procedure, which is extremely important in considering the effectiveness of arbitration compared to the court, we can read that il lodo ha dalla data della sua ultima sottoscrizione gli effetti della sentenza pronunciata dall'autorità giudiziaria. So we do not have any definition, but we have maybe something more, which is the effect, the importance, well, the validity and the binding character of the award is clearly demonstrated by this provision, even if we do not have a definition. As I said here, the award is the decision by which, in general, the arbitral proceeding is closed. Why did I say in general? Well, because we might have other awards, we might have different categories of awards, for instance, partial awards, which are decisions that only partially rule on the merits of the case, and partial awards might be aimed at deciding certain specific issues before arriving to the end of the case, or interim awards that rule on some preliminary issues without settling the case, and this could be the case of an award on jurisdiction. So the distinction is relevant as long as we have to consider the purposes of the enforcement of the award, and then, of course, consequently also potential challenges to the award. So in sum, which are the categories of award? That's why I said in general. Well, first of all, we have domestic awards and foreign awards. In these, I took one of the slides presented by Patricia just to keep in mind the role of the seat, because she very clearly, she put all the points, the basic points, which are extremely important for the award, also in considering the different character of a domestic award or a foreign award. And the qualification of what is a domestic award or what is foreign has to be made in accordance with the point of view of the court where the recognition or the enforcement is requested. As I said, a partial awards is an award, a decision that only partially rule on the merits of a case, and interim awards, again, rule on some preliminary issues. And then awards on jurisdiction, which could be only jurisdiction, on quantum, awards by consent, whenever the parties reach a settlement during the procedure, which is something that happens quite well, probably not really frequently, but often. Additional awards or awards rendered ex equo et bono. So these are the different categories of the award. Now moving to the requirements of an award. The award must comply with some formal requirements, and we have already mentioned the antitrust model law. And according to Article 31 of the antitrust model law, the award, as already mentioned, shall be made in writing and shall be signed by the arbitrators. It will have to state to contain the reasons upon which it is based, unless the parties have agreed differently, and it shall state its date and the place of arbitration as determined with Article 20. So the award shall be deemed to have been made at that place. So this is important in trying to qualify the award as domestic or foreign. Still in relation to the qualification of the award as domestic or foreign, I just want to mention briefly that the New York Convention of 1958, which is the Convention for the Recognition and Enforcement of Foreign Awards, states at Article 1.1 that the Convention will apply to the recognition and enforcement of arbitral awards made in the territory of a state other than the state where the recognition and enforcement of such awards are sought. So this is also an important criteria to be considered to define and to distinguish domestic and foreign awards. According to our Code of Civil Procedure, the award should contain the name of the arbitrators, the seat of the arbitration, the indication of the parties, so the names of the parties, the arbitration agreement, the grounds, and then the decision. And again, the award has to be signed by the arbitrators with the date of signing. One of the difference Andrea mentioned procedural orders, and he also raised the issue of a difference between procedural orders and awards. Of course, awards opposed to procedural orders may be challenged before national courts. They cannot be revoked or amended by the arbitral tribunal and may be recognized and enforced abroad according to the New York Convention of 1958. Time limits for the award. Well, of course, the award must be rendered within certain time limits, which could be provided for by the lex arbitri or by the institutional rules chosen by the parties. Considering that we have chosen the ICC rules, well, we have Article 31 of the ICC rules, according to which the time limit within which the arbitral tribunal must render its final award is 6 months. And the time limit shall start to run from the date of the last signature of the arbitral tribunal or by the parties of the terms of reference, or by the date of the notification to the arbitral tribunal of the approval of the terms of reference. And in any case, the court may extend the time limit pursuant to a reasoned request from the arbitral tribunal, or on its own initiative if it decides to do so, that it is necessary to do so. So the time limits might be extended, and this is the case in which the parties might request to the ICC court, or the case in which it's the ICC court secretariat to extend the time limit for rendering the final award. The time limits also appear in our Code of Civil Procedure, where in case there is no fixed term for the award, different term, the arbitrators have to render the award within 240 days from the moment of the appointment. And also, according to our Code of Civil Procedure, the term for rendering the award might be extended. So, in case there are no different indication by the parties, the time limit might be extended for 180 days in certain cases. And as it's stated in the article, no more than once whenever all the conditions here stated are indicated. So in case they need mezzi di prova additional, mezzi di prova, una consulenza tecnica d'ufficio, se è pronunciato un lodo non definitivo, un lodo parziale, o si è modificata la composizione del collegio arbitrale o è sostituito l'arbitro unico. So this is what is provided by our Code of Civil Procedure. Here we have a very useful instrument provided by the ICC. I'm afraid you cannot read very clearly, which is an ICC award checklist. So it is an instrument provided to help arbitrators acting under the ICC rules of arbitration and in order to guide them during the drafting of the award. And we have different issues, some general indication which have to be contained in the award, like the ICC case reference, and then the table of content if possible, some abbreviations and translation of quotations should be made in the language of the arbitration, and the indication of the version of the ICC rules which is applicable in the case. So these are general considerations. Then, according to the ICC checklist, the award should also contain the correct identification of the parties, their representatives, and the arbitrators. So the names of the parties, with all addresses and correct names, then the parties' counsel, and then the arbitrators. Sorry. But what is extremely important is, of course, reference to the arbitration agreement. So the precise quotation of the entire arbitration agreement, and with a possible, sorry, amendments to the agreements. Then the quotation of the choice of law clause, where you have already learned about the relevance of the choice of law clause, and it has to be indicated clearly in the award. And then normally the award will provide an history of the arbitral proceedings. So a summary of the procedural steps followed by the arbitrators and all the different communications exchanged between the arbitral tribunal and the parties. Then all the references to the ICC court decision regarding the rules, the applicable ICC rules, so the version of the ICC rules, the place of the arbitration, the number of arbitrators, how the arbitral tribunal was constituted, and so how the arbitrators were appointed. Then the date of closing of the proceedings, and the indication of the time limit for rendering the award. Then again, other issues are the cost of the arbitration in case we have a final award, which could be fixed by the ICC court, and all the details concerning each party's legal costs. And then the allocation of costs between the parties, together with due consideration of the parties' legal costs. And then we go to the dispositive section, so to the real content, the merit of the award, followed by the indication of the place of the arbitration and the date with the signature of the arbitrators. So these are according to the ICC model which we choose, we have chosen today as relevant arbitral institutions. This is the checklist guideline that the arbitral tribunal is invited to follow. So according to the ICC system, the court is also has the right to provide for a review of the award, which is called scrutiny of the award. So before signing the award, the arbitral tribunal will send the draft to the court, and the court may lay down modification, amendments, and may also raise issues as to some points of substance. As you can see, it is not a review on the merit, but the ICC court has the power to draw the attention of the arbitrators to some points of substance. So therefore, it is not only a formal scrutiny by the court, but it sometimes might also indicate some, let's say, more sensitive issues, which should be maybe stated in a clearer way, or points where the language is not as clear as requested. But this is absolutely necessary, and no award shall be rendered by the arbitral tribunal under the ICC rules until it has been approved by the court. So now let's move to the cases in which we have the award has been signed, we already had the scrutiny by the institution, if so provided by the arbitration rules. And then so now we have the award, which has to express all its effects. Well, here the lex arbitri comes into consideration, because the procedure, the time limits, and the grounds for setting aside an award are regulated by the lex arbitri. Arbitration laws generally provide for specific remedy, whereby the courts may review an award also only in relation to minimum procedural and jurisdictional requirements of the proceedings. Needless to say, there is a pro-enforcement presumption, and this is clearly stated in Article 5(1) letter E of the New York Convention, and where the convention stated that the recognition enforcement of the award may be refused at the request of the party against whom it is invoked only if that party furnishes to the competent authority proof that. And so, what has to be proved? That the award has not yet become binding on the parties, or it has been set aside or suspended by a competent authority of the country in which or under the law of which that award was made. That's why the setting aside of the award has a strict connection with the recognition and enforcement according to the New York Convention. But we have to keep it to keep very clear in mind that according to the New York Convention, there is a strong feeling pro-enforcement. Which are the grounds? Sorry, the grounds for setting aside adopted by the ancestral modern law. The grounds are strictly noted in Article 34. So, a party to the arbitration agreement was under some incapacity, or the agreement is not valid under the law to which the party has subjected it. The party making the application was unable to present a case, so we had a breach of due process, which is one of the major causes, considered one of the major causes for determining the setting aside of the award, or the award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration, so what we also called ultra petita, or in any case it contains decision on matters beyond the scope of the submission to arbitration. So we have a case in which the arbitrators went beyond the scope of their role. Again, the constitution of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties or with the lex arbitrae. And then the subject matter of the dispute is not capable of settlement by arbitration. So the subject matter is not arbitrable, arbitrability as one of the grounds for setting aside. Or again, the award is in conflict with the public policy of the lex arbitrae. So again, we have, I think you can now connect all the different points already raised by my colleagues before, especially with reference to the importance of the lex arbitrae. Now, the time limits and the competent courts stated in Article 828, and the grounds are indicated in Article 829. So here we have Article 828. L'impugnazione per nullità si propone entro 90 giorni dalla notifica del lodo alla Corte d'Appello, nella cui circoscrizione è la sede dell'arbitrato. So we have a link between the court in front of which the setting aside can be requested and the seat of the arbitration. So again, don't forget what Patricia has said in her intervention. L'impugnazione is subject to some time limit, non è più proponibile decorso un anno dalla data dell'ultima sottoscrizione. L'istanza per la correzione, il lodo può essere impugnato relativamente alle parti corrette ai termini ordinari a decorrere dalla notificazione della pronuncia di correzione. Articolo 829, here we have all the grounds. So as you can see, we have the Italian version of what has already been clear. La convenzione di arbitrato è invalida. gli arbitri non sono stati nominati con le forme e nei modi prescritti, se il lodo è stato pronunciato da chi non poteva essere nominato, se il lodo è pronunciato fuori dei limiti della Convenzione di arbitrato, il lodo non contiene i requisiti indicati, è stato pronunciato dopo la scadenza del termine, nel procedimento non sono state osservate le forme prescritte dalle parti, il lodo è contrario ad altro precedente lodo o a precedente sentenza passata in giudicato tra le parti, se non è stato osservato il principio del contraddittorio, se il lodo conclude il procedimento senza decidere il merito della controversia, se il lodo contiene disposizioni contraddittorie, se il lodo non ha pronunciato su alcuna delle domande ed eccezioni proposte dalle parti. So, you can see we have a full set of grounds for the setting aside. Of course, I have to rush because of the time constraint, but I mean, you can see that it is clearly all the grounds for setting aside an award are clearly stated in this provision. L'impugnazione, just to take, I'd like to draw your attention to number 3, l'impugnazione per violazione delle regole di diritto relative al merito della controversia è ammessa se disposta dalle parti della legge, è ammessa in ogni caso l'impugnazione delle decisioni per contrarietà all'ordine pubblico. So I will move to the recognition enforcement of foreign awards, which is probably the something more linked to the idea of international arbitration. So the reference is to the New York Convention, and the states have an obligation to recognize and enforce foreign arbitral awards, and it applies to the recognition enforcement of awards made in the territory of a contracting state, which means in one of the many contracting states, considering that now we have 166 contracting states to the New York Convention. It is really an international convention, extremely successful. And this is a map just to show you how many states are sharing the provisions contained in the New York Convention. So this is also one of the reasons in favor of arbitration in certain international commercial relationships. So the possibility to make use of the set of rules of the New York Convention in so many countries. So what is the purpose of having an award recognized abroad? Of course, it is that the award should be recognized as binding on the parties and among the parties in the state where the recognition is sought. So first the recognition in order to obtain later the enforcement of the award in that state. Few basic rules in the New York Convention. The New York Convention has only a few rules, but very clear, and they've not been changed since 1958. So it means that they work and they work well. Each contracting state shall recognize arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon under the conditions laid down in the following articles. And here we have the under Article 4 and Article 5 of the New York Convention, we have the formal and substantive requirements for recognition and enforcement of foreign arbitral awards. And what is extremely important to stress is that the contracting states of the New York Convention, they can only provide for less stringent requirements for recognition and enforcement. So there was no other way. When the states adopted the New York Convention, they accepted in full what the convention provides for as to the requirements and the requirements and the grounds for recognition and enforcement. And so let's see what is needed according to the New York Convention to obtain the recognition and enforcement of a foreign award. So, according to Article 4, what has to be provided, supplied is a duly authenticated original award or a duly certified copy of the award. And then, of course, the original agreement. That's why it is so important to provide, to draft a valid arbitral agreement. And of course, if the award or the agreement have not been made in one of the in the language of the country in which the award is relied upon, well, the party will have to provide for a translation of these documents into the language, and the translation shall be certified by an official or sworn translator in order to be perfectly comprehensible and understood by the authorities of that country. And here we go to Article 5, number 1 of the New York Convention. These are the only grounds for admitted for refusing recognition and enforcement of the award. So the parties to the award were under some incapacity, or the agreement was not valid under the law to which the parties had subjected. Second, the party against whom the award is invoked was unable to present the case, so there was a breach of the due process. The award deals with a difference not contemplated by and not falling within the terms of the submission to arbitration, or the decisions reached by the arbitrators go beyond the scope of the submission to arbitration. Again, the composition of the arbitral tribunal, which was not in accordance with the agreement of the parties, or it was not in accordance with the law of the country where the arbitration took place. So the composition of the arbitral tribunal. And then last, the award has not yet become binding on the parties, or has been set aside or suspended by competent authority of the country in which, or under the law in which, that award was made. So these are the grounds for the sole grounds under which the recognition and enforcement may be refused. As I said before, there is a strong pro-enforcement presumption. So these grounds have to be interpreted narrowly, and notwithstanding what has been provided for in one of the national legislation of the countries involved, or the parties involved. And the party who makes the application must furnish the proof of the ground on which he relies. Article 5, as I said, is the core provision of the New York Convention. Under number 2, it states that recognition and enforcement of an arbitral award may also be refused if the competent authority in the country where recognition and enforcement is sought finds that So here we do not have any more reference to the procedure, to the details of the case, to the arbitral agreement, to the composition of the arbitral tribunal, to the decision, the ultra petita. Here we have two hypotheses: the subject matter of the difference, so of the controversy, of the dispute, is not capable of settlement by arbitration under the law of that country, so the subject matter was not arbitrable, or the recognition or enforcement would be of the award would be contrary to the public policy of that country. So these are the two conditions which are in addition to the cases under Article 5, number 1. So these are, as I said, these are the substantive requirements imposed by the New York Convention under Article 5.1 and under Article 5.2. So we have grounds which are linked to the case, to the arbitral procedure, and other reasons which are other grounds which are linked to the nature of the dispute. So to the arbitrability of the matter in dispute and the possibility that the content of the award would be better, the effect of the content would be contrary to the public policy of the country where recognition and enforcement is sought. Running out of time, so I'll go faster. Each contracting state shall recognize arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon. And here we have the applicable rules of the lex fori, which comes into consideration, relevant to competent court, stating competent court, fixing time limits, and fixing the grounds for challenge in case of refusal of the recognition and enforcement of the awards. In the procedure for the recognition and enforcement in the Italian Civil Code is regulated by Article 839 and 840. We have two-tier procedure. On one side, we have an order granting or refusing recognition of the award, which could be issued without the parties being heard. And the second one, the sentence deciding challenges to the order, but rendered in an adversarial setting. Well, what is the scope of the application of these two provisions, Italian provisions? First of all, the decision at stake should be an arbitral award, and therefore it has to have some requirements, and it has to be foreign. And in this case, the Article 1.1, which I read before, becomes relevant in order to consider the foreign character of an award. I will run on these provisions. Well, this might be interesting. Unless recognition is granted, a foreign award is not binding in Italy. But recognition does not entail enforceability. So the parties in the first year, the parties are not heard. It's the president of the Court of Appeal which reviews the formal validity of the award or denies recognition of the award ex officio. Okay, let's run. Maybe this might be of interest, which is the breach of a lex fori public policy, and it's the second condition under Article 5, number 2 of the New York Convention. What do we mean with public policy? Of course, it's you might be aware that it's a complex notion, and which entails rules and policies that Italian legal order does not allow to derogate from, even in its international relations. But of course, it's a notion which should be interpreted in a narrow way. We might have some examples taken by the Italian jurisprudence, for instance, and cases in which the foreigner was there was a violation of a procedural rule. Should I stop? I heard someone. Okay. Or foreigner was breaching criminal law rules, or breaching general principles of domestic and EU competition, bankruptcy law, cases connected with the order of punitive damages. So different cases in which the issue of public policy has been raised. This is tier 2, so we have the possibility of having it's very long, I will just run. We have the party may challenge the order, granting or refusing its recognition before the Court of Appeal. In this case, we have the adversarial setting. Again, the fundamental principles are pro-enforcement presumption and, extremely important, no review on the merits. And the party making the application can only rely on the grounds provided for by Article 804. I think I will just stop here, which is, I'm already late, I think. So,
well, this is wonderful. Thank you. Thank you so much. It's been extremely interesting. You've been rushing. Nevertheless, you were going slow because you're very peaceful in your presentation. So it means you're very well in control of what you're saying. Congratulations for that. It's not easy to get all this information through. We do have one question at least in the chat. If you can grab it, or I can read it out for you. Is it possible to impose a bank guarantee to a party domiciled in a non-contracting country of the 1958 New York Convention? Otherwise, enforcement becomes quite impossible. References can be made to Libya. I don't know whether you have an answer to that.
I think Andrea might have an answer on this because...
Of course. Thank you, Maria Beatrice. Thank you. But I think it's if I understand the question, is whether the nationality or place of domicile of the debtor on the basis of the award may justify probably not only the security for costs, but security for the outcome of the case, actually, for the award itself. But that would be a typical interim measure to be requested during the case. I think on the basis of arbitral practice, maybe the simple nationality of the debtor would not be enough. You would have to show something else, some deterioration of the financial condition of that party, for example. I mean, this is my experience, especially because in arbitration, as opposed to court proceedings, there is a presumption that when you enter into an arbitration agreement, you can assess the chances of enforcement of the award, considering who your opponent is. And so you can just claim that party is from Libya, so it's obviously difficult to enforce. Maybe you should establish something more. As I say, the deterioration of the financial condition between the time when the arbitration agreement was concluded and when the award may have to be enforced, and other elements.
Well, there was a reason why I passed the question to Andrea, actually. First, because it was interim measure, and then second, because if I'm not wrong, while you were secretary of the ICC court, you had a case with another country, maybe not this country you mentioned, which was involved in a case similar to the one raised by the Filippo Paris, I think. Yeah. So that's why I wanted you.
I mean, it also very much depends on who exactly your opponent is, whether it's a company that may only have assets in a certain jurisdiction where it may be almost impossible to enforce, or, for example, if you have a sovereign as the debtor on the basis of the award, you may consider enforcing the award also in other jurisdictions, which enhances the chances of enforcement, and therefore probably it reduces the chances of obtaining security for the enforcement of the award. But it's a complex topic.
Okay, well, I don't see any further questions, and I'm afraid we need to cut off because our next speaker is from Germany, and I'm sure that at 2:30 exactly he'll be expecting to start on. We go on for negotiation this afternoon. So I'd like to thank this wonderful panel. I don't think we could have had a better panel. So Patricia, thank you in Paris, and Andrea in Rome, and grazie Maria Beatrice Deli. Che piacere conoscerci finalmente. So thank you, and we will need to go through these materials. I'm sure there might be a discussion to follow within the group because there's so much information that's come through, so interesting. I've made so many notes, about 22 pages in fact. So thank you ever so much. It's been a privilege having you, and we will adjourn with the participants at 2:30 exactly for the afternoon then. Thank you.
Thank you so much, Carlo, everybody.
Bye.
Thank
Thank you so much.
Everyone.
Thank you to everybody.
Thank you for this.
you. Afternoon session, and what can I say? The only thing I can say about our leader this evening is that Professor René From is a lawyer with a leading law firm called Freshfields. Well, in German it's Freshfields Bruckhaus Deringer LLP, and a real leader in negotiation. I would say probably, or without probably, the best negotiation professor we have available is with you this afternoon. Having studied at the University of Bonn, then at Harvard Law School, and of course Harvard Law School, we know they have this school for negotiation program, then King's College. A wonderful background. And I'm going to hand over to you. We have 37 people present, and the floor is yours. Thank you very much.
Thank you so much for your very warm welcome and kind words. Let me quickly pull out my slides and then kick off. All right, so also from my side, hello everyone, good afternoon, and thank you so much for having me. That was more honor than I deserve, but it's always the pleasure of being in Florence, even virtually. It sounds so nice to say this afternoon I'm in Florence. Negotiation is an amazing topic because it relates to basically everything we do privately, professionally, and our success is widely influenced by how well we negotiate. And therefore, it's great to speak with you, all accomplished lawyers, this afternoon about this topic. The session will be split. The first half will be run by me, the second half by Mike. And of course, we've spoken about how to split the content. You'll get the the tough side by me. I've prepared 385 slides, just text, no jokes. So I expect you all to learn it by heart. And then Mike will do the American way of basically running some fun parts. No, kidding, of course. But let's start by asking the question, why on earth should we care about the topic of negotiation? I would like you to join me on a brief journey, mind journey. Imagine before Corona that on the way to your law firms, you have had an accident. The ambulance comes, you're injured, you're rushed to the hospital and into the emergency room. And here comes a very young medical doctor, lady or guy, doesn't matter, and says, "Hi, my name is Pete. I'm going to perform surgery on you." And you're like, wait, you look a little bit young. Have you done this before? And the person says, "Trust me, I'm a medical doctor. I've studied for many years, and the theory, I know it all. The practice, I haven't really studied that much." And how would you feel? I would assume that you don't feel that safe in that moment. But if you think about how we as lawyers, and I know that we are lawyers, we basically know everything, right? But that a lot of us, we are really, really good when it comes to legal content, but only a few of us have actually studied the strategies and techniques of negotiation, even though our clients expect us to negotiate on their behalf and to achieve great outcomes. But when we look at the curricula at law schools all around the world, maybe the US is a little bit different, but most other jurisdictions, we learn the content, but not how to get to the goal. And listening to another very famous lawyer, James Freund, who's a partner at Scan, M&A lawyer, he's been, well, many years of experience, and he's also taught negotiation for a bit. And he wrote in one of his books that lawyers and businessmen alike often are very, very good when it comes to substantive issues, but when it comes to the question of how to get to your goal, we're actually quite weak. And I've observed that in my own life, working with a lot of lawyers all over Europe and Asia and the US. And I think this is something where we can work on, because as you will see, negotiation techniques are no rocket science. It's all quite straightforward. We just need to make sure that we know what we're doing, then prepare, and then basically enter the game of negotiations. And my goal today would be to talk with you about 3 strategies that you can apply right away and that will have an impact on how you shape perception, increase profitability, and ensure sustainability of your deals, because that is basically what we all want to do in a negotiation. You will get the slides, so you don't have to take that many notes. All the slides will be in the PDF that's shared afterwards. And we'll also have some interactive simulation parts where you can actually test your knowledge and see how well you do. Because in normal life, you usually, I would assume, arrive at negotiation outcomes. The other side says congratulations to the deal, but you just don't know whether your deal is good, great, or average, because no one would say congratulations to 100, I would have paid you 200, right? So you just don't know how much you could have gotten. Today in the simulations, you will see how much of the cake you can actually get for yourself. So let's get started with a little video, and I would like you to please switch off your screens for a bit so that the bandwidth is stronger, and enjoy the video. And be reminded there's an interactive part now, so you actually have to talk. What would you say? Good outcome, bad outcome? Did Clooney do well or not so well? Just activate your speakers and share your thoughts. Don't be shy, you're all lawyers.
It seems to be that the only issues, the only thing he was interested in was coffee. So in this case, there is no such a margin to discuss, to bargain.
Mm-hmm. Would you say that Clooney did well in the negotiation?
Probably not. He had no idea, but he should probably make a counter offer. No, I did. Indeed. Okay. Probably should make an offer anyway.
What about the others? Any other thoughts about the 2 gentlemen negotiating about Nespresso?
Do we need to have a second go so people think about what is critical and come back?
So, do you want to run the video once again?
I don't know, just maybe we were not concentrating, or people were not concentrating on the fact that we need to actually think about it and come back to you.
Okay, good. So
just a suggestion to break the ice.
That's fine. So then let's revisit mentally. So what was the first mistake that Clooney actually did? And if you think it through, when he walked up there and the negotiation began, he said, "It must be a mistake. It's not my time." And that basically was the moment when he gave away all his negotiation power to the other side, right? Because from that moment onwards, Malkovich, the gentleman in white, knew exactly what Clooney cared about most, and he could use that knowledge to Clooney's detriment. Imagine the same situation where Clooney would not have said those words. Then Malkovich would have said, "I want the coffee maker," and Clooney could have responded by saying, "Oh, the coffee maker, what do I get in return? 50 years more of lifetime, maybe 2 angels to take with me?" It would have been a negotiation face to face. But here, the moment he gives away that he cares for his life so much, Malkovich could actually ask for whatever he wanted and would probably get. And then in the further course of the negotiation, Clooney did several other mistakes. The first counter offer, when Malkovich asked for the coffee maker, was a Porsche. How many coffee makers fit into a Porsche, right? I mean, it's just too valuable to give up as a first counteroffer, and then even a house at Lake Como. I mean, it's beautiful there, but you would never offer it for a coffee maker, right? So in a way, I know it's an ad and it's TV, but what I wanted to show you is that we often, consciously or subconsciously, verbally or non-verbally, give away signals to the other side that they can use against us, and that we often don't spend enough attention to those little details that have an impact on how we are perceived by the other side and how they perceive our own power. And power actually is an interesting thing. If you think about the negotiation we just saw, you might easily say, wait, I mean, Clooney didn't have any chance there. He was standing up to Malkovich or St. Peter or whoever he was. So there was a huge power imbalance between the two, a very strong and a very weak person. But is that so? I don't think so. I mean, of course, one of the two can decide over death or life, but apparently Clooney had something that Malkovich did not have, a coffee maker, and that he had an interest in. And that actually makes the negotiation an even one, because if you have something that the other side really wants, it doesn't really matter how strong they are, well, unless you care too much about what they can decide about. So in a negotiation, if you cannot walk away, if you need the outcome at all costs, then your power is weak. And if the other side can see it, then it's very, very difficult to get out of it with a great outcome. Then you have to be quite a good poker player. But it comes down not to how powerful the other side is, but whether they see how weak you are, or put differently, how you play your cards with regard to your alternatives. And when we think about what defines power in a negotiation, it's all about the question whether you can reach your goals by other means as well. So what we have to do is to think about what is our best alternative to a negotiated agreement with the person we're currently negotiating with. So what is your no-deal option? What would you do if the current negotiation fails and you want to achieve your outcome by other means? In many cases, it's a court proceeding, so you would probably do an analysis of the most likely alternative. So what are your chances in court? But it might also be having an agreement with another party or doing something else. And it's very, very important to define that best alternative, or BATNA, as they call it in Harvard, very early on, because that defines how you go into the negotiation and also what your walkaway is, because your walkaway, the minimum acceptable negotiation outcome, is actually your BATNA adjusted by cost. So any opportunity or transaction cost that comes with it. We will look at that in a bit more detail. But what I would like you to take away is, first, whenever you go into a negotiation, first think about, what is my goal? How can I reach it at the negotiation table or away from the table? And what is actually the walkaway point that I have? So the minimum I need to achieve because a lot of negotiators start negotiating without a clearly defined walkaway point, and that often leads them to be pushed across that line and actually giving in far too much. And if you think about the negotiation we just observed, there's another element that is really important. And that is that a negotiation is usually not about truth. You don't know what the other side knows. The reason for that is information asymmetry. You just don't have all the information that the other side has. And therefore, a negotiation comes down to be about perception. It's a perception that you have about the other person, but also that the other party has about you. And even if you're extremely weak, as long as you can shape the perception of the other side, as long as they believe you have other options and you don't need the deal that strongly, then this can easily give you the leverage you need to come to a good outcome. Unfortunately, in real life, a lot of people show consciously, subconsciously, verbally, non-verbally, that they are weak. And that then, of course, has an impact on the negotiation. Second, there is a thing called partisan perception. And that means that we have a lot of information available. You, your clients, the other side. And of course, our brain cannot digest all that information. So what our brain does is picking individual pieces, bits and pieces here and there, and then we give meaning to that, what we see or hear. And of course, it's influenced by how we see the world. But it could mean something completely different. But if you have a pre-assumption about something or someone, then that influences how you see certain information. Just think back when in the past you wanted to buy an expensive gadget, a car, a nice piece of jewelry, whatever. The moment you've started to think about it, the likelihood that you see it all around you, that you see a lot of those cars on the streets, is actually quite high. Why? Not because there are that many of those cars, but because you spend more attention and your brain digests that piece of information much stronger. So what we need to do in a negotiation is to make sure that we get the information right, that we ask a lot of questions, that we really understand what the goals of the parties are, what their concerns are, and stuff like that. Try not to have too many assumptions, but really talk about the stuff. You've heard that probably in other lectures as well, but it's tremendously important. And I think one of the biggest issues we see in legal negotiations that we just don't have enough information on both sides. And then there's one thing that I've observed that I find actually quite funny. And that is the question of, well, do I or should I think about the power of the other side? We are lawyers, so we prepare our cases diligently. We spend a lot of time preparing about the negotiations we have. But as part of that preparation, would you also think about the power of the other side? Would you try to identify who's more powerful, you or them? And a lot of us would.
What kind of power? Economic power?
Any negotiation power or negotiation leverage that they may have. So should we think about that? And there's a very interesting study they ran in the US. They took a group of senior lawyers, partners from big law firms. They were attending a one-week program. And they had to do a simulation, one like the one you're going to do. And they split the lawyers into two groups. Group A just received the fact sheet, the confidential information about the case, nothing else. Group B received the fact sheet, but also they were told the other side is very competitive, a tough cookie, a very tough negotiator who in the past always achieved great outcomes. Now, what do you think? Which group scored better? Which group achieved better outcomes? The group just with the confidential information, or the group with the additional information that the other side is a tough cookie? Now, a lot of people would say the group with more information, right? But the opposite is true. The group that didn't think about whether the other side is a tough cookie or not did significantly better. And of course, they negotiated with exactly the same person, so we could easily compare what was the impact of that additional piece of information. And it was that they started to negotiate against themselves. They had less expectations about what they could achieve. They started lower, they had lower walkaways, and they achieved less favorable outcomes. So stop thinking, stop guessing, don't think about whether the other party is powerful or not. Play your game, as long as they sit at the table, they must have an interest in negotiating with you because they invest money and energy. So assume they have the same interest as you with regard to finding an outcome. And then, of course, you play your game. So it's about perception. How do you shape their perception of your no-deal options? How do you get the information right? How do you show no neediness? And then how do you do that verbally and non-verbally? Strategy number 2 is about profitability. So how do you optimize your own outcome? And that obviously is something that we want to do in our negotiations for our clients to get the best possible outcome, right? And the question is, how do we get there? I would like to do a quick exercise, and for that I would need a volunteer. So someone from among you who dares to do a quick exercise with me. It's not painful, you will survive, no casualties in the past. Anyone who would dare to stand up for a quick negotiation exercise. Filippo, is that a yes?
Okay.
Perfect. Tell me a bit more about yourself first. Where are you from? What brought you to this program? What are you doing in your life?
Of course, I'm a lawyer. I'm from Rome, from Italy. I am a civil lawyer specialized in corporate and commercial disputes, mainly as a litigator. And I have our law firm has also a branch abroad in some Arab countries.
Okay, great. And this is the first program at UIA that you're attending, or are you regular?
No, this is my first program. I am associated to UIA from this year.
Okay, great.
I'm a junior associate.
So I saw you last week having lunch with this gentleman. You probably recognize the photo. So I was sitting at the table next to you, and happily I had Latin in school, so I could follow your conversation a little bit. And I heard Carlo, he was inquiring about how you like the program so far, how you think whether the courses are helpful, and whether you think it's worthwhile to attend. And he was really amazed by what you say and how you liked it, and how you saw the strategy for UIA and for programs like this. And at the end he said, Filippo, you're a role model for this group, for this association, and every participant should be like you. I mean, just the energy you have and the determination and like the understanding of the legal world. So he was really, really amazed of you. And then he did something that personally I found a little bit weird, but then Italians, come on. He took out of his suit a photo of himself, he signed it, and he gave it to you as a token of appreciation. You looked at the photo, you looked at him, you were like, okay, what's that? But you said, of course, thank you. And you took the photo. And then you thought, like, when he's such a busy man, such a successful lawyer, that he probably had forgotten about it anyhow the moment he was out of the restaurant. But anyway, you took the photo and you shared the story with the other participants in this course. And then they started to react in a weird way. They said, why on earth did you get the photo? I mean, look, we are also great lawyers. Luigi was like, come on, I mean, I'm also a great lawyer. And why did you get the picture, not me? So you felt a little bit the atmosphere getting tense. And one thing you want to avoid at all costs is a tense atmosphere in this group. So you thought like, okay, look, Carlo, he's so successful, he probably had forgotten about the whole episode. Anyhow, you want to increase the good atmosphere in this course, so you want to get rid of the photo, just to have like peace of mind. So you go on ebay.it and you type in signed photo Carlo Mastroianni, but nothing shows up. You go on google.it, nothing shows up. You check the international platforms, but apparently no signed photos of him are available. You check some other lawyer's name, but apparently no signed photos of lawyers are available. So you have a problem. You want to get rid of the photo, but there is no market. But happily, I tell you today, I've been collecting for the last 25 years signed photos of lawyers, and I'd be delighted to get this photo from you. So you're will to sell, I'm will to buy. The only thing we need is a good price. So what do we do? Yes, I know it's a little surprise, but I mean, you're good lawyers, so you probably come up with a good idea. So how do we deal with the situation? You want to sell, I want to buy. All we need is a good price?
Of course, it depends what you mean as a good price, but
yeah, I mean, you probably want more than I'm willing to pay, but I mean that's normal. So how do we go about the?
It's like the previous bargain between George Clooney and the coffee maker and St. Peter and St. Peter. No one.
No, but how should we do it? I mean,
well, it's not really easy, not easy task, really. Well, okay, but the only chance is only to negotiate the price, or there is also some other possibility? Because, for example,
I mean, yeah, I want the photo. You want to get rid of it. Here we are, and we need a quick outcome because we have some other stuff to discuss with this group. So, yeah, let's make it quick and dirty.
But, well, because if the target is to create a good atmosphere also within the group of the people, transfer the discussion from only to the to the price, maybe is not suitable. That means because this create only it's only matter of money, and this does not create a really good atmosphere between the people,
Okay, but let's assume whatever money you make out of this photo, you can invest in some drinks with the group, so you can come together and just enjoy a glass or two afterwards. So just let us get about it. How do we make it?
Okay.
Do you want to propose something? Should I propose? What do you think?
Okay, in this case, we can eventually propose, okay, certain price for the photo and all the income related to the selling of the photo. So it could be shared between the group of the people, as you say, for example, enjoying them with ourselves with some, unfortunately, virtual, drinking.
Okay, no, perfect. Let's do it that way. So, yeah, what about the price? How do we?
Or while we are planning, we are talking since the few months ago that in the future, maybe when we'll be able to meet each other in person, we will have a good dinner all together. From the selling price, I mean, all the amounts collected from the selling price of the photo, so eventually we will finance our dinner.
I'm not quite sure that the photo gets you that much, but okay.
Too much, yeah. At least some part of the budget.
Okay, so yeah, what are you thinking? Or do you want me to propose a price?
Well, let's say 50 euros.
50 euros?
Yeah,
gosh,
per photo.
Man. I mean, okay, it's great to have you. And I really think that, we offer this negotiation course here as part of this series because we want you all guys to become better negotiators. And let me tell you one thing. In negotiation, it's good to get a great outcome, but you should also think about reputation. So never ask for too much. And I've been doing this negotiation for quite a while. And I found a very fair process to follow. What I do is I compare the lawyer I want to buy with a soccer player, because there's a liquid market for signed soccer player photos. So we would now argue about what league this lawyer is in, obviously the best league available, and then what soccer club, and obviously I would give you that, also a very good soccer club. And in my world, the German soccer world, that is Bavaria Munich, and the best player we currently have there is Manuel Neuer. And then I would look into how much is his photo worth, and then I would double it because a lawyer has more in their brains than a soccer player, right? So I would go on eBay, I would find this photo for €9.90. I would double the price. So I would offer you €20 for Carlo's photo, and I think you would make great and could deal with that. So my offer stands at 20 euro. Would you be happy with that?
Okay, we can eventually consider the fact that we are talking about two different kinds of people. We are talking about one football, football player, and we are talking about one of maybe one of the best lawyer in the UIA, at least in Italy. So, from my point of view, I consider Carlo much important than, more valuable than Manuel Neuer. From my point of view, and this is my perception. Maybe I'm right, maybe I'm wrong.
Okay, no, I mean, I hear you and I get your point. So of course, it's weird to talk as an Italian about German soccer players because German soccer is not as good as Italian soccer. So I did some of your work and I also looked into some Italian players. You said you're from Rome, so let's take Daniele De Rossi. Who I think
for me is too much because I am not a supporter of Roma. I am a supporter of Lazio. So 7.99 is too much anyway.
Okay, so my offer of 20 euros stands. Would you agree on that?
So accept or not?
No, you can try to negotiate more, but I mean, I offer you 20.
For my point of view, Carlo, at least not less than 40.
You know how much I get for this lecture? I mean, after tax, this is probably pro bono and I have to pay on top. I mean, that's a lot of money. Look, if you give me an NDA, a non-disclosure agreement, I could possibly be willing to give you 25 euros. I don't need an invoice, so it's basically tax-free for you. But it's tough for me to pay you more than 25. Could we agree on 25?
If I have to use the usual technique in negotiation in the Arab country, I have to say to you, okay, 30, is the medium, is in the middle of the both, of both ways. Mm-hmm. So that's the most reasonable price.
Okay, so you want 30 for that? Okay, we have a deal. Thank you very much. So first of all, congratulations to Filippo for doing this little exercise. And now the question to all others. What you just observed.
Thank you, René.
Well, thank you very much for volunteering. Was a little negotiation, obviously. So what did we do well and what did we do not so well? What were your observations from a merely negotiation strategy and tactics point of view?
Probably.
Matteo, yes.
Can you hear me? I don't remember if you said that the Carlo Mastellone photograph was the only one on the market. Probably yes. The last one we can find on the market. Or there were some other photos of Carlo. Mm-hmm. I didn't understand that particular aspect.
The connection is not that good, unfortunately, so I only got a bit of what you were saying. Could you maybe repeat? Sorry.
Can you hear me? Can you hear me?
Go ahead.
I can hear you.
Okay, please say it again.
Can you hear me now?
Mm-hmm. Yes, better.
No. Probably I have some particular problem with the mic. I don't know why.
Just say it again, please. Now you're muted. Okay.
I didn't understand if the Carlo Mastellone photo was the last one or not.
Mm-hmm. Exactly. So the question is,
was the last one? Okay.
30 was the last offer that we had.
Probably, I think you put on the table some information that mixed it up, Filippo, because the price of De Rossi's photos or Neuer photo. There's no who know that they are the real price of that photos? You told
Yes.
that, but there's no particular evidence of that.
Exactly. So the problem we had here is that Filippo had no idea what the market price for Carlo's photo would be. Actually, there is no market, right? So we are negotiating about something where there's uncertainty about the acceptable outcome for the other side. And I choose this weird example because I wanted you to not have any related value that you could refer to. And Filippo's challenge was to think about what would be the best approach to go into this negotiation. When he proposed 50 euros as a price, do you think that was high enough? Could he have asked for more? Would 100 be okay?
I'd have asked at least 1,000 euro.
So probably you could have asked for more or less any number that you come up with. And you just need some justification how you can justify that it's a good number. You could say, well, Carlo charges 500 euros per hour. The lunch was a quick one. It was just 2 hours. So I think 1,000 euros would be fair. My reaction to no matter what number you say would always be shocking disbelief, right? If you ask for 50, I would say, it's too much. If you ask for 100, I would say, it's too much. If you ask for 1,000, I would say, it's too much. Why? Because I want to shape your perception of what is the fair price that I would be willing to pay. Now, why did I use those soccer player photos, which, as you know, I mean, they probably sign more photos than they actually play soccer themselves. So it's something that is not that easily comparable because everyone is having them. I used it because I wanted to start as low as possible, right? In order to start as low as possible, I needed to have some justification. And therefore I said, well, let's just compare him with a very liquid market and a soccer player that is quite cheap. So when we go into negotiation in order to protect our reputation, we need objective criteria, something that we can justify our demands with. And then it's up to you to decide how high or how low you start, as long as you protect your reputation by having a principle of fairness, some objective criteria that you can use as justification. Then what happens in nearly every negotiation, no matter whether you're talking about price or about a legal clause, is always the same thing. And this graph should identify or should show this to you. So imagine we have two parties, party A and party B, and they are looking or they are negotiating over a car. Party A is looking to buy a used car and has a standing offer in the market at 10,000 euros. So A would not pay more than 10,000 euros, but happily pay less. 10,000 euros is A's walkway, because if he gets a car of that quality at 10K, why should he pay more? So at 10K, he would break up the negotiation with B and rather buy the car at 10,000 euros. B is selling a used car and has a standing offer at 5K. So B would not accept less than 5K, but happily more than 5K to have a good bargain. So B's walkaway is 5,000. Because the two overlap, the greenish area in the middle is a room for possible agreements, a zone of possible agreement, or ZOPA. And it doesn't matter whether you end up here, here, or here, the deal is better for both parties than their respective alternatives. That is quite easy, and it applies to all negotiations. But now comes the fun part. A, of course, will not say, listen, B, I'm willing to pay up to 10,000, but I would like to only pay half. He will probably try to shape B's perception that A's maximum willingness to pay is slightly below B's minimum willingness to accept. And likewise, B wants to shape A's perception that B's walkaway point is slightly below A's maximum willingness to pay. Why? Because you want to optimize your outcome. And what we do in our negotiation, and again, it doesn't matter whether it's price or a legal clause, is to shape the perception of the other side of what is this zone of possible agreement. And that is what...
Sei rilassata che non c'è Martinelli che ti distrae. Se sei rilassata che non c'è...
And that is the whole game that we try to play when we talk about shaping perception. Now, on the market, and that is something that we just talked about as well, this is what you would see on a bazaar, right? You start extreme, then you make a last offer, then you make a very last offer, you threaten to walk away, then you threaten again, and then you may or may not come to an agreement. Now, obviously, we are lawyers, so we do a complete different game, right? We would never do bazaar trading in our negotiations. Really? Actually, I think what we see here is what happens in a lot of legal negotiations. Of course, we wouldn't do it the same way as on the bazaar, but I think you all have made last offers and threats to walk, and probably then made a last offer and possibly also a very last offer. So I think this structure is similar to what is underlying most legal negotiations as well. So we try to find common ground and shape perception of the other side. And I was traveling in Georgia and Armenia a few years back with a client, and I heard a very nice saying, which is, when he says 12, he means 10 and wants 8. So it will be worth 6. Thus, I want to give 4, and I will say 2. So from what you hear first from the other side, you start to deduct in your brain what the probable real value is and where you start your negotiation. Okay, taking this all together, what does it mean for our legal negotiations? Because we need to think about, okay, how do we improve our legal negotiations? Number one, don't give up on your demands too quickly or too easily. If the other side says it's not possible, you have to offer more, or you have to accept less, and you move right away and say, okay, then it shows your neediness far too much. So we should try to push back a little bit, hold out the pressure moment, of course, indicating that there is room for agreement. I don't want you to say this is take it or leave it, the best offer I can do, unless it is. Rather, show them there is room for agreement, but hold it out a bit, because a lot of people say make concessions far too quickly. Number two, use objective criteria to justify why you ask for something and to test the other side's demands. Ask them, why is it fair? What's the objective criteria you apply? Once we move our negotiation away from positions to objective criteria, it's much easier because we can talk about it in a neutral form. We don't have to talk about concrete numbers, and we can be creative when it comes to markups and markdowns. One of the most important strategies or tactics is to never concede unilaterally, but to swap. So if you have to make a concession, make sure that you get one in return. If you, then I. So that you always connect what you give up with something you get in return. Why? Well, number one, because it increases your outcome if you get something in return instead of just giving up. And number two, it shows the other side that, of course, it costs when you have, or if you have to change your position. So it also influences subconsciously their perception of what you should or could do. Equally important is to use your concession steps to shape their perception. So the timing, sequence, and size of your negotiation concessions influences the outcome. Let's make an example. If I want 100 for a one-day workshop, and the other side says, oh, it's too much, and I say, okay, 90. Then that was too quick, right? Because you probably think if you give me a 10% discount that easily, then I could get another 5% discount if I just push a little bit harder. So I have to hold out timing. Second, what is the size? If I give a 20% discount right away, it shows the other side, I probably get another 15 or 10 if I just push hard enough. So think about what is the right size of concession that you make. And then what is the sequence? If I give 10 and then 20, it sends the wrong signal, because my concession actually increases, even though it should decrease, and show that the air is getting thinner, and that by making less and less concessions, I get to the point where I actually have to walk away. So again, subconsciously, you influence the perception of the other side also by your concession steps. And then the last point, exploit value differences. So think about what can you or your client offer at low cost that generates high benefit for the other side. So is there anything where the two parties have different perceptions or valuations. And this afternoon, in the second part with Mike, you will be doing a negotiation simulation where this one actually is something that maybe it's worthwhile to think about. And then trade in packages. Make a package instead of negotiating clause by clause. Most lawyers, if you have 10 clauses that need to be negotiated, start with clause number 1, you finalize it, you go to clause number 2, you negotiate, you finalize it, clause number 3. The result is a sequential distributive bargaining, which means that you basically haggle about all the clauses with 2 extreme positions and then try to meet in the middle. And that is ineffective. Rather try to link clause 1 with clause 3 or whatever and have a package that plays with the valuation differences of both sides. So I hope that these ideas help you with regard to claiming the bigger slice of the pie, so to get the bigger piece of the pie for yourself or for your client. But there is another part, another side of the coin, and that is called value creation. Most of us think intuitively just about how I can get the biggest slice for myself. But the biggest slice gets even bigger if we can increase the pie. And therefore, the idea of value creation is probably the most powerful idea in negotiation, because we think about how can we increase the total value of our deal. So let's put that into a picture. Here you see on the axis the value of a deal to parties A and B. And let's assume they have a lot of different options what they could agree upon. Some of the outcomes are better for A, some of the outcomes are better for B. After a tough and long negotiation, the parties agree on this point here. And actually it seems to be fair because the value is similar, the value it means for A is similar to the value it means for B. Is it the best deal they could have gotten? No, because if we look at all the outcomes, the red dots indicate the Pareto optimal outcomes for both parties. So what are the best outcomes they could get in this negotiation, considering walkaways, alternatives, and stuff like that. So from our position, where the 2 lawyers agreed upon, they have missed this golden triangle. Every deal within the golden triangle would have been better than what the 2 agreed upon, at least for one party, but possibly for both parties. And your goal in your negotiations is to use this golden angle and to think about how can you move your deal northeast, how can you increase the value to both parties. For instance, just to give you an example, if I negotiate with the firm about the price for workshop, then of course we could haggle over the price, but I could also say, look, you pay me less, but in return, I can use your name and logo as reference, or you introduce me to other firms, or I get some free legal advice or whatever. So we start thinking about other ways of creating value. And an example that you might have heard is the orange example. Imagine 2 kids that fight over an orange. And they both argue a lot, say, I want the orange, I want the orange. And then at the end, they cut it in half. One of the kids takes half the orange, squeezes it, drinks the juice, and throws away the rest. The other kid takes off the peel, throws away the rest, and bakes a cake. And this is a typical example of where our positional bargaining, just haggling over I want X, leads to a suboptimal outcome, because had the kids asked, why do you want the orange? Kid number 1 would have said, I want the juice. Kid number 2 would have said, I want the peel. And the outcome would have been 100% better for both sides. And that is what I want you to do in your negotiations, to look behind positions. Don't just ask, what does the other side demand? What do they want? But ask, why do they want it? What is their goal? What is their motivation? What are their concerns? Understand what drives them and where do they want to get. Because often parties can use their common interests or opposing interests to create additional value. And the idea is to help each other achieve a better outcome by using the resources, capabilities, or preferences or valuations that we have, so to make the pie bigger. Now, you're lawyers and you're critical, and I appreciate that. And so you might say, this sounds great in theory, but in practice, it would never work. Let us imagine a conflict-loaded negotiation. Let's assume we have one of the biggest airlines in the United States that uses a new slogan, a marketing slogan. It's put on television, it's put on print media, and then comes up a small company from Texas and says, stop, you have stolen my slogan. This is my slogan. I've been using it for many years. Now, what is the natural thing to do for the parties if a big airline steals the marketing slogan of a small company? Right? You go to court, you sue them, you try to get damages. But these two companies, and it's a real case, actually did something different. I would like you to please switch off your screens, solve your legal conflicts by arm wrestling matches. But if you think this case through, they achieved free publicity, prime time across the US, marketing run by the TV stations for solving a dispute instead of paying $500,000 in legal fees, which is a reason why most lawyers don't like this example, but which for the companies was a great outcome in achieving a higher goal for both of them and by solving their dispute in a creative way. And what I want you to take away from this video is to be a bit more creative when it comes to overcome positional bargaining, looking behind positions and thinking about creative ways of helping each other achieving a higher value, a higher goal, rather than going to court. Unless you're a litigator and all your money comes from going to court, then maybe it's good to stick with the old way. Strategy number 3 is ensuring sustainability, because the best deal doesn't help you if it doesn't last. And therefore, I would like to use one slide to also talk about what is the soft side of negotiations, which has a huge impact on the hard facts. And the most important part probably is to really understand where the other party is coming from. What are their concerns? What do they want to achieve? What is their problem that you try to solve? Because only if I can look at the negotiation through the eyes of my opponent, I can come to an agreement that he can say yes to. Because you will not, in most cases, convince someone that your legal arguments are better than theirs. We've been trained many years to justify whatsoever position with some legal arguments. And I don't know how often you have received a brief by the other side giving you some legal argumentation. You said, yeah, they're right. We should definitely give in. I think it doesn't happen. At least it never happened in my own career. And therefore, it's much better to think about what is the underlying goal? What is the problem they want to solve? And then think about a way to solve that. Second, emotional impact. Emotions is something that most lawyers don't want to think about because, I mean, come on, we're lawyers, right? But emotions matter. It's not only the emotional part of fairness and whether the process and how you deal with people affects our likelihood to say yes, but it's also what sticks. Remember the last legal presentation you've listened to. How much of the legal content do you actually remember? I would assume not that much. Why? Because facts and figures is something we forgot very quickly. What we do remember is emotional moments, stories, pictures, metaphors, something where we had to do something ourselves. And the same thing applies for negotiations. So think about what are the messages, the emotional messages you can get across. Third, psychological techniques. It's very easy to make someone say yes just by exploiting influencing techniques and psychological bias. And we could talk about that for ages, at least a day or two. But maybe you just buy a book and start reading about it because it's really, really interesting to see how those psychological effects influence how people say yes and whether they say yes. And just picking out one, make sure that the other side believes that your outcome is the best possible outcome. Why? Because if people think they could have gotten more, they will probably try to renegotiate. And I had a very nice example in the first year when I moved out of big law and started my own company. I had no idea how much I should charge for a day of my service. So I thought, okay, let's test it with the best thing I can do, and that is negotiating. So I went into negotiation. 100 was my goal. I started with 115, and I said, well, if they negotiate me down, then at least I end up with what I wanted to get. And so the guy asked me, okay, how much is your day rate? And I said 115. He said 115. Mm-hmm. Okay, can do. How did I feel? I just made 15% profit and I felt really bad. Why? Because I probably could have gotten 125 or 130. And that is something that we often observe, and I've seen that at conference tables across the world, where afterwards the other side said something or did something that made, or that gave us second thought. We're like, wait, did that mean they could have paid more? And then you often see clients getting a little bit uneasy about the thought. And probably one of the most important tactics and strategies to use in negotiation, if you want to mark some of the slides red, and this is probably the point, is the reputational side. The outcome that you achieve, which hopefully is on your end of the scale so that you get a great outcome, must save their face. So they, the other side, has to sell your best outcome as their own win, at their own gain. Why? Because the lawyer of the other side needs to look good in front of their client's eyes. And therefore always think about how can you tell the story, how would you draft the press release to make them see the outcome as the best they could achieve and a great outcome. And if you do this homework, because they will not do it for you, if you do this homework, it often gives you the upper hand in a negotiation because you tell the story that they will tell their clients afterwards. All right, before we get to the practical side, are there any questions on these three strategies that you would like to raise right away? Okay, everyone's exhausted. Then now is the moment when you actually have to negotiate. And let me briefly explain the process to you, and then it's action time. So in a second, we will activate the virtual breakout rooms, and you will be put into virtual breakout rooms in groups of 2. The negotiation you're going to do is a one-on-one negotiation. One of you will represent a European law firm acting as international counsel in an international deal. And you will have to negotiate the fee of a local counsel in Mexico with a Mexican lawyer. So the other one of you two will be the Mexican lawyer. The process is the following. So in a second, there will be a pop-up window that asks you to confirm that you're moved into a breakout room with one other person from this group. Once in the breakout room, you will have to agree with each other who takes the Mexican role and who takes the EU role. It doesn't really matter who of you takes which role, just make sure that you know who is the Mexican and who is the European. Before you go into the rooms, we will share a PDF document that includes 2 links, one for the confidential information of the Mexican side and one for the EU side. Please only read the document that relates to the role that you're agreeing with your negotiation partner to play. So don't read the other side. It would spoil the exercise, it would spoil your own fun. So download the document that we will share, don't look at it, go into the breakout rooms, agree with your negotiation partner who is Mexican, who is European, then you open the link. Then you have 10 minutes to prepare, 10 minutes to negotiate, and then please come back to the main room and we will debrief the exercise and see what your outcomes are. Okay, any questions on that? So then we will now share the PDF document over the chat. Please download that document, but don't look at it yet. Then we will activate the breakout rooms. You will get a pop-up window. Please accept it, move into that room, wait for your negotiation partner, then discuss who is Mexican, who is EU. Once you've agreed, read your respective confidential information. Then you have 10 minutes to prepare, 10 minutes to negotiate. So please be back at 5 to 4 in the main room for the debrief. Good luck. May the best parties win. Okay, wow. I mean, I'm really surprised about the outcomes.
It's 400.
Gosh. Okay. Wow. Okay, at least one group that didn't agree. So interesting. Let me share with you what normally gets out of this exercise, and then some of you will party, I guess, given what you agreed upon. So the this is what basically happened in the case. We had the international lawyer who needed the Mexican local counsel. The client was really cost sensitive, so the European side would try to push as much as they could to get the fee down. The Mexican needed the case in order to reach their annual goals. The minimum the Mexican would have accepted was 240 US. The average market price was 400. And there was a little psychological trap in the case for the European, saying, get us the best rate possible, but at least 10% discount. Now, what usually happens in this case, and I've done it in Italy, both in Florence and Rome several times, and usually it worked well. Today, I'm surprised by how many of you got the Mexicans negotiated down so much, is that given that 400 is the average market price and there's the goal of reaching at least 10% discount, most groups end up with 350, 360 euro or dollars, sorry. And the reason for that is that you focus as European on the average market price, and then you try to negotiate the other side down, but your goal is that 10%. Now, I'd be interested in hearing how on earth did you agree on 230, 240, 250? How did you do that? Could the Europeans from those groups please share your success strategies with us? That's amazing.
Yes, I offered actually 250, but I think Simonetta didn't understand it. And she said, is 240 fine? I said, 240 is even better. So that's how I arrived at 240.
Okay,
I was a European lawyer.
Different roles?
Sorry?
Were you negotiating different roles?
No. I was from the European side, and I started at 200. I said, you know, I would like to pay 200.
Mm-hmm.
And then it was 350. She said 350. I said, no, 250. And then we ended up at 240.
Okay, wow, what a step.
Yeah.
What about the other teams?
Well, I have emphasized the possibility of obtaining new assignments from other European clients. And I pointed out that the Mexican market is going, as the other countries, is going through difficult times. So the Mexican local council reputed that my offer is a good deal.
Mm-hmm. Okay, so those of you who are Europeans and you agreed on more than 240, you missed the goal of getting the best rate possible. And as the chat shows, some of your colleagues actually managed to get there. Those Mexican of you who agreed on less than 360, you could have got more easily. And some of the outcomes prove that. So I think this exercise is actually for all of you some idea of where you stand in the negotiation arena. And it was very brief, very simple, very straightforward. I appreciate that. So just take it as a warming up exercise for Mike's simulation later today, which is a little bit more demanding. But here's what happened. There was a sentence by the client of the European side saying, get us the best deal possible, at least 10%. And most people focus on the 10% and end up with 350 to 360, thereby foregoing a lower rate, even though it was possible to get as low as 240. And for the Mexican side, you probably could have closed the deal at 400 as well, because that was the going market rate. And the Europeans really, really wanted to get a deal with you. The challenge we had here is how tough do you actually negotiate? Because both sides wanted to interact and deal with the other side. But of course, we are in this conflict of love versus money. Do we want to have a good atmosphere and working well together and close the deal, versus how do we optimize our outcome? And that requires that we can separate the way how we negotiate, like the tone, the friendliness, the personal interaction, from the substance, which is the question, what's the number that we end up with? And at the end, it doesn't really matter where you end up, because within the greenish area, every deal is better than the respective alternative. So I think all of you who got a deal, congratulations, you managed to have a interaction with each other and a deal that helps both parties, and who knows what comes in the future. But I think the exercise also shows you a bit where you could have gotten. I would like to add a few aspects on starting such a negotiation, because of course you probably had different approaches of how to get to your outcome. Both of you knew average market rate was 400, and then you had like individual confidential information. And I would like to share with you two studies on the question of who should go first. So should the European say the first number, or should the Mexican quote the first number? And that applies to basically all legal negotiations that we're doing. Who should go first? And one study, and there have been a lot of studies on that subject, and one study looked into professional real estate brokers. And they showed a group of real estate brokers a house. That house was for sale, and the real estate brokers received information about when the house was built, square meters, when it was renovated, what other houses sold for in the same street, in the same part of the city, how the prices developed over the last year. So all the information you need, and probably more than real estate brokers normally have. Then they put the real estate brokers into three groups, A, B, and C. And the three groups saw different suggested list prices for the house. One group was told the house sells for 119K, the next for 129K, and the third group was told 149K. And they were asked, what is the fair value of the house? Now, you know and I know that the fair value has nothing to do with a list price that you ask other people to pay for, but it's influenced only by the qualities of the house. But look at what the professional real estate brokers came up with. They got influenced, all other information being equal, by that anchor, by that number that is irrelevant for the outcome, but still drove them. In another study, they asked Americans on the street, what is the percentage of UN member states being African? And probably most people don't know how many UN member states are African. I assume all of you, of course, know. But before the people were allowed to answer, they had to play with the wheel of fortune, which was manipulated. It either showed the number 10 or the number 65. Now, you know and I know that these numbers have nothing at all to do with the number of UN member states being African. But look at the average responses. Those with the number 10 said on average 25% of UN member states are African. Those with the wheel of fortune showing 65 said on average 45% of UN member states are African. Now the right number is 72.8%, but all studies out there indicate that if you go with the first demand or first offer, it has a stronger impact on the outcome than anything that comes after. It's called the anchoring effect. And we should use that anchoring effect when we try to claim value by going in first and by trying to start as high as possible. In order to protect your reputation, think about a credible explanation that justifies the demand you go in with. That's basically the soccer photo I used earlier in our little exercise. So think about objective criteria that justifies your demand. Then go in as aggressive as possible, but still yet realistic. So the maximum plausible thing you can ask for. Why? Because you want to have as much space as possible to negotiate your way down or to be negotiated down. And the maximum plausible is basically the moment before you flash red. What is the maximum you can somehow justify by an objective criteria? And after you've named your request, your number or your demand, make sure that you shut up. The silence is really important for two reasons. Number one, it stresses that you are serious about what you ask for. Number two, it gives the other side room for what they have to do. The Hollywood game of saying, oh, it's too much or too little, or you can't be serious, it's out of the ballpark, blah, blah, blah. All that is typical negotiation behavior, which you need in order to shape perception, but don't take it too seriously, because the other side has to say, they have to push back, they have to say that what you ask for, what you offer is too little, just to increase their own negotiation power moving onwards. And then you are basically in the game, and then you try to come to an agreement. Okay, are there any questions with regard to what we have discussed or the exercise we have done? Anything you would like to bring up and share or discuss with the others that we haven't spoken about enough? That seems not to be the case. Then let me wrap it up by reminding you of the 3 strategies we've discussed. Number 1, influence perception. So think about what is the, what strategic messages do you want to send? How can you stop guessing about the power of the other side, because that might influence you negatively. Rather think about what do you want to send as a strategic message, verbally, non-verbally. How can you influence the other side's perception of what your alternatives are, what the potential zone of possible agreement is. And remember, a negotiation is not about truth, it's about perception, because we just, information asymmetry, cannot know what the other side really knows. Second, increase profitability. And that relates to 2 aspects: value creation, that is making the pie bigger, increasing the total net value of the deal, and value claiming. How do you get the biggest slice of the pie? How can you increase your own share in what you get from that outcome? And then number 3, ensure sustainability. How do you ensure that the deal will actually live on, that the other party is happy with the deal? And remember, it's about rational arguments, so the zone of possible agreement is about emotions, psychology, and reputation. How can you make them feel good with the outcome, write the winning speech for the other side, and let them save face in agreeing to your proposed outcome? Well, with that, there's nothing more than to say thank you very much for a very interactive session. It has been short, but a lot of fun to interact with you. Thank you for volunteering, Filippo, for the exercise and the photo. We will follow up with the bank details afterwards. I wish you good luck in Mike's part and simulation coming up after a little break. And for the rest of your online course, would be great to stay in touch and hopefully see you again once the pandemic is over, maybe even face-to-face somewhere in this world. Thank you all, and good luck with your further course.
Well, René, thank you very much.
Thank you, René.
Everyone here. I think we thoroughly enjoyed the interactive approach, very practical. Those of you who may not have studied or approached any courses on negotiation, this is not something you can pick up quickly. You need time. It takes years to learn how to negotiate. I can tell you, there's a lot of very scientific behind this. But so thank you, René, for this was fine both for those of us who have done negotiation, those who haven't. It was great fun, and definitely will look forward to inviting you another time to perform these rather creative and exciting sessions, separate sessions. So thank you again, and we now have 7 minutes interval before we have a coffee in 7 minutes. Okay, thank you, René, again. Thank you.
Thank you. Bye-bye.
This is welcome to the to this session. Thank you ever so much for making yourself available. I'm delighted that you are our trainer and presenter and speaker this afternoon. Michael McIlrath, we've known one another for quite some time now, especially through mediation, I guess. Michael is an executive of the Baker Hughes company, a GE, General Electric Group. And I think your position, if I'm still updated, is litigation counsel, global litigation counsel.
Well, actually, it's vice president of litigation.
Vice President of Litigation. So congratulations for that. Sounds very important to me.
Sounds.
It definitely
It's
is.
the same job I've always had. It's the title changes, but the job is always the same. Yeah.
Okay. Okay. Well, we have 38 people here out of 48 registered, so it's quite good, almost 100%. Mike, the floor is yours. Thank you. Thank you ever so much for being with us.
Thank you, Carlo. Well, thank you. Thank you, everybody, for being so patient and being around on a Friday night. Given that this is an international commercial business course, and we're also in the negotiation component here today. And with Renee, we coordinated in terms of the exercises. So I know you've already covered some key aspects of negotiation. As the head of litigation for an international company that faces very difficult situations very often, I also get asked all the time, what about this dispute resolution clause? What about this governing law clause that we have in a contract? And I deal a lot with the risk that dispute resolution clauses pose to the company, and also perceptions of risk. And so I thought that what we could do today is we'll throw you right into a very real type of situation that we deal with, which is where we have conflicting cultures in trying to agree on a contract. This is a problem. I'll spend a little bit of time on the sort of what's called theory background on dispute resolution clauses, but then shortly we'll have you actually engage with each other in negotiating a dispute resolution clause for a very important contract that's similar to the type of contracts that my company would do, because that just makes it easier for me, because it's the type of contracts that we tend to do. And this would be the sale of liquid natural gas equipment. The company in question here, the seller is an English company called Multicorp. They're a publicly traded multinational corporation present in over 100 countries around the world. And they're selling, or in negotiations to sell, some liquid natural gas equipment to a company that is state-owned by the government of Qatar. It's called Qatar Special LNG. And so you have these two different types of companies, a state-owned company and a multinational company involved in a very large international transaction. It's a commercial transaction. I mean, state companies, state-owned entities engage in commercial transactions all the time around the world. And so that's the problem that we're going to have you jump into shortly. And you're the perfect people to jump in. In fact, you'll see from the instructions you have, it's because you've taken this class that you're expected to know how to negotiate the dispute resolution clause. You will negotiate the way the parties will resolve their disputes. So before we get there, though, I think it'd be useful just to cover some of the key points, which I presume that probably most people here already have some familiarity with. And that is, the concepts that go into contract dispute resolution clauses, and in particular, arbitration, agreements to arbitrate. And fortunately for you, in the negotiations, you'll see between your respective clients that you'll be representing shortly, they've agreed not to use the courts for resolving their dispute. They've agreed to resolve disputes by arbitration. So you've already partway there in having agreed the concept. Now you have to agree the rest of the dispute resolution clause, and also what law will govern the contract of your clients. So let's talk a little bit about negotiating dispute resolution clauses. I have a personal annoyance, well, in English I would say is a pet peeve, something that has always bothered me when I see law firms and arbitration institutions offering seminars and courses in drafting dispute resolution clauses or drafting arbitration agreements. Because in my world, we don't have the luxury usually to just draft. The real challenge is negotiating. It's actually finding common ground on how we are going to resolve disputes if they ever arise. And so that's why I think it's important to look at this not as just a drafting exercise, but a negotiation exercise where we come at this from very different points of view. And if you're going to be involved in international commercial transactions, you're always going to deal with this. This comes up all the time. How are we going to resolve disputes? What are the methods? Governing law is a different aspect. I think this is something that most people will know, but I will just say it for the sake of clarity. The place of arbitration is what provides the procedural law. It's the law of the arbitration. It's not the substantive law for the contract. The law of the contract is what we would call the governing law, the choice of law. And so they're typically two different clauses, although sometimes you find them together, but they're conceptually different. We have the the way we resolve disputes, and then the law that's applicable to the contract, the substantive law, governing law of the contract. And that's an important, that's critical to establish how the contract will be interpreted, what certain parts of the contract will mean, whether certain parts of the contract will be valid or if the contract itself will be valid, keeping in mind that under the laws of almost every country of the world, an arbitration clause in a contract is considered a separate agreement. There's what's called the doctrine of separability, that these are separate, independently valid clauses. So you can actually have an arbitration over whether the contract is valid, but the arbitration is valid, but the contract is not. That's the doctrine of separability. So when we're negotiating dispute clauses, you need to think about, how's the contract going to be interpreted? What is the law that will be applied? Who's going to interpret the contract, judges or arbitrators? This is always a big issue in my business where disputes can be very, very technical. Judges can be very neutral. They can be actually very efficient. But if they don't understand technical issues, they're not going to be good for the contract. So you may want to have arbitration, and in this case, you will have arbitration, but that's one of the considerations. We always think about what are the risks, what are the objectives. One thing that my business, we're very active in the oil and gas industry. And so we often fight a lot over getting the right dispute resolution, thinking about how do we enforce our rights under the contract. And the reality is many of our contracts, we're never going to enforce them. We don't want them enforced against us. What do I mean by that? What I mean is, well, actually, a guy named Chuck Beach, who was my counterpart for many years at ExxonMobil. He was the head of dispute resolution, of litigation for Exxon. I once heard him say that the places in the world where God put the oil are not places where you want to appear in the courts. It's a very diplomatic way of talking about the problems of corruption and inefficiency of certain courts. So, we will often use arbitration. But when I say that, though, we're using arbitration because we don't want to have the other side use a process against us. It's unlikely in many cases that we may even actually enforce because certain countries, it's pointless. We know that we can't enforce against a government-owned entity in a country where they control the courts and they're not going to decide in our favor. So that's a different assessment of where do we come from when we're negotiating international contracts. And finally, one of the things, just getting to drafting, and I think this is important to keep in mind when you are negotiating, is what is the actual language that you will use. If you are agreeing to use, for example, the ICC rules of arbitration or the rules of arbitration of the International Chamber of Commerce, you should not try to be creative. You should go and look at the ICC website and look at their model clauses and use that as a model for your drafting. But you should also consider that while you're negotiating, because there may be terms in the model clause that you haven't thought of. You say, I agree to ICC arbitration, but what do you mean by that? There's the expedited rules. There's this, there are lots of different things. There's mediation under the ICC rules. There may be, the model clauses may actually give you, want to make you keep in mind certain things that you will want to negotiate. well, this is, I sort of mentioned this already. Let me go kind of quickly here. Governing law. When we talk about the governing law of the contract, you know, you are, again, this is a contract between an English company and a Qatari company. There's no reason you have to choose English law or Qatari law. You can choose any law. It's an international commercial contract. The disputes will be decided by arbitration. The arbitrators are capable of deciding under any law. You can choose Brazilian law if the parties wanted. If for some reason you thought Brazilian law was optimal, you could choose that. If you thought Italian law was optimal, you could choose Italian law. An interesting side point here, we talk about, you know, you have Qatar here that you'll be, half of you will be negotiating on behalf of Qatari. So I don't understand Qatari law. I don't either. But what is Qatari law? Well, Qatari law is based on, is derived from the United Arab Emirates, which I think is derived from Egyptian law. And although they speak English in Egypt, Egyptian law is derived from French law. So for the purposes of this exercise, again, this is not to qualify you as Qatari lawyers, but for the purpose of this exercise, you can kind of assume that Qatari law is going to be kind of similar to Italian law, or not too far from Italian or French law for the purposes of this exercise. But the governing law doesn't have to be the law of any of the parties. It could be anything that you should choose. And there's an interesting book actually that came out 2 years ago on choice of law by a case manager at the London Court of International Arbitration, Gustavo Moser. And it's a wonderful book where he goes through all of the empirical studies on choice of law in international commercial contracts. And Gustavo's finding is that lawyers typically do not choose the best law for the parties or the best law for the contract. Not surprisingly, most contracts have a choice of law that just is the same law as the lawyers, because the lawyers choose the law that they're most familiar with, right? Not because it's the best law for their client, but because it's the one that they know. And so anyway, I throw that out there that you may want to think about that maybe some other laws might be better than, I'm trained in New York and I rarely see contracts because I practice most of my activities outside of the United States that are under the law under which I qualified. So the governing law, I think, is very important when it comes to some of the key clauses of the contract and the language that you'll use in the contract. Things like whether you exclude direct, indirect, or consequential losses. These are very common in common law, in English, American, Canadian, Hong Kong, Singapore, Australia, Nigeria, systems of law. But under the civil law systems, I know Italian is a very good example. All damages are considered to be direct. There's no concept of indirect and consequential. All the damages that flow from a breach of a contract are direct damages. But the common law typically makes a distinction between direct, which are the actual things that are produced, like stuff that breaks and has to be repaired, as opposed to lost profits. That would be considered indirect or consequential loss. And so a typical common law clause might exclude consequential, whereas Italian, that would be meaningless. And so you have to address these differently. The important thing being here that the law that you choose will have an impact on other parts of the contract and how it will be drafted. I won't spend any real time here about dispute resolution because you've already got clients who have agreed to use arbitration. Arbitration, I'm sure, or I hope that everybody is at least somewhat familiar with the process of at least arbitration and international arbitration. It is a consensual process in the sense that you agree to participate in arbitration. To be a valid agreement to arbitrate, you must exclude the jurisdiction of the courts. You do that by saying any disputes arising under this agreement shall be referred to arbitration. Arbitration agreements don't need to, but they really, really should include a place of arbitration because, as I said, that provides your procedural law. That means if there's a challenge to the validity of the arbitration process or a challenge to the validity of the award that the arbitrators render, it's the courts at the seat. So the seat of arbitration is your procedural law. very important for an international company like mine that we in our contracts, we have what we call a safe seat, meaning it is a seat where the courts are friendly to arbitration and they are reasonably efficient, and that they are not corrupt. They're independent. So London is very well known as a seat, as is Paris, as is Singapore, as is Frankfurt, as is Stockholm, as is Geneva. Milan is kind of a medium, not that well recognized, not because of corruption or lack of competency, but more as just the efficiency. It takes so many years, it takes so long to challenge or to get things done in the Italian courts that it's just not an internationally favored jurisdiction. It is what it is. I mean, I don't think anybody looks to Italy as being one of the leading jurisdictions, which is a shame, because people like to come to, when you can travel, people like to come here, but they don't typically put their arbitration agreements here. For those of you who, but mediation, of course, doesn't require the assistance of the courts, and so you shouldn't worry about if you want to have mediation in Italy. There's certainly no downside to the delays that one experiences with the courts. Finally, institutional versus ad hoc arbitration. This is whether you specify an organization to administer the arbitration, that is to help you appoint the arbitrators, to pay the arbitrators, to notify a request for arbitration, to regulate the exchanges between the parties, and in some cases like the ICC, to also provide a certain degree of quality control on the final award. They call that scrutiny of awards at the ICC. Ad hoc arbitration means that there is no institution that does any of that. Paying the arbitrators is something that you agree between the parties and the arbitrators. You have to notify according to legal process. That means often finding a bailiff in the other jurisdiction, following appropriate channels of legal process, as opposed to simply sending the entire request to the institution and letting the institution handle it. So it's much more demanding on the parties. It can be difficult to negotiate with the arbitrators how much you're going to pay them, how you're going to pay them, and when they're going to pay them. Those are things that institutions take care of. And you might say, well, given all that work, why would I ever do ad hoc arbitration? And the answer is, I think that's actually a good question. I think institutional arbitration usually pays for itself. But some people think that ad hoc arbitration is cheaper because you're not paying for an institution to run things, and you don't see the institutional fee schedule. I'm going to assume that you've already covered mediation or at some point in this course, because Carlo's here, but if not, I'll say just one word or two about it.
That's going to be Laura Ristoria and Professor Lucarelli will cover that tomorrow morning.
Right. I will simply say that, particularly in contracts like the one that you will negotiate, where there is the probability of a long-term relationship, and mediation, it's commonly used in big infrastructure industries and large contract situations. And also because of this new international convention, one of the advantages of arbitration for the last 50 years has been the New York Convention, which is also known as the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which has the tremendous advantage that an arbitration award, once rendered, can be enforced against the assets of a respondent party in an arbitration anywhere in the world where they have assets, and it is treated as a judgment of the court of first instance in the courts of wherever you are trying to enforce. And that's over 100 and some countries around the world that have signed the New York Convention. There is a new convention called the Singapore Convention for Mediation, which if you reach a settlement agreement in mediation, you also get the effect of a court judgment as you go. And the countries are only now beginning to sign on to this, but I think we'll see this will also propel greater use of mediation, but there's certainly no downside to including it. So with that, I would say background to your negotiation. Emanuele, I think I'm going to ask you to help take me away,
Yes.
take us away. into the negotiations, where I think we're destined to end at 6:30. I don't want to run up against the clock. So what I would suggest is that everybody be given about 45 minutes to read the materials and to negotiate, all inclusive. Okay. It's not a very big project. What you will see is that you'll download the materials for each side. Each side is given points by their management for negotiating key provisions of the dispute resolution and governing law. So each side is coming at the contract with a different legal background, different expectations, different risk understandings, and your management is telling you, I would like you to get, I don't know, ICC arbitration in Paris or in Qatar or wherever, and you will be given points based on how many of those provisions you can achieve. I've suggested that you write the clause afterwards. I don't think we have enough time. So it says step 2, skip step 2. Let's just get to step 1, and then we'll get back in the room at, Carlo, I would say at 5:45, which gives us plenty of time to discuss the results of the negotiation. How does that sound?
Yeah, sounds fine.
Any questions? I know I went kind of fast. I'm here, but I'm just going to catch up on things. Veruska.
I think she has some trouble with the connection.
Okay. But here would be the question is that, 6 months can be from the filing of a request for arbitration to the issuance of award. That's a very short 6 months. Or it could be, say, if your ICC rules, now we would have to look at the rules to look at the dates. It might be from what's called the commencement. I think that's Rule 2 or Rule 4 of the ICC rules. But you would say when the arbitration commences, it could be from the notification of the request for arbitration, or it could be from the constitution of the arbitral tribunal, or it could be from the signing of the terms of reference. I mean, I'm referring to the ICC rules as what you could have as objective dates. So it could be for the terms of reference until the issuance of the final award. But here's the problem. If you look at the ICC rules, I don't know if Andrea Carlavaris mentioned this, ICC applies scrutiny to their award. So once the arbitrator renders the award, it goes to the court of arbitration, maybe another month or 2 months, right? So if you say the final award, it's still a much longer time period, but what happens if you get to the end of the 6 months and the court has not published your award? Is the arbitration now invalid? I don't know. Wait, you're on mute, I think.
Well, I think that the arbitration is invalid because it's a different agreement. Otherwise, the contract will remain valid. So probably the negotiation clause will be not enforced in this event, and the law for the Italian, for example, for the Italian jurisdiction won't be applicable.
Right. It certainly could be a problem that this is one of the things that when I teach this class elsewhere, I say when you're negotiating, this was not part of your exercise, but since we're waiting for other people, why not make the point? But when you were negotiating these things, I think it's really good to have in mind how you will write the concepts, because here actually you're leaving out of you're saying 6 months, but you're actually really not agreeing the key points, which is when does the 6 months start? When does the 6 months end? Let me pick on somebody else. I mean, let's see, Federico, who just joined. So I'll grab Federico. Who are you, Qatar or Multicorp?
Multicorp.
And did you agree to go through mediation?
Yes.
Okay.
I agree. It's on arbitration.
But you had a required step of mediation, correct?
Yes.
Okay. How does that work, this required step?
The step was quite easy because Qatar is an Arabic state, so in my opinion,
no, I mean, procedurally, I mean, sequentially, if you're going to mediate before you arbitrate, how are you going to sequence that?
We sequence starting from place of mediation. Where do place of arbitration?
But I mean, timing wise, here's my question.
Yes.
You're multi-corp, right?
Yes.
I'm Qatar and I want to sue you.
Yes.
So I start an arbitration. I file a request. What rules did you agree to?
Rules to ad hoc.
Ad hoc. Okay. So I say under ad hoc rule, I send you a notice of arbitration immediately, and you say, "Well, whoa, wait a minute. You agreed to mediation first."
Yes.
You didn't fulfill that, and I say, "I don't think mediation is required." And you say, "But it was in the contract." And I say, "Okay, let's." So we begin to mediate. But what happens if the can I stop? So even if we begin the mediation, can I say, wait a minute, you can't start the arbitration. We're still in mediation.
Yes, we start to understand for mediation to see the prices, but we start to make the clause. We made in a different way. We start to put down the clause for the arbitration. So to study the place, the law, the number of arbiters, the time limit, language, and so on. We don't start from mediation, right. And then because we understood that we need to draft also put the basis to draft the clause for the arbitration.
Right. Right. No, I agree. I was just pointing out this was not part of your negotiation. But I was saying that when you negotiate these types of agreements, it's very helpful to keep in mind how you will write the actual clause. So one of the problems that you will find, for example, I think a mediation requirement is great, but when does the mediation start? When does the mediation end? What are the rules of the mediation? These were not part of the exercise, but you might say, the mediation shall, from the notice of mediation, and then say 60, if the parties do not settle in 60 days, because otherwise you have a risk of creating a jurisdictional impediment. I actually have a case right now, about a $20 million case in the United States, where the parties agreed to engage in executive level negotiations before arbitration, not mediation, executive level negotiations. And the other side is saying they're asking the arbitrators to suspend the arbitration for, I think it was like 3 months, so we can engage in the executive level negotiations. We said, we did engage. They said, but not enough. Because why? Well, because that criteria is very subjective. And so again, when you're negotiating a dispute resolution clause, one of the things, if you write it out and you think like a lawyer, right? You think, well, how will this work? If we start a mediation, if it then goes to arbitration, what are the steps that we have to follow, with as much as possible objective reference points, not subjective, but if, for example, the ICC rules would say, arbitration might be a request for arbitration being notified, would be an objective event. Or in your case, ad hoc, with no mediation rules and no arbitration rules, you would say from the notice of mediation or from the request of mediation. And then, Willie, do we want to bring people violently out of their rooms and back into the main room?
Yes, of course. So they have
a little violence, a little virtual violence on a Friday night.
So in less than 60 seconds, they should be back in.
Okay. No, but I think, I guess I say the moral of my story, or of my point here, is that the drafting, the writing, the actual writing part, to have that already in your pocket, have that done as you are negotiating, can be helpful. I'll make that point again as I see people popping up all over the screen. I love these formats are really cool. This virtual meetings. see 23 people back in. Absolutely, yes.
Thank you so much. Don't you think that as a lawyer of the company from Qatar, it would be very difficult to close the contract because I think we couldn't reach the points that they need. 12 points is very difficult.
Did you close?
Yeah, because I think that possible result could be a place of the arbitration in Dubai with the International London Court of Dubai, English law, and I lost the test, but I reached 2, 4, 6, 7 points.
Great.
Yeah, and so
I think we have a lot of people, so I have a few examples we'll do, and Stefan, I may ask you to give yours as an example here. But before we actually get to the results, one thing that I was saying to others before people were joining, for some people who had come back into the room a little early, is that as you are negotiating a dispute resolution clause, this wasn't in your assignment, but it's part of what I do. I teach a class in legal writing at Bocconi, and I teach this also in some other places. And that is, as you are negotiating, it is useful to already have the language, the wording that you would like to use. For example, probably most of you agreed to a 6-month limitation because both sides got points for that. So why wouldn't you, right?
Yeah.
So, but the question really, so that's an easy thing to agree. It's not an easy thing to implement because when does the 6 months start? If you agree, for example, to the ICC rules of arbitration, well, you read the rules, there are lots of potential reference points. There is the notification of the request for arbitration. That could be one time of when the 6 months starts. It could be when the tribunal is constituted. That could be another point. It could be when the terms of reference are assigned. It could be when the hearing is held to the rendering of the award. That could be, you could wait till the hearing to start the clock running. So there are lots of different places where your clock can start. There are a lot of places where your clock can end too, the 6 months. It could be the hearing, 6 months from the request for arbitration to the hearing, the terms of reference to the hearing. It could be until the issuance of the final award. But with the ICC rules, you have a problem in that the ICC applies what they call scrutiny, so that, which means, and actually it's a very valuable procedure, but that's where you've got very experienced arbitrators who look at the award, and if they see defects or problems, they send it back to the arbitrator, and the ICC almost always has comments that for arbitrators to improve. Then that's outside of the arbitrator's control. That may be add a month to, if the arbitrator has done a bad job, you might, the hearing may end in March, but you might not get you might get your award in April. Or if the arbitrator didn't do a good job, you might get your award in July because it has to go back and forth and be rewritten. So now you have a problem, which is that if the award is rendered beyond the term of 6 months that you agreed, as you've defined it, is the award invalid? So have you agreed to something that can potentially invalidate your arbitration agreement? My point here, again, this was not part of your negotiation exercise. We'll talk about other things, but I do think if you're engaged in international contract negotiations, it's very useful to think in advance when you have the term of how you're going to express this in language. So it's not just a question of agreeing to 6 months. It's like, when does the 6 months start? When does it finish? And maybe it's not a bad idea to give the arbitrators the authority to extend their own term, or to give the institution the authority to extend the term. Or another way you can achieve the 6 months, if you're, again, this is just with reference to the ICC rules, is you could look and say, do they have expedited rules of arbitration? Oh, they do. How long are the expedited rules? 6 months. Okay, so instead of saying 6 months, I will propose that we agree ICC rules of expedited arbitration. And that's another way that you can achieve your goal, but it requires you to do some thinking up front. Again, not something that was for you today, just something I think it's useful when you find yourself in these negotiations. So before we get to your results, let me tell you one thing that, you know, if you've had a chance to share things, but there is a negotiation concept here, which is a positive and negative zones of negotiation. A positive zone of negotiation means that you're in a range where a deal can be reached. So, you know, buyer wants to buy at 10 and the seller wants to sell at least 5. That's a positive zone because you're gonna close between 5 and 10, right? That's what's called a positive zone of negotiation. A negative zone of negotiation is where you can't reach a deal. It means buyer wants to sell at a minimum of 10 and the buyer wants to buy at a maximum of 5 and the seller wants to sell at a minimum of 10. Well, you're 5 apart. There's no way. That's a negative zone of negotiation. There's no overlap. So this negotiation, and I don't know, Stefano, you were Qatar. Let's ask you, what was your maximum price under which you would sell, in which you would purchase the equipment? How much is your client willing to pay here for this equipment? Do you remember? You're on mute.
Yeah.
I can't hear you. You're on mute. Stefan, you're on mute.
250,000, I think.
250 or 270?
250.
250, okay.
Yeah.
And so 250 is one extreme. 250 is your max. I think it might have been 250 or 270, but anyway, it's a lot of money. Let's put this, $1 million, right?
Yeah.
Multicorp, let me ask, I think Federico, I was talking to you, you're Multicorp. How much were you, what was the lowest price that your client was willing to accept for this equipment?
230.
No, what's the lowest? Now, come on.
The lowest for me, the lowest for her, 220.
No.
No? For me?
Yeah, for Multicorp, I think the lowest you
for Multicorp, 180.
180.
Not less than 180. Yes.
Not less than 180, right?
Not less than 180.
I think 270 was, somebody correct me, I think 270 was the maximum number for, I wrote this.
For Qatar, yeah.
I don't always remember. So you have a range here of $90 million from 180 to 270. That is a super positive zone. That's the zone where you're, I mean, what is the legal term for not doing a deal here is effing crazy. That's a juridical term. Effing crazy is probably, it's Anglo-Saxon, so forgive me, but $90 million, that's a deal that the parties really should do, right? Plenty of room. On top of that, you also have the opportunity to adjust price, right? So Multicorp, you can, to get better terms, how much can you spend? How much can you increase? Federico, you remember?
From 180 to 230.
I think you had $5 million that you could spend.
No,
right?
5 million. Yeah, sure. Sorry. Let me see.
You could even go lower than 180 down to 175
yes.
if you could get better terms. You had $5 million to spend. And Stefano,
yes.
how much did you have to spend?
$5 million.
Sorry?
How much money did you have to spend? You could have spent money to get more.
I think 220.
No, but you had $7 million. So Qatar had also $7 million. So actually, you could go all the way up to 277, and you're still fine if you get a very good contract. But here's the thing about spending money, and this is, I think, a very important principle for international lawyers, is that you are either this is flexibility and inflexibility, or risk versus perceptions of risk. And that is, if you are a shareholder of Multicorp, again, we have $5 million of your own money and $7 million of Qatar's money. That's $12 million right there. If you're a shareholder of Multicorp, would you rather have arbitration in London under ICC rules, which is what you say you want? Or for $12 million, will you accept arbitration in Qatar under ad hoc rules, which is what Qatar wants? I mean, maybe you want a better contract and it's worth the 12 million, but maybe as a shareholder, you also want that money. And so one of the things I think to develop as an international lawyer, and this is, you know, if you can tell your client, look, I took this course at UIA. Carlo Mastaloni was one of the professors, one of the teachers in the course. You know what? I think if you have an arbitration here and it's in Qatar, I can represent you. We can manage that. I think you are better accepting the $12 million because I don't think this is a serious risk. I mean, I think it's more risky, but it's a risk that you can accept for $12 million. And I think that's one of the things that you as lawyers can really bring as value to your clients when you find yourselves involved in these negotiations, which is, look, it's in Singapore. They've got arbitration there. The courts are fine. I think that we can handle that. It's not really risky. If you can get more money that way, let the other side's inflexibility pay for you, unless your client wants the certainty, in which case maybe you pay more money for certainty. Either way, it's win-win because you're giving your client what they want, right? The point is you need to be able to articulate that to your client, how you are adding value as the lawyer. And it's not just value in terms of I'm doing a better contract. I'm making a contract that's either, from our perspective, less risky, or I'm helping you with a contract that is bringing in more money. So that's just, I think these are some general concepts about negotiating the dispute resolution clauses. And I've actually seen this in reality sometimes where the other side is being totally inflexible because they're a government-owned entity. They can't change anything. And so you say, okay, I'll take this, but give me something else somewhere else in the contract. Maybe if it's not money, it might be give me delivery terms. Give me a reduction in the amount of, say, the penalties that might be applied. You might find other ways of concessions, of making that inflexibility in the negotiation pay for you. And again, risk is risk, but often perception of risk is not real risk. And the more that you do these things, the more that you, for example, are engaged in international dispute negotiations. I mean, one thing is for those of you who negotiated and included a mediation requirement, you'd say, look at this contract. We're both big companies, massive plant. We're going to be working together for the next 30, 40 years for this project. If we have a dispute, we're going to have a mediation. These are such an important client. We're never going to go to arbitration with them. You know, if worst case, we go to mediation and we find a resolution. So the mediation is even a way for you to accept more risk for your client. Anyway, those are, and that's also something to think about as well. And that is it's not just who are your clients in this, but what is the relationship and the contract that you have. So with that said, we've had a discussion already a little bit about what are the different contracts. Let's talk a little bit about not your negotiations, but let's say the client objectives, the client values. And I'm going to pick at somebody at random. Let me go with Anamike. I'm just picking you.
I have to unmute, yes.
Okay.
Yes.
Are you Multicorp or are you Qatar?
I am Qatar.
Okay. So let's talk a bit about two things that you were getting points for, which is governing law and place of arbitration. What is the most points that you could get for governing law?
The most points was Qatari law.
Yes.
It was 8 points, and we concluded that Qatari law was going to be applied. And then the place of arbitration, Doha was 3 points, Dubai or London, both 2 points. So we went for London.
So we could, if we look at this and we try to understand your client here, it would be, to me, clear that the client places a much higher value on governing law and having their governing law than they do on the place of arbitration, right? 8 points maximum for governing law. That's super important for them.
Yes.
Place of arbitration is important, but not nearly as important. Who is your counterparty?
Filippo.
Where's
Parisi?
Filippo?
I'm here.
Filippo, how many points did you get for governing law? Maximum.
The maximum point is a 2 point. The choice between English, Swiss, or New York law.
Okay. And maximum points for place of arbitration?
6 point London or Geneva.
Okay. And so now we have I think we have an opposite situation here, whereas the counterparty is super married to having Qatari law. You're like, English law, Swiss law, whatever, 2 points. But place of arbitration is so important. Why do you think that your client places such a high value on place of arbitration?
Well, I was acting for this British oil and gas company. Yeah. In my personal knowledge, always the company in oil and gas, they prefer to refer in the arbitration accordingly the SEC rules in London. This is the best option, or Geneva. They have no doubt about, they have no problem to choose also the Qatari law, because as you said before, Qatari law is mixed also with the French commercial law. So there is no big issue to manage
but your opposing side is like super, for them governing law is so important, but for you it's only 2 points. My question is, why do you think for a multinational like Multicorp, place of arbitration is so important?
Because the problem for them is that they already knows the procedure in London. They knows exactly which are the rules. They know exactly how much is the time for the arbitration and eventually for challenge.
Okay,
so they have no.
Who is your client? But your client here is a multinational, right?
Yeah.
And whereas Annemieke, how do you pronounce the name?
Annemieke.
So Annemieke, your client instead is, what type of company is it?
My client is a state-owned, wholly owned by the state of Qatar. So it's a state company.
And so why do you think for them governing law is so important?
No, I think that is practically any state company will do that. It is your own state, so you want to apply your own law.
Yeah.
Without even looking at the contents. It's more a sign of nationalism almost.
Could be,
most state companies all over the world will apply their own state law. Even though sometimes it might be more convenient to choose another state law without even considering another state law.
Right. I mean, they may have procedures where they can agree in a commercial contract to foreign laws, but it may be more difficult for them to get approval.
Yeah, yeah. Yeah.
They're a state company, it's a public company, whereas,
Yes.
but then why do you think that they don't put such a high value on, not as equally high on place of arbitration?
Maybe London is convenient for them as well to have a good, neutral, non-corrupt arbitration. Place of arbitration might be convenient. If they do it in-house, they might have local issues, political issues.
Okay.
Yeah. So that could be.
Or it could be difficult, or it could be that they just realize that it's impractical to insist on people coming to Doha. Maybe people, their courts are not recognized for arbitration.
No. Yeah. So they're like, well,
reflect just the reality. Yeah, exactly.
Yeah.
My objection,
Multicorp,
for example, my objection when Annemieke asked me to place the arbitration in Doha was that in Doha we don't have enough feedback about the capacity of arbitration court in Doha to manage the particular some specific technical issues related to these equipments. So that's why I insist to place the arbitration in London, because my company already knows, has background and feedback about the capacity of London Arbitration Court.
But you got 6 points for London or where else?
And or Geneva.
Right. So it's not like you're not looking for a home court advantage, right? You're looking for a place that has a reputation for courts.
Yeah.
Right.
Capacity to manage properly the arbitration, and the capacity for the arbitrators to understand the technical issues, because most of the time these kinds of arbitration are related to non-performance of the equipments. This is the biggest issue.
Well, but you can have the same arbitrators in Qatar as you have the same arbitrators in Geneva or London. You know, you can point, that's up to the parties to a point. But I think you make a good point here, which is that you want to have a court, right? Again, I know that you guys had Andrea Carlavaris and others this morning. The place of arbitration is the legal framework. It's the validity of the arbitration. So if you're a multinational like us, like my company or Multicorp, you want to make sure that the dispute resolution process, whatever it is, will not be subject to an unfair challenge, that there are courts, that they're reasonably efficient, they're independent, right? So it's not that London's a home court advantage, maybe it is, but it's that it's a place with a reputation for international arbitration, as is Geneva. Milan would be okay, as I said earlier, Milan, it could be okay, but you know, the courts are not, you're going to take years if you have a challenge or a problem there. Let's move to another issue. Let me by the way, as to governing law, I would say for Multicorp, it's not that governing law is unimportant. I think Filippo, you touched on this. Multicorp is an international company. They're present all over the world, right? What law does Multicorp not accept? Whereas, and Amicus points out, her company, her client is a state-owned company. They don't have a lot of flexibility. They don't do contracts all over the world. But Filippo, your client does. So it's not that they don't, they will value governing law, but they'll say English law, that's fine. But I could also take French law. I can take other laws because I have lawyers. We have lawyers all over the world. They can help us with that. So,
but the state-owned company always try to impose their own governing law.
Their own law, yeah.
Well, they may have reasons for being inflexible. Yeah. You will be more inflexible on place of arbitration, and more flexible when it comes to on governing law. Something to, at least in this case, to think about. Let me move on to something else. Rules of arbitration, and let me pick on a couple of people now. I'll go to Mariangela and Marco because you have the misfortune of having your video on. So bam, on you. Who were you representing, both of you?
I represented the Qatar company.
Okay, and Marco, who did you represent? Marco Zanini.
I represented the seller.
The Multicorp. So we have a Multicorp and we have a Qatar. Very good. So why don't you guys, so tell me about the rules.
I obtained the law of Qatar. So I have to give some other conception.
Yes, concessions.
And so we agreed that the ICC rules.
Okay, so you went to ICC rules. Okay.
We drafted the clause with the ICC draft clause.
And you're Qatar. What's the most points you get for the rules? What is the most points?
For the rules is for the UNCITRAL,
okay.
But they didn't accept. So I pushed to obtain the law, and that got 8 points. So the UNCITRAL rules were 4, and the ICC rules were 2, maybe, or 3, 2 or 3. I don't remember exactly because I didn't print. My colleagues print the result.
That's fine. And let me ask, and Marco, what was the maximum you could get for?
I've obtained ICC rules for 4 points.
So you have so your maximum is 4 points for ICC. How many points for ad hoc? For ad hoc or UNCITRAL?
UNCITRAL.
4.
No, but for
Multicorp. 1 point. Only 1 point.
Only 1 point. Okay. So that's so from what we have a difference of there's something going on here where Multicorp values institutional arbitration, 4 points, and they'll accept ad hoc, but they don't value it very much. whereas Qatar values uncitral ad hoc, and they value institutional lower. Again, I think Anamike made a good point about Qatar being a state-owned entity, but do you think that there might be something here about why there's this difference in why Qatar would be pushing for ad hoc uncitral arbitration and Multicorp wants institutional?
I think it's there is more equilibration when at the end of the contract with ICC rules, English language, and we utilize the English law. But the location of the arbitration is Singapore.
Right, but I'm just saying, but why you're Multicorp and you get 4 points for institutional arbitration, yes, only 1 for uncitral, so you want administered, you want your client wants institutional arbitration, but you're negotiating with someone who doesn't want institutional, they prefer uncitral ad hoc. And so one thing to think about here is that maybe that what's happening with Qatar, because Qatar's a state-owned entity.
I don't know.
Maria Angela, any ideas?
I didn't understand, sorry.
So you have different clients here, right? And so they're asking for different things, but they come from different backgrounds. They come from different legal and corporate backgrounds. Mm-hmm. So maybe the reason that your client is insisting on uncitral, or not insisting, but has a strong preference for uncitral, for ad hoc, is because they don't want to pay for an institution.
Okay.
Right? They would say, I'm a public company. I don't want to pay money to an institution. I would rather just pay for the arbitration itself. Whereas Marco is representing a company that says, look, I'm involved in cases all around the world. I'd much rather have an arbitration institution, pay the arbitrators, manage the process and administer things. And so there might be a higher level of sophistication that comes to how do you approach the process. So that's also something to consider. And I would just think that, Marco is more likely to be a repeat player in arbitration. And he knows that institutions keep proceedings going and they keep costs down. Your client may see that, well, no, if I have to pay somebody to administer, I'm paying more money. So you have different perceptions in the negotiation. Let's talk.
I didn't catch it. I didn't understand why uncitral and not ICC.
Well, because ICC you have to pay, because uncitral you don't pay for the institution, right?
But I got a good discount. I obtained $200,000 million, so 17. So it was quite good. We can pay for uncitral.
No, but the bad news is you got such a good deal that you're going to go work in Qatar for the next 40 years. You're hired and you're going to Qatar. At least you're going to have to be there for the entire 30 years that these equipment are in operation. All right, Maria Angela? So pack your bags. Good. That's very good. Good job. Let's move on to another subject that was negotiated, which is the mediation requirement. And let me I'll pick on Elisa. Elisa, who are you representing? Elisa Zime. You're on mute.
I am a buyer, Qatar.
Yep.
Qatar. And we agreed about mediation before the arbitration.
Okay.
0.
How many points do you get?
0.
Oh, why?
Probably it's neutral.
But why do you think your client says, all this discussion, why is your client giving you no, says no, they don't penalize you, but why 0?
Probably 0 for the Qatar because it isn't convenient for a big part to be obliged to have a mediation before the proceeding?
Well, that would be a negative. If that were true, they would say -2 points, but they say 0.
Zero, neutral.
So maybe, yeah, neutral. I think maybe you're right. Maybe because they don't know mediation. Let me ask someone who is representing Multicorp. Somebody from Multicorp who got a mediation. Let's see a hand up with Stulakova.
Yes. Yes, I was for a seller.
Yep.
For a London-based Multicorp, and we had to discuss different points.
Yep.
But you want to talk about mediation.
Yeah. Why? How many points do you get for mediation?
3.
3. And why do you think that that Multicorp, for a contract like this, values mediation? Says, well, you know, I think it's important, 3 points to put this in, but Qatar 0, they're neutral.
To be honest, this is not very important for me, because I wonder what should happen if some emergency decision should be needed. No. So the mediation for me is not so important.
Okay, but for your client it is. Your client gives you 3 points.
That's why I decided to negotiate the mediation before arbitration, and that's why we decided to choose the obligation of the mediation.
But I guess the one question is, if we look at Multicorp and they say they want mediation, and Qatar doesn't want, or they don't not want it, they're just neutral. And you might want to consider why a multinational would say, well, wait a minute, I have if we think about the contract here, this is a contract that will be maybe $200 million, very big contract, for lots of equipment. Probably this equipment will be in operation for 30 or 40 years. That's why we already said Maria Angela is going to have to go to Doha because she did such a good job. She will have to be there to make sure that the equipment is performing under warranty and everything, right, Maria Angela? So you're still here? I thought you were leaving for the airport. But the time period for the contract is one where there will be a very long relationship. And so maybe, I'm just thinking, maybe Multicorp says, in case there's a dispute, yet after 2 years, I'm going to have a real problem if I go to arbitration in the 2nd year of the contract, and I have to be here with this equipment for the next 30, 40 years. Because you sell the equipment for 200 million, but think about this. You can provide spare parts, you can provide services. That 200 million, I mean, for a company, again, a company like mine or others, that could be 700 million or $1 billion in future work that you may be able to have from that relationship. So again, thinking about, you know, arbitration is a good way of resolving disputes, but it may also be a way to destroy the value of the relationship. And so mediation might be also a way for you to reduce the risk of the impact to the relationship in terms of valuing everything, right? So that may be why Multicorp says, you know, for me, it's, you know, it's important. It's 3 points. I mean, I consider it a significant thing to include.
I have 18 points in at all.
Yeah. 3. I mean, you know, they're not going to walk away from the deal if they don't get it, but they think it's enough to try to put in. Let me ask Barbara. Very quickly, did you agree on language of the arbitration? Who are you? You were Qatar, right?
Yeah, I was Qatar. Yeah. Well, yeah, we agreed and we decided not to, I decided to give up with the Arabic interpretation choosing the Arabic language as the language of the arbitration. Because I exchanged that with the number of arbitrators. That was more important for me.
Okay. And who is your multi-corp opposing party?
My opposing party was can't find.
Nicolò.
I am.
And
yeah, I am.
So what? And so you were silent on the language of the arbitration. Oh well. But Nicolò, what does that mean for you if you're silent?
That English will be the language.
But how many points do you get?
2 points.
2 points. So multi-port. So Barbara, he got 2 points from silence because there's an informal rule that the language of the arbitration will be the language of the contract. It's not official. It's not written in the arbitration rules. So by being silent, he got points. It was favorable. That was favorable to his side anyway. And to be frank here, probably not a good idea to put the arbitration in Arabic. Why? Well, because I think Stefano pointed out earlier, this type of, or someone else, that this is likely to be a very fact-intensive dispute. If there ever is a dispute, there will be lots of documents, technical matters. Probably most of those will be in English.
You think for that?
And also arbitrators. You'll need arbitrators who speak Arabic. There are some very good arbitrators who speak Arabic, but you limit the number of people by putting in a language requirement. My friend Tom Sikora, who's the current International Arbitration Counsel at ExxonMobil, talks about a case he had some years ago where the arbitration clause not only had a requirement for the arbitration to be conducted in the Hungarian language, but the chair of the arbitral tribunal could not be a Hungarian national. And he said, I searched the world for somebody who was not a Hungarian national, but spoke Hungarian and was actually a good lawyer and somebody who could understand a complex project. So it's one of these things where you have to be careful what you ask for in your arbitration agreement.
And also, I thought also that it has nothing to see with all the consideration that we made in relation to the present case, but also choosing. I was thinking that also choosing the Arabic language, it could have been a little bit risky, since there are lots of differences even in the same Arabic language.
Yeah.
Because I studied a little bit of Arabic, and the Arabic language that is spoken in Qatar is different from the one that could be maybe be spoken in another Arabic country. So maybe. Sure. If I choose that,
if they even speak Arabic in Qatar, because in Qatar we call them tourist lawyers in Qatar, because Qatar has such a small population. No, but we decided because they're people from Italy, from Iraq, from Australia. They come from all over the world and they stay there for 2 or 3 years and they go on. So they're not. I would guess that probably most people in Qatar don't speak Arabic. I would guess. I have no idea, but anyway. Thank you all very much. I told you I didn't want to push you all the way to the 6:30 time limit. But this was a lot of fun. This is what my life is like, watching you guys in your discussions about these. This is one of the things. All I can tell you is this is real life in our world of our international contract negotiations.
Well, Mike, thank you, because I find this table with points and items which differ according to the point of view, according to the party, an extremely valuable teaching tool. So congratulations, it's really good. I think we've benefited enormously from your guidance and this discussion, because we've actually been considering the point of view. So your idea, the message of perception and perspectives is a very good message. Thank you very much. It's been an invaluable experience. I'm most grateful on behalf of everyone. I'm sure we're going to get some, you call them kudos in America. We don't in England, on the chat. So thank you, and I hope to see you shortly on another occasion, because it's so interesting. Thank you very much.
I'm sure that we'll all meet each other somewhere in the world of international dispute, somewhere. Hopefully on my side. If you're taking this class, hopefully you'll be on my side.
Okay.
Bye-bye, everyone. Have a great weekend.
Thank you.
Bye.
Thank you. Bye.
Bye. Thank you.
Ciao a tutti, a domani.
Thank you. Bye. Tomorrow. Bye.